any memo. Please give all the memos. That will come, give it, yes.
Vacating stay.
Will you please give the memo? Give the
This
memos.
matter has to
My
be
lords, this
posted.
pertains to the order of
Give
the
all the
Kaludari
memos, sir.
that
I'm
was
not hearing
passed.
anybody. Please give the memos.
Last, this time,
Whatever it is, give the memos.
this matter has to be posted.
Give the memos. If you want to give the memos or call the cases, madam.
Last, this matter has to be posted for order submission on the office objection, my lord.
That will come on Monday, give it, sir.
Maybe, my lord.
Well, Monday baratte
No,
kodi.
in the file in the board bank, my lord, from
Monday.
last
Now stop it. I would start the proceedings. There are 300 matters.
Please.
Don't disturb.
Please.
Yes, stop it. Give all the memos.
Lordships, I'm sorry.
Give
to-
all the memos.
Lordships, I'm sorry to interfere. List number 2, I need some time, your
No
lordship.
adjournments in the morning. Mention when it is called.
There is a death
Mention
in
when
the,
it is called.
there's a death in the family for which.
All right, I will adjourn it, but mention when it is called. Or make someone mention which is the serial number. Barkondi remember. Yes, call the case now.
30.
Number 1.
Okay, for the
Ah.
petitioner, my lord. Lord,
List number 2, 13, 14.
Yes,
there
sir.
is a delay of 132 days in filing the execution petition, my lord.
Ah.
Admittedly, there is a delay of 132 days.
Ah.
The trial court, after considering my objection, has come to the conclusion that see exemption, what was granted during the pandemic by the Supreme Court, my lord, that has to be excluded. If that period is excluded, it is well within the time. My lord, the limitation expires not during that period, my lord. It is not during the exempted period, my lord. The trial court, my lord,
What is the
has
date of the
erred
decree?
in-
Date of the decree, sir?
date of the decree, my lord, is 9/7/2010, my lord.
What is the limitation, sir? 12 years from 9/7/2010?
12 years is 9/7/2022.
Yes, sir. When will it
It
expire,
is-
sir?
It expires on 21 9/7/2022. It expires.
Correct. Yes. No
It
problem.
is filed on
Anything else,
21/11/2022.
sir? Anything else, sir? The petitioner
My lord,
is before this court.
my lord,
Yes, sir.
the order is very clear, my lord.
I am also passing a clear order only, sir. The
Because
petitioner.
during pendency,
No, sir.
during the pandemic, if it is expires, my lord,
Yes, sir.
there is clearly, the Supreme Court has mentioned, my lord,
Mentioned what, sir?
90 days, the time is granted.
No,
My lord,
sir.
if today, if I am filing a petition today, my lord,
Sir, you see the order of the apex court in suo moto 3 of 2020, which says execution cases also is extended.
please, my lord,
Anything
even,
else, sir?
even if it is extended, my lord, it expires on 9/7/2022. It is filed on 21/11/2022. There is a delay of 132 days.
No problems. Anything else, sir? The petitioner is before this court. The petitioner, the judgment debtor, is before this court calling in question an order dated 30/10/2023 by which the concerned court permits initiation of execution petition, which according to the learned counsel for the petitioner is beyond the period of limitation of 12 years. Heard so and so. The petitioner is the judgment debtor in which reaches this court in RSA 1559 of 2006, having it been disposed on 9/7/2010. The execution petition is preferred on 21/11/2022. The limitation to prefer an execution petition is admittedly 12 years from the date of the decree, which would be 12 years from 9/7/2010. The learned counsel for the petitioner submits that the execution petition is preferred on 21/11/2022, which is 132 days beyond the period of limitation. The said submission would run counter to law as when the nation was engulfed with COVID-19, the apex court in suo moto 3 of 2020 had passed certain orders extending the limitation from time to time. The period of limitation that stood extended was for a period of 2 years from 15/3/2020 to 28/2/2022. If the said period is excluded, the execution petition now preferred would be well within limitation. The concerned court has, considering the order passed by the apex court, has held that the execution petition is maintainable. The order of the concerned court being tuned with law, no warrant to interfere with the said finding, petition lacking merit stands rejected. Yes,
Number
next.
2.
The petitioner is before this court calling in question an order of the concerned court rejecting an application filed under Order 6, Rule 17 of the CPC. A perusal at the application for amendment would undoubtedly would prima facie indicate that the application ought to have been allowed. In that light, there shall be an interim order of stay.
My lord, kindly give the stamp, my lord, because.
ಅಯ್ಯೋ ಅದನ್ನೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ನಾನು ಒಂದ್ ನಿಮಿಷ. Interim order of stay of further proceedings before the concerned court till the next date of hearing. List the matter 4 weeks ಬಿಟ್ಟು it.
Much.
Emergent notice to the respondent. Next.
Number 3.
No representation of the petitioner list after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks. Next.
4.
Then the petitioner,
Suit itself must be over by now. It was at the stage of arguments on 27/11/2024.
pending it is set down to 2/8. Only
Serve on the
appointment,
council then.
appointment of a commissioner.
That's all right, sir. ಅದಕ್ಕೆ ಹೇಳಿ ಸೂಟೇ ಆಗೋಗಿರುತ್ತೆ.
Suit ಇಲ್ಲ pending.
ಅದು ನೋಡುವ.
2/8 ಇದೆ.
Petitioner to serve on the council who represents the respondent in the trial proceedings, list the matter on first and preliminary hearing. Next. In the event service is not affected, the petition would not be considered for its interim order. Next.
5.
9/2/2023 compromise ಇವಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಸರ್?
ಅಲ್ಲ ಅದೇ
ಅದೇ ಏನು?
all officers and the one person has joined and the
Correct, yes. Petitioner to serve on the council who represented the respondents in the trial proceedings. Pendency of this petition will not come in the way of any further action or alter the rights accrued in terms of the compromise. Next.
6.
Release compensation, pass over ಕೊಡಿ ಇಲ್ಲಿ.
Respond number, I will take notice for respond number 1 and 2.
Wait sir, ಇವತ್ತೇ ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ ಕಾಂಪನ್ಸೇಷನ್ ಪಾಸ್ ಓವರ್ ಕೆಳಕ್ಕೆ. ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಫೈಲ್ ನ. Learned HCGP is directed to accept notice for the respondent 1 to Shumaga Urban Development Authority yaru. Council Shri A.V. Gangadharappa is directed to accept notice for the third respondent petitioner to serve set of papers upon the aforesaid council. List the matter on 28th August. Next.
7.
PDA, my lord, NOC.
I start for unanimous direction to the respondent number 203 minutes
Ah.
to consider the representation made by the petitioner.
Correct sir.
To give an
10 ವರ್ಷದಿಂದ ಕೊಟ್ಟರೆ representation denotify ಈಗಲ್ಲ ಆಗುತ್ತೆ. Anyway, Learned HCGP is directed to accept notice for the first respondent. Ajay Kumar is directed to accept notice for respondents 2 and 3 petitioner to serve set of papers upon the aforesaid council 28th.
Please.
Yes, next.
8.
Learned counsel heard the learned senior counsel R.S. Ravi appearing for the petitioner counsel T.P. Vivekanand is directed to accept notice for respondents 2, 3 and 4 HCGP 1. The counsel for the petitioner shall serve on the counsel who represented aforesaid counsel with requisite set of papers 28th. Next.
9.
For the petitioner, my lord,
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service till the next date of hearing. Warrant of any kind hanging on the head of the petitioner shall remain stayed. Next. List on other madam, list on 29th. Serve ಮಾಡಿ ಇವತ್ತೆ ಇಲ್ಲದ್ರೆ ವೆಕೆಟ್ ಮಾಡ್ತೀವಿ. Yes, next.
For petitioner, my lord.
ಹಾ.
Kindly see page 22, caveat, my lord. Caveat was
No
lodged,
problem sir. Concurrent finding ಹೇಳಿ sir.
my lord, on 9/3/22,
Hmm.
when the caveat was filed, along with the caveat, photographs of the wall, mud wall was also posted.
ಮಡ್ ವಾಲ್
Mud wall,
ಏನ್ ಮಳೆ ಬಂದು ಹೋಗ್ಬಿಟ್ಟಿದೆ ಮಡ್.
ಇಲ್ಲ,
Yes.
JCP ದಂದು demolish ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು.
Then photographs
Both the
are,
courts have not believed your version at all.
my lord, both the courts say on the western side. at
So
the-
it's a matter of evidence, correct? No question of temporary injunction.
My lord, the first appellate court has allowed one appeal, that is,
Appeal filed by the respondent
yeah, that is.
and dismissed your appeal.
Dismissed my,
Correct. Yours is concurrent finding.
my lord.
His interim injunction is granted, yours is rejected. His interim injunction is affirmed, yours is again affirmed.
My lord, MA 30 for a minute, annexure M is filed by me. And
That is rejected, sir.
yes,
Correct.
MA 31,
Filed by him, filed by the defendant is allowed.
no, my lord, it's mine, annexure N.
ಏನ್ partially allow ಮಾಡಿದಾರ ನಿಮ್ದು?
ಅಲ್ಲ,
ಮತ್ತೆ?
ಒಂದು allow ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದು allow ಮಾಡಿದಾರೆ?
MA 30, kindly see.
ಅದ್ ಯಾರು ಹಾಕಿದ್ದು?
That is mine.
So what? Then why are you here?
My page 125.
Then why are you here?
My lord, that is the order of injunction against me in the,
That's exactly I am telling.
yes,
What injunction was sought against you is granted and affirmed.
yes.
That is concurrent finding. It's a matter of evidence with regard to existence of the mud wall or not. How can you injunct anyone?
One appeal is allowed, one appeal is dismissed. Both appeals are by me.
Sir, maybe if it concerns, sir, both appeals are you.
Yes.
Why you filed appeal is one rejection of temporary injunction.
Yes.
Another grant of temporary injunction to the defendant.
Yes, my lord.
Correct.
Yes.
What is allowed is your temporary injunction.
What is
What is allowed, you know?
Against me, that is page 125.
Both are against you only, sir.
Lord, kindly see 125
Get-
for a
get the-
minute.
get the
my lord.
respondent,
Sorry,
yes.
sorry for.
No
detail.
problem.
Page-
Petitioner
page-
to serve on the counsel who represents the respondent in the trial proceedings. List the matter on next Thursday, 14th,
Please,
Wednesday, 13th. Yes,
please.
next.
11,
For petitioner, my lord. The petitioner is a tenant and is a defendant in the
The
suit.
petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 13 till such time the impugned order shall remain stayed. Next.
12,
Lapsing, my lord, 25 years delay. Respond number 1, I take notice.
Only my lord,
28-4 ಯಾವಾಗ ಆಗಿದೆ?
1999, preliminary
28-4.
preliminary notification only, no final notification.
ನೆಕ್ಕೆ 28-4 ಅಂದ್ರೆ ಏನು?
ಹೌದು.
ಫೈನಲ್ ತಾನೇ ಅದು? ಅದು ಹೇಳಿದ ಅದು ಕ್ವಶನ್
ಇಲ್ಲ,
ಬಿಟ್ರೆ ಬೇರೆ ಏನೋ ಹೇಳ್ತೀರಾ?
Sorry.
ಎಸ್.
PV Chandrasekhar, my lord,
Notice.
I have already
I will
served
take
copies.
notice.
Learned counsel PV Chandrasekhar is directed to accept notice for the respondent board. Petitioner to serve set of ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
Learned HCGP for the
Respond number.
first respondent 28th. ಈ ಪೊಸಿಷನ್ ಇದ್ದೀರಾ?
They have not taken possession.
The
All the acquisitions.
petitioners if are in possession as on today shall not be disturbed till the next date. Next.
13,
One clarification I want. Are the properties now being bought into the proceeding of partition were part of
They
the
were not.
compromise?
They were not.
They were not.
They were not. My lord, one more aspect is this, my lord. In respect of the same suit, another writ petition is also
ಕೊಡಿ,
pending.
ನಂಬರ್ ಕೊಡಿ.
And your lordships have granted stay also in that matter.
ನಂಬರ್ ಕೊಡಿ.
WP
ರಮೇಶ್ ಸರ್
19,675.
ಎರಡು ಒಟ್ಟಿಗೆ ಕೇಳೋಣ.
ಒಟ್ಟಿಗೆ ಕೇಳಿ ಸ್ಟೇ ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಕೊಡೋದು ಬೇಡ ಈಗ
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ
ಇದ್ರಲ್ಲಿ ಕೇಳ್ತಾ ಇಲ್ಲ ನಾವು.
2004 ಅಲಿನೇಷನ್
ಏನ್ ಕೇಳ್ತಾ ಇಲ್ಲ ಅವರು.
ಇನ್ನೊಂದ್ರಲ್ಲಿ stay ಇರೋವಾಗ ನಾನು ಇದ್ರಲ್ಲಿ ಯಾಕೆ ಕೇಳಿ?
ಅಲಿನೀಸ್ ಆರ್ ನಾಟ್ ಪಾರ್ಟಿ.
No problem. Heard the learned counsel Madhusudan Rao and N.K. Ramesh appearing for the petition and the respondent respectively. Tag this petition along with so and so.
19,675.
List the matter on 12th, 13th.
13. Achha.
Yes. Next.
14,
Petitioner to serve on the counsel who represents the respondent, plaintiff before the concerned court and file an acknowledgement to that effect on or before the 31st of July. List the matter on 20th July, 20th August. Till such time, the impugned order shall remain stayed. Next.
15,
ಮುನ್ಸಿಪಾಲಿಟಿ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನಿಮ್ಗೆ ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದೆ ಈಗ?
ಇಲ್ಲ ಮೇಡಮ್, this is strip of land, my lord, 9 feet into 100 feet, so only
All right.
in between the properties, my lord. It will not stretch to the other side of the property.
ಚೀಫ್ ಆಫೀಸರ್ ಪಟ್ಟಣ ಪಂಚಾಯತ್ ನೀವೇನವಲ್ಲ? Petitioner to emergent notice to the respondent returnable by the 20th of August. The till such time status quo where the property be maintained by the parties. Next.
16,
Alternate site. BDA.
16, we are not 16.
Learned
I am for
count.
the petitioner.
Correct, sir. Alternate site.
2006 the alert aside.
Correct, sir. Notice ಕೊಡೋದ್ ಬೇಡವಾ?
ಕೊಡ್ಬೇಕು.
ಮತ್ತೆ?
2007 ನಲ್ಲಿ I have paid entire amount.
Correct, sir. 20 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ನಾನು I have been continuing following up.
we'll-
They
we'll
say
see.
that it is
Learned
pursuant to
one minute.
redo order.
Learned counsel Vasant is directed to accept notice for the respondent BDA. Petitioner to serve set of papers upon the aforesaid counsel. List the matter on
Blood, I have
19th
sought
August.
for an interim direction.
No, sir.
Blood.
Sir,
Redo
2007 ಇಂದ ಸುಮ್ನೆ ಕೂತ್ಕೊಂಡು ಈಗ ಬಂದು interim direction not to allot. No,
Your
sir.
Honor, may kindly peruse
List the
annexure
matter,
E,
list
my
the
lord.
matter on 19th, instructions be sought by then.
Annexure E may kindly
Next,
be.
next.
17,
Yes. Compromise scheme,
Yes.
we'll see.
Annexure A
Learned
represent.
counsel, what's
ಶರಣ್ ಸಬ್ರದ್
Sharon Sabrad accepts notice for the respondent board. First respondent, HCGP 2, 3, Nandi Infrastructure, nice yaru.
Nitin Prasad.
Nitin Prasad accepts notice for the third respondent petitioner to serve set of papers upon the aforesaid counsel, if not already served.
In this state, they have not made state as a party.
Second respondent status.
No, state is.
I'll represent on this.
Ravinder Reddy for second respondent, HCGPL. Yes, petitioner to serve set of papers upon all the aforesaid counsel. What's the problem now?
There's nothing.
Is it interim order in but yes.
Not to disperse some third arrow.
We'll say list the matter
Trial
on
claimants.
19th. Atra ಏನಿದ್ರೆ move ಮಾಡಿ.
18,
Petitioner, my lord, is,
39,
Joint
1 and
family
2, we will direct consideration in 4 weeks.
yes, please.
The petitioner is before this court seeking the following prayer. The petitioner, plaintiffs 1 and 2, institute a suit in OS 514 of 2025 before the concerned court. The suit is for partition and separate possession. An application is filed along with the suit under Order 39 Rule 1 and 2 seeking the respondents seeking a direction to the defendants not to dispossess or not to alienate the property. The said application does not merit consideration, but the application is still pending before the concerned court. Therefore, the present prayer is, aforequoted prayer is sought by the petitioner. In the light of the prayer being innocuous, I deem it appropriate to direct the concerned court to dispose the application and order.
In other interim applications also there, not to.
Dispose the applications that are pending before it as on today with an outer limit of 4 weeks in accordance with law. Ordered accordingly. Next.
19,
Lord, in this case, I've already issued a NOC.
19 ನೀವೇನಾ?
For petitioner, I filed.
ಇಲ್ಲಿ ಇದಾರಲ್ಲ already. Yes. Registry to delete the name of Suresh K and
Vijay
print the
Kumar.
name of
K. Vijay Kumar.
K. Vijay Kumar. Yes, so and so.
Blood, the acquisition proceeding 2006 is preliminary notification. 2008 is the final notification.
In our
2020, 22 is the award.
So
Milord, after lapse of
ಆಯ್ತು.
1.5 decade, Milord.
we'll see. You are in possession still?
Yes, Milord. That's why not to.
One
this
minute.
any-
The learned counsel Sharan Shabrad is directed to accept notice for the board. Learned counsel Ravindra Reddy is directed to accept notice for respondent 1. State board ge Nitin Prasad for 4 and 5. 4, 5 and 6. ಅದು ಯಾವತ್ತು ಹಾಕ್ತೆ madam? Previous. List the matter on 19th. The petitioner, if in possession as on today, shall not be disturbed till the next date of hearing. Yes. Great. Next.
20,
What happened to the miscellaneous petition?
Miscellaneous petition is still pending for consideration, my lord.
We'll direct the court to
Notice is
consider
issued,
it.
my lord. Notice has been issued, my lord. in-
ಆಯ್ತು ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ ಈಗ ಮಧ್ಯದಲ್ಲಿ ಇದು ಇಲ್ಲೇ ಇಲ್ಲ ಅಲ್ಲೊಂದು ಇಲ್ಲೊಂದೇನು
My lord, in fact, what they are doing is specifically against the defendant number 6, who is the present petitioner, my lord.
Hmm.
They have initiated criminal proceedings as well, my lord. But
How-
whereas I.
how is that the subject matter of this, sir?
But.
I will direct the first appellate court to dispose it off within a time frame.
But your lordship may kindly peruse the judgment for a moment, my lord. In the entire judgment passed by the trial court, there is no iota of pleadings regarding the item number 1 of the scheduled property, my lord. Even not only in the entire judgment, even in the entire pleading submitted by the respondent number 1 as well, my lord.
But since
And
it is
completely
it's
beyond
an
jurisdiction,
ex
they are
parte
passing
judgment, I know.
Please, my lord.
But
please.
miscellaneous appeal is still pending. The petitioner is before this court calling in question a judgment rendered by the trial court in OS 26034 of 2020, which is an ex parte judgment. On the ex parte judgment, the petitioner files an application in MA
Please, my lord, 25034.
25034 of 2020.
Please, 2024. my lord.
2024. They said miscellaneous application is still pending seeking recall of the ex parte judgment. In the interregnum, contempt proceedings are initiated by the defendant which has driven the petitioner to this court in the subject petition. Therefore, there shall be an interim order of stay as prayed for petitioner to serve on the counsel representing the plaintiff before the concerned court and file an acknowledgement by the 31st. List the matter on 20th August.
Grateful, much
Yes.
obliged.
ನೀವು ಸರ್ವ್ ಮಾಡಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮತ್ತೆ ಸರ್ವಿಸಿಗೆ ಬಂದ್ರೆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ವೇಕೇಟೆಡ್.
Definitely, sir. my lord.
Yes.
Please. obliged.
21,
Who are you, sir?
Because I have purchased the land,
Not to disperse compensation ಅನ್ನಕ್ಕೆ ಯಾರು ಸರ್ ನೀವು?
well, I have purchased the land under the registered sale deed
When, sir?
in the year 2006. Prior to that,
Prior to the preliminary notification, after the preliminary notification?
no, prior to the final notification.
Final
Notification is issued only in the year 2018.
ಹಾ.
That's prior to that, 23rd April.
ಇದ್ಯಾವ ಶಿವರಾಮ್ ಕಾರ್ ಅಂತ?
ಹೌದು, ಹೌದು.
ಹಾ, ಮತ್ತೆ
23rd April 1999 is the first sale deed.
in your favor?
No, in favor of my vendor.
Hmm.
Thereafter,
You purchased it when, sir?
I purchased it on 27th October 2006.
2008
Thereafter-
is the preliminary notification.
That's right.
18 is the final notification.
Yes, ma'am. Thereafter, a
You have-
collusive decrees,
Agreement or sale deed?
sale deed, registered sale deed.
Yes. Learned HCGP is direct to accept notice for ಒಂದೇ ನಿಮಿಷ madam. The first respondent, 1, 2, 3, 4. Counsel Ajay Kumar is directed to accept notice. 5 emergent notice returnable by the 28th August. The learned counsel for the petitioner submits that he has purchased the subject property in the year 2006 for his, from the hands of his vendor who had purchased it in the year 1999. The preliminary notification is issued in the year 2008 for formation, for acquisition of lands for the formation of Dr. Shivram Karant layout. The final notification comes about in the year 2018. The landowners have now projected that they are the owners and are entitled to receive compensation. In that light, there shall be an interim order of stay of interim order of restraint on respondent BDA not to disperse compensation without the leave of the court to any person. Please list the matter on 28th ಹೇಳಿದೆನಲ್ಲ? 28th ಹೇಳಿದ್ನ? 28, yes. Next.
22.
Similar matter.
Same order.
Great.
For the petitioner in this case, your lordship, here the respondent number 1 had filed a commercial OS, in commercial OS number 415.
Miscellaneous application is still pending.
Yes, your lordship.
The petitioner is before this court calling in question the process of execution and other orders passed thereon in the teeth of the pendency of the miscellaneous appeal owing to the fact that it was an ex parte decree. Therefore, there shall be an interim order of further proceedings in commercial execution 518 of 2024 till the next date of hearing. Petitioner to serve on the counsel who represented the respondent in the trial in the before the concerned court and file an acknowledgement by the 31st. List the matter on 28th. 27th. 27th Rajana. List the matter. Ready there? List the matter on 20th. If you don't serve, interim order gets vacated.
Thoroughly serve, your
Yes.
lordship. Great.
Right away.
24.
20?
24. 20.
Withdrawal of suit, partition suit.
Declaration and permanent injunction.
Declaration ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
No, actually, there
No
was certain-
permission granted to withdraw the suit.
No permission was granted, my lords, to withdraw the suit, and it's out for liberty also, my lords.
We'll see. Who is the contesting defendant?
All defendants are contesting.
15 ಜನ ಡಿಕ್ಲರೇಷನ್ ಹಾಕಿದ್ದೀರಾ?
ಆಗಿದ್ದಾರೆ.
Who is the contesting defendant?
All defendants are contesting.
All defendants. Serve on all defendants. The petitioner to serve on the counsel representing the defendants before the concerned court. List on 20th.
25.
28A.
Petitioner in this, my lordship.
Yes,
My lordship, my land has been acquired for.
correct,
farmers.
madam. 28A is not done. Yes. The petition counsel for the ಯಾರ್ ನೀವಾ? ಯಾರಿಗ?
R1, government.
ಸ್ಟೇಟ್ಗ? Learned AG ಏನಾ? Learned AG is directed to accept notice for the first respondent TP Vivekanand to the second respondent petitioner to serve set of papers upon counsel to TP Vivekanand 20th.
26.
Appearing for petitioner here.
ಆಮೇಲೆ
My lord, I sought an amendment, my lord, in this case.
ಆಮೇಲೆ
The amendment is, my lord, the
the
property.
petitioner to serve on the counsel representing the respondent before the appellate court. The petition is preferred against dismissal of an application filed under Order 6 Rule 17 seeking amendment. The perusal at the amendment would prima facie indicate that the same ought to have been allowed. In that light, further proceedings shall remain stayed. Serve list on 26th, 25th. Serve ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಬೇಕಾಗುತ್ತೆ. ಕೊಟ್ಟನ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೇನೆ.
Please, yes.
20? ಆಯ್ತು, list on 20th. Next.
27.
Nothing, sir. Partition suit, 39, 1 and 2 concurrent.
My lords, basically they suppressed the material facts, my lords. Similar suit was filed by children of respondent number 1. They were not-
Partition suit ಅಲ್ಲವೆಲ್ಲ ಏನ್ ಬರಲ್ಲ.
Like same reliefs are sought, my
ಪರವಾಗಿಲ್ಲ.
lords. Partition and even
ಅದು ಎಷ್ಟು ಬೇಕಾದ್ರೆ ಆಗ್ಬೋದು ಸರ್. Any number of PDs and FDs.
they were not successful in getting interim order and subsequently they
You are
withdraw
also
one more
not
suit.
successful in getting interim orders.
So there was material suppression, my lords. In the subsequent suit, they have suppressed the fact of filing the.
Both the courts have not accepted your submission. ಕೊಡಂಗಿದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ. What you will do? Withdraw the petition. Learned counsel for the petitioner arguing the matter at length would seek leave of this court to withdraw the petition and urge all these contentions before the concerned court at the relevant point in time. Reserving such liberty, petition stands disposed.
For the cavator respondent, kindly my lord look at my lord the prayer.
ಏನು?
ಅಲ್ಲ, I-
ನಿಮ್
my lord,
prayer
say- say-
ನಿಮ್ prayer
ನನ್ನ prayer
ನಿಮ್
ಅಲ್ಲ.
prayer ನೋಡೇ ನೋಡ್ತೀನಿ. ಅದು I am most untenable.
Kindly my lord look at the blind prayer, my lord.
You
I-
said look at the
I
prayer.
have- I
If
have,
the
my lord-
petitioner is saying look at the prayer, I'll have to look at the prayer of the petitioner.
ಅಲ್ಲ, I
You
have,
should
my
have,
lord,
you
tolerance
should have said relief before the
I understand.
concerned
But
court.
my lord, I have tolerance to take this humor. Your lordship sees my lord page number 44.
I don't know, when you become intolerant, what will be.
I'll convince your lordship, my lord. My lordship also will not be able to contain, my lord. This is the prayer. And my lord, the learned judge. my
Yeah,
lord, the first
who is
court-
seeking quarrying to be stopped?
My lord, it is a quarrying leases are granted by a sangha called, my lord, Madhakanalli Kallu Kuttigara Sangha. My lord, it grants leases to individuals. I am the applicant. I have been doing it. My sister.
That Sangha is granting leases under what provision of law?
My lord,
What authority of law?
my lord, it is, there are certain government senates, my lord, in some, my lord,
No,
villages.
no, our personal property, yeah?
Alla. The common areas, my lord, which belongs to the
No,
government.
who has given them that power to grant license or grant?
But there have been detailed, my lord, agreements between the government, the RTCs. RTCs, my lord, stands in the name of, my lord, the Sangha. Now, my lord, what the Sangha does, Sangha identifies, my lord, individuals and grants lease, my lord, then thereafter, my lord, all following, my lord, the government rules and regulations. My sisters would come and file a case against me, saying that my brother has got a lease and we also need, my lord, if that was the prayer, at least, my lord, I could have tolerated. Your lordship sees the prayer.
So why are you become so intolerant?
ಈ ತರದ ಕೇಸ್ ನಲ್ಲಿ the learned judge rightly rejects the interim prayer, my lord, the RA judge.
Yes, sir.
Lordship may kindly see page 21.
Ah.
This is an ancestral property. Lease rights are ancestral property. Page 21.
Lease
In
rights
their-
ancestral.
No. Since your lordship may kindly see. ಎರಡನೇ ಪಾರ್ಟಿಯಾದ ನಾನು, that is the petitioner. ಸಂಘದ ಗಣಿಯಲ್ಲಿ ನಮ್ಮ ತಾತ ತಂದೆಯವರ ಅನುಭವದಿಂದಲೂ ಇಲ್ಲಿಯವರೆಗೆ ಕಟ್ಟಡ ಕಲ್ಲುಗಳನ್ನು ಅನುಭವಿಸಿಕೊಂಡು.
ಆಯ್ತು, will direct status quo to be maintained ಬಿಡಿ.
Yes, please, my lord. To preserve the thing pending partition suit.
ಅವರು quarrying ಮಾಡ್ತಾ ಇದ್ರೆ ಮಾಡ್ತಾರೆ.
No. Trial court has dismissed my application, praying that to stop him from quarrying, temporary injunction. Against that application, I am in MA. MA has been allowed, holding that not only this petitioner, it is for the entire family. The lease is granted. He can't have exclusive right over the property. To preserve that pending disposal of the partition.
Family lease ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
ಅಲ್ಲಿ ಎಲ್ಲರಿಗೂ
ಹೆಂಗ್ ಬರುತ್ತೆ?
Lordship may kindly see in its own.
So where is the concept of family lease?
Lordship may kindly
Lease is given to families also, and government.
Phase D.
No way, my lord.
No.
It's never.
Phase
Quarrying lease ಫ್ಯಾಮಿಲಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Lordship may- it is in
ನಾಳೆ
its own-
ಇನ್ಹೆರಿಟೆನ್ಸ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ ಅದ್ರ ಮೇಲೆ.
Lordship may
That's
kindly
what,
see.
my lord, is this suit.
In annexure D.
Precisely the suit is that.
Its own agreement, it says. ನಮ್ಮ
Agreement of
ತಂದೆ
what?
ತಾತ-
Now, who has been given the quarrying license?
Society, please, my lord.
Society.
ಕಲ್ಲುಕುಟಿಗರ ಸಂಘ
By
ಅಂತ
the
ಒಂದು
government.
society.
By
Yes.
the government.
Society.
All right. Government grants it to whom?
Initially,
Grants
it
it
was-
initially ಬೇಡ sir. Grants it to whom ಅಷ್ಟೇ.
now he has entered into an agreement.
Sir, grants it to whom? Straight question. Don't beg the question.
My lords, initially there was no lease agreement. People were doing, the villagers are doing, a group of villagers, particular community. Now, what they say in their own agreement, it says, ನಮ್ಮ ತಂದೆ ತಾತ ಕಾಲದಿಂದಲೂ ಕಲ್ಲುಗಳನ್ನು ಅನುಭವಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಈ ಪ್ರದೇಶದಲ್ಲಿ ಈ ಕಲ್ಲು ದಿಮ್ಮಿಗಳು
Government, how are you
ಬಂದಿರುತ್ತದೆ.
granting all this?
Lordship,
Government property like this?
I will get it.
ಯಾವ ಸಂಘ ಕೊಟ್ಟಿದ್ದೀರಾ ಇದನ್ನ?
There, my lord, that is, my lord, there is a scheme. my lord.
We'll get into the root of the matter. sir. Yes.
It's fine, my lord. I'm good with it. I'm good with
ಹಂಗಂದ
it.
ತಕ್ಷಣ ಯಾಕೆ ವಾಯ್ಸ್
ಇಲ್ಲ ಇಲ್ಲ ನಂದೇನಿಲ್ಲ. I am good with it, my lord.
yes.
Sometimes, my lord, I have to be very careful, my lord, in my verbatim before your lordship. I am good with it. Now, what would happen is, your lordship sees, my lord, this open the patra, which is on page number 27. My lord, this Sangha, who is authorized to lease it out for the purpose of sale of, my lord, quarried material, gives it to me. My sisters would go and say, my lord, if a partition at least is a prayer, my lord, I can, my lord, understand. That is not even the prayer. Kindly, my lord, look at the plain prayer.
We'll hear it, sir.
My lord,
List the matter on 25th August. Adu Rajala, sir. 29th August. Status quo, where the property be maintained till the next date of hearing.
greatly obliged.
29.
Package compensation.
Status quo, my lord, ante. Otherwise, my lord, what would happen is, my lord, status quo post, my lord, the MA order, my lord, which is.
You went away silent.
I'm sorry, my lord, I'm sorry, my lord. My lord, the order under challenge, my lord, is, I'm sorry to say this, my lord, it's a disastrous order, my lord, that cannot be, my lord, let to continue. My lord, that is, my lord, it's absolutely disastrous.
My lords, he will continue querying. That is the reason I am, let the property be.
They're not losing anything at the end of the
We'll
day.
see. The lot of queries in this. We'll see.
I understand that, my lord. But, my lord, this order, my lord, in the MA, my lord, that can't stay, my lord. The status quo, my lord.
Let him
We
not
take
querying.
advantage.
Status quo, my lord, ante. My lords may kindly say.
Status quo. You take advantage.
My lord, if my lord today, my lord, rightly or wrongly, my lord, the MA order is there. MA order, my lord, literally the learned, my lord, the appeal judge decides, my lord, a partition claim where there is not even a prayer. My lord, that's the finding. No, it
Yes,
belongs
we'll
to the
see. We'll
family.
hear it. Yes, sir.
This is the.
My lords may
property
kindly
is
say, my lord, status quo
Test the
ante.
matter on 28th. Till such time, the order of the first appellate court shall remain stayed.
Greatly obliged.
He will continue querying.
Let him continue. ನಿಮ್ಗೆ ಆಮೇಲೆ ಶೇರ್ ಕೊಡೋಣ ಬಿಡಿ. Succeed
How
ಆದ್ರೆ.
to assess the share and all.
That
How
we'll
to
see.
assess
We'll
it
appoint
in
a court
party-
commissioner to assess what is the income.
Status quo would have been justified and.
What do you do, sir? ಅವರು ಇಲ್ಲ ನೀವು ಇಲ್ಲ. ಸುಮ್ಮನೆ ಇಬ್ರು ಮನೇಲಿ
Let the
ಕೂತ್ಕೊಂತೀರಾ.
property be preserved, please, my lords. Let him
Property
not-
will be preserved,
There are
sir.
7 members in the
Property is
family.
not yours, sir.
I'll keep accounts, my lord.
Lord,
I'll
it's
keep
the right.
accounts.
ಬೇಡ ಅವೆಲ್ಲ ಬರೆದ್ರೆ ಆಮೇಲೆ
ಹೌದು.
ಬ್ಲಾಂಕೆಟ್ ಪರ್ಮಿಷನ್ ಟು ಕ್ವಾರಿಂಗ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಹೌದು.
Yes.
Let there be stay.
Till the next date of hearing.
Greatly
What
obliged.
quarrying is this?
It's a building stone, my lord.
Stone,
It's
building
not, my
stones.
lord, any, my
Size
lord,
stones.
ornamental stone alla. Granite to ornamental stone.
What is ornamental stone?
ಅದೇ ಈ ಗ್ರಾನೈಟ್ ಅವೆಲ್ಲ ಆರ್ನಮೆಂಟಲ್ ಸ್ಟೋನ್ಸ್.
Oh.
Size stones, building size stones.
ಸರಿ.
ಅಲ್ಲ.
ನಿಮ್ ಮನೆ ಕಟ್ತಾ ಇದ್ರೆ ಅದಕ್ಕೂ ಕೊಡ್ತಾರೆ.
Querying ಅವ್ರಿಗೆ ಬಿಟ್ರೆ.
ನಾನೇನ್ ಬಿಟ್ಟಿಲ್ಲ. I have stayed the first appellate court's order.
Greatly obliged.
It is being enjoyed.
Sir, first appellate court is deciding a partition suit here.
Well, so far as this right is concerned.
On the face of it, it's an illegal order. If you want me to say everything and state, I will state. I have just kept it for hearing on 20th. Partition suit ತೀರ್ಮಾನ ಮಾಡ್ತಿದ್ದಾರೆ ಅವರು.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಲೀಸ್ ಆಗಿದೆ, ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಬರಬೇಕು, ಅದಕ್ಕೆ ಕ್ವಾರಿಂಗ್ ಸ್ಟಾಪ್ ಮಾಡಬೇಕು. ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್?
ಕ್ವಾರಿಂಗ್ ಮಾಡಬಾರದು. ಪೆಟಿಷನರ್ ಒಬ್ಬರೇ.
ಆಯ್ತು, ಈಗ ಟರ್ನ್ ಬೈ ಟರ್ನ್ ಕೊಡೋಣ ಬಿಡಿ. ರೊಟೇಷನ್ ಬೇಸಿಸ್ ಮೇಲೆ ಎಲ್ಲ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ಗೂ ಕೊಡೋಣ. ಓಲ್ಡೆಸ್ಟ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ ಯಾರು?
I am the surviving, my lord, oldest.
ಎಷ್ಟು ವರ್ಷ?
Petitioner's mother.
ಎಷ್ಟು ವರ್ಷ?
ಲಲಿತಮ್ಮ 68 years.
ಅಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. ನೆಕ್ಸ್ಟ್ 20th. Yes.
Greatly obliged.
The petitioner, my lord.
Package compensation. Learned AGA is directed to accept notice for the. ಎಲ್ಲಿದೆ? ಬೋರ್ಡೇ ಇಲ್ಲ, ಇದು ಸ್ಟೇಟೇ ಇಲ್ಲ.
State illa. KDB and BMRCL, my lords.
BMRCL ಯಾರು?
Pradeep.
ಹರೀಶ್ ನರಸಿಂಹಮೂರ್ತಿ ಅಲ್ಲ ಮೇಡಮ್? BMRCL. Pradeep Odair. Council Pradeep Odair is directed to accept notice for 2-1 SLAO board. ನಿಮ್ಮ ಹೆಸರೇನು?
Gopal.
So and so accepts notice for the first respondent. The third respondent, income tax.
That is, we have made them as a party, my lords.
Why
because
income
TDS
tax?
Because the TDS ಇರೋದ್ರಿಂದ.
Learned Council DS Jay Shanti Bhushan is directed to accept notice for the third respondent. 4-5 emergent notice returnable by 28th. List the matter on 20. ಗೊತ್ತಿಲ್ಲ ಯಾವತ್ತು ಅಂತ ಇದು. ಎಲ್ಲೇನ ಇದು?
ಹೌದು.
List the matter on Tuesday ತಗೊಂಡು. List the matter on 19th. Yes, petitioner to serve set of papers upon the aforesaid council.
Proceedings before the trial court is on 19th itself.
No
my lord.
problem.
Until then, my lord,
Yenagala. Yes, next.
my lord, the reason why I am seeking for a stay, my lord, is that.
List the matter on 18th. Yes.
Grateful.
It stay ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಏನು ಆಗೋದೇ ಇಲ್ಲ ಆಮೇಲೆ.
Mandamus prayer, my lord, to consider the application
sir.
under section 28A.
The petition.
Moda, my lord. Respond number 1 is Moda. Government is.
Mysore Urban
Mice ಗೊತ್ತಾಯ್ತು. Serve on TP Vivekanand next week will dispose it. Heard the learned counsel Balakrishna Shastri appearing for the petitioner. Petitioner to serve set of papers upon TP Vivekanand representing the respondents. List the matter next Tuesday, Hakim madam. We'll close it. Please. Yes. Next.
31.
This is good for partition.
Correct, sir. Gift you have challenged is null and void.
Please.
ಅದು ಡೆಪಾಸಿಟ್ ಮಾಡೋ ರೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ, ಅದು ತೀರ್ಮಾನ ಆದ್ಮೇಲೆ ಅಲ್ಲ. Nothing. Yes. Petitioner to serve on the counsel who represents the defendants before the concerned court and file an acknowledgement of such service. List the matter on 2nd September.
Please.
Yes, next.
32.
Lord, the respondent number 10 having already taken his share, my lord, sought to get impleaded in
So
this.
what?
Lord, he belongs to a totally different
Yeah,
branch.
ಇಂಪ್ಲೀಡ್ ಆಗ್ಬಿಟ್ರೆ ಏನು ಶೇರ್ ಕೊಟ್ಬಿಡ್ಬೇಕಾಗುತ್ತೆ.
ಇಲ್ಲ, but,
Court will determine.
they are only delaying the proceedings by in collusion with the plaintiff. I've already.
I will direct the concerned court to dispose the petition in time frame.
Yes, please.
Yes. The petitioner is before this court seeking the following prayer. After arguing the matter at length, the learned counsel for the petitioner would seek leave of this court, would restrict his prayer to a direction to the concerned court to conclude the proceedings within a time frame. The learned counsel for the petitioner would further contend that the present suit for partition is an offshoot of the earlier suit for partition. In that light, the concerned court shall endeavor to conclude these proceedings within 9 months from the date of receipt of the copy of the order, if not earlier. Ordered accordingly. Yes. Next.
33.
Okay, for the petitioner in this case, my lord, petitioner in his
Ella
challenge.
33, 34,
Yes.
36, 37, 39. 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದೆ.
12, 13
ಅದಕ್ಕೆ ಏನಿಲ್ಲ, ಅದಕ್ಕೆ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರೆ ಇಂಟ್ರೆಸ್ಟ್ ಹೋಗುತ್ತೆ.
No, my lord.
ಅಷ್ಟೇ.
Honorable court, your lords may kindly.
We'll see you serve on the claimants.
Very latest judge.
Serve on the claimants. ಎಲ್ಲ 4,336 delay ಕೊಡಿ.
Which has passed the order, by state the order passed by the.
The petitioner Kaveri Niravari Nigam is before this court. ಇಲ್ಲಿಗೆ ಬರುತ್ತಾ ಇದು? ಏಳು 39 ಇನ್ನೊಂದು ಯಾವ್ದು ಭೀಮನವ್ರೆ? 39 ಆಮೇಲೆ
Batch matrix.
Along with this matter.
ಅದೆಲ್ಲ ಕೊಡಿ.
10 more matters, sir.
ಕೊಡಿ, ಎಲ್ಲ ಕೊಡಿ, ನಂಬರ್ ಕೊಡಿ. The emergent notice to the respondent. One SLAO ಯಾರು? Learned AGA for respondents 2 and 3. The petitioner is before this court on an order. Who is that? On an order allowing the application seeking condonation of delay of 4,336 days by the claimants seeking enhancement of compensation for acquisition of their lands. The learned counsel submits that identical matters are pending and interim orders are operating. Tag this petition, these petitions along with so and so. There shall be an interim order as prayed for till the next date of hearing.
Much.
Next.
45.
The petitioner is before this court. ಇದು ಕೊಡಿ ನಿಮಿಷ. ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು ಹೇಳಿ?
BDA.
Fast, fast, move.
Second respondent is BDA.
ಆಮೇಲೆ
Third
first
respondent is SLAO.
First ಯಾರು?
Government of Karnataka.
Learned HCGP is directed to accept notice for the first respondent 2 and 3. BDA na? Counsel.
Who is BDA, my lord?
BS Sachin is directed to accept notice for the second respondent. 3 ಯಾರು?
SLAO, my lord.
Of what?
Of Bangalore North, my lord.
BDA ತಾನೆ?
BDA, my lord.
2 and 3, VS Sachin.
My lord,
The
interim order
petitioner,
will be.
1 minute. The petitioner, if in possession today, shall not be dispossessed till the next date of hearing.
Grateful.
List the matter on 1st September.
Grateful.
Next.
6, 37, and 38.
Appearing for the petition.
Petitioner to serve on the council, 38 Niva.
38 I am appearing.
Siddhappa Niva.
I am appearing.
The petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service by the 31st of July. In the event the acknowledgement is not filed, the interim order that is now granted shall stand vacated. Subject to the aforesaid condition, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. List the matter on 28th.
Please.
Next.
And adjourn 40.
Documents denied. What documents you wanted, sir?
There is a declaration suit between the respondents.
ಯಾವ
and-
document ಬೇಕಾಗಿತ್ತು?
All-
Order 18 rule 17
Please, 14 rule 17.
1417 sorry.
Please,
Yes.
production of documents was rejected, please.
The petitioner contesting ಯಾರು ಇಷ್ಟೊಂದು ಜನ ಇದ್ದಾರೆ
All the respondents, please.
ಸಿಂಗಲ್ ಒಬ್ಬರೇ ಕೌನ್ಸಿಲ್ ಇದ್ದಾರೆ ಯಾರಿದ್ದಾರೆ
22 is the BDA, I will serve it.
ಬಿಡಿಎಗ
Please.
ಹೂ ಅಬ್ಜೆಕ್ಟೆಡ್ ಟು ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್
1 to 22.
ಎಲ್ಲರೂ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರು
ಹೌದು, please.
ಮತ್ತೆ ಎಲ್ರಿಗೂ ಒಂದೇ ಕೌನ್ಸಿಲ್ ಇದ್ದಾರಾ
ಇಬ್ರು ಇದ್ದಾರೆ ಸರ್.
ಇಬ್ರಿಗೂ ಸರ್ವ್ ಮಾಡ್ಬಿಡ್ತೀವಿ
Please, ಮಾಡ್ತೀವಿ.
petitioner to serve on the counsels who represents the respondents before the concerned court and file an acknowledgement of such service by the 31st. 20th, list on 20th, till such time further proceedings before the concerned court shall remain stayed. ಅದರಲ್ಲಿ R22 ಗೆ counsel Ajay Kumar is directed to accept notice ಅಂತ ಮಾಡಿ. List the matter on 28th.
41.
ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ನಾ further proceedings stay ಮಾಡಿದ್ನಲ್ಲ 40.
41.
I will take notice for respondent 2 and 5, my lord.
Consider representative learned HCGP is directed to accept notice for respondents.
2 and 5, my lord.
Respondents 2 and 5. Case counsel Shri K.S. Bhimaya is directed to accept notice for respondent 1 and 3. 1, 3, HCGP 2, 4 and 5. 1 and 3, K.S. Bhimaya, petitioner to serve set of papers upon the aforesaid counsel if not already served, 1st September. Next.
42.
Again for the petitioner, my lord. For Metagalli Levitt.
Huh?
My land is been acquired for the formation of.
Correct,
Metagalli-
40 ವರ್ಷ.
Yes, my lord.
ಒಂದು ನಿಮಿಷ ತಾಳಿ. Learned AGA is directed to accept notice for respondent 1. Learned counsel TP Vivekanand is directed to accept notice for respondent number 2 and 4. 2 and 3, sorry. 2 and 3. Petitioner to serve set of papers upon counsel Shri TP Vivekanand forthwith. List on 18th.
43.
My pleading application.
Who are you?
I am son of one of the co-sharers.
Why were you not made party?
I get a
Preliminary decree party idra.
Illa. It
Why?
is not necessary. It is not necessary.
Why not necessary?
Preliminary decree, it decides who are the,
Correct.
how the shares have to be decided.
How did you emerge in the final decree proceedings?
That is where final, the role of.
Why you did not enter into the preliminary decree proceedings?
I was not aware.
Why? You are not aware?
I was not aware.
Then you are not a member of the family.
I am a member of.
Then
the
how
family, but I
how
was
are you not aware?
I was not aware. But in any case, Yogendra versus Leelavati of the Supreme Court, it says, I am entitled to a share. Now, please see the order passed by the learned judge. He has confused joint family status with ancestral property. Please
That's
see,
all right. I wanted to know who you are.
I am son of first respondent. I want to claim a share in her property.
What happened to the second respondent?
Suit was decreed in her favor.
What is the relation between you and second respondent?
She is my mother.
Mother. The learned counsel for the petitioner to serve on the counsel who represents the respondent. Yaru contesting yaru? Plaintiff.
Respondent number 1 only.
Plaintiff first respondent before the concerned court and file an acknowledgement. List the matter on first till such time further proceeding shall remain stayed.
Very good.
Next.
44.
My lords, I appear for the first respondent in this matter, my lords.
3 guntas of land compensation, sir. Yes.
I am the petitioner.
But we'll hear. Yes. The petitioner, the learned copy ಕೊಟ್ಟಿದ್ದಾರಾ madam?
ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, for one only.
NHAI, yeah?
NHI.
Shobhit Shetty is directed to accept notice for respondent 3 and 4. 3, 4 and 5, 3 and 4. 2 and 5. HCGP, uh, one is already represented. So it's list on 20th.
45.
Next. Modified equal share.
I appeal for respondent.
So what is?
After 2020 judgment, it has been modified.
Not provided any opportunity.
Not a opportunity ಕೊಟ್ಟಿಲ್ವಾ?
Objection
ಏನು opportunity?
In
terms of Supreme Court.
schedule number item number 2, that is action ಆಗಿದೆ ಸರ್ 9 acre.
ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. ಇಲ್ಲೇ ಸುಮ್ಮನೆ ಇರ್ತಾ ಇದ್ರಿ ನೀವು. ಶೇರ್ ಕೊಡ್ಬೇಕಲ್ಲ ಅಕ್ವಿಸಿಷನ್ ಅಲ್ಲಿ ಅದಕ್ಕೆ.
ಕೆರೆ ಒತ್ತುವರಿ
ಕಾಂಪನ್ಸೇಷನ್ ಅಲ್ಲಿ.
ಇಲ್ಲ ಕಾಂಪನ್ಸೇಷನ್ ಏನು ಅವಾರ್ಡ್ ಆಗಿಲ್ಲ ಸರ್ ಅದಕ್ಕೆ ಒತ್ತುವರಿ.
Yes, file your objections. Counsel for the respondent seeks time, 2 weeks time to file statement of objections. Objections, if any, by the 3rd of September, list on 3rd of September. ಒಕ್ಕಲತ್ ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ? Registry to print the name of
ವಿವೇಕಾನಂದ.
so and so. ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ, ಹೇಳ್ಬೇಕು ತಾನೆ. Registry to print the name of so and so is appearing for the respondent. Next.
46.
7 Rule 10 application.
Is allowed.
Is not allowed, my lords. I am
This
for the defendants.
commercial OS.
Regular OS.
Regular
Defamation, suit for defamation. Paragraph 18, page 190.
Why, to which court it had to be transferred?
Ramnagar, because I had sent that email during
Ramnagar?
business.
Now Greater Bangalore. ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
But court jurisdiction still Ramnagar.
The
Now, my
light-
lords, the alleged email, defamatory email was sent during business hours. And the cause title also shows, my lords, the defendant's address to be in Ramnagar itself. Therefore, my lords, in terms of section 19, cause of action or where they carry on business. Therefore, it should have been Ramnagar, my lords. That is the.
What's defamatory here?
In fact, there is nothing defamatory. He has just listed out the duties of a director that non-compete ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಷ್ಟೇ. They call that defamatory, in fact.
I serve on the respondent. The petitioner, what's the next date?
6/8, my lords.
Petitioner to serve on the counsel representing the respondent before the concerned court and file an acknowledgement of such service by the 31st. List the matter on Monday, 4th August.
Please. 4th August. My lords, 4th, I have some difficulty. May I request for 5th, my lords?
5th.
5th.
Yes.
47.
Learned AGA 1, 2 and 3 railways, Southwestern Railway. ಯಾರೋ appear ಆಗ್ತಾರೆ.
ಸೆಂಟ್ರಲ್ ಗವರ್ನಮೆಂಟ್ ಅಲ್ಲ.
Central DSGI Shanti Bhushan is directed to accept notice for respondents 2 and 3. Petitioner to serve set of papers upon the aforesaid counsel. BWSS be covered,
My lords, ಇಲ್ಲ ಇದರಲ್ಲಿ
ಮತ್ತೆ?
insofar as water connection is concerned, writ appeal ಅಲ್ಲಿ there is an order for 50% of pro rata, my lords.
Same order, whatever is there. We'll dispose it on the same terms. Subject to the outcome. ಇದು writ appeal ಹಾಕೇ ಹಾಕ್ತಾರೆ ಅವ್ರು.
ಅಲ್ಲ 50% to grant water connection. my
The
lords.
order is not stayed.
The order itself is not stayed. What has happened is, insofar as pro rata is concerned, water supply could not be disconnected. Other water supply ಕೊಟ್ಟಿದ್ರು pursuant to the interim order. Therefore, they said 50% had to be deposited. The Honorable Division Bench has said so.
I will follow my order. After that, follow this order and dispose this petition.
Please, my
Is that all right?
That is fine. my lords.
Yes.
As long as they give water connection
No,
upon
whatever.
50%.
For division bench,
I am ready to deposit that 50%.
the petitioner is before this court seeking the following prayer. The issues raised in the subject petition are all answered by this court in writ petition 12893 of 2022, 12983 of 2022. Ada, Allah.
10020 of 2020, my lords.
10020 of 2020 disposed on so and so. Therefore, the petition would be disposed on the same terms. The learned counsel for the petition at this juncture would submit that the division bench has passed the following order on 19/12/2024. In that light, but respondent ಕೇಳೋದು ಉತ್ತಮ ಅನ್ಸುತ್ತೆ.
Because this order was passed after hearing the respondent.
So and so. In that light, the petition would stand disposed following both the orders of this court and the order of the division bench as directed. It is needless to observe that the order of the division bench would be complied with by the respondent BWSSB.
The
And-
only aspect is there was disconnection, my lords. Here it is fresh connection.
No problem, whatever is, ಇಲ್ಲ you serve on Manish Kumar,
I'll serve it.
better. ಅಲ್ಲೋಗಿ ನಮ್ಗೆ ಹಿಯರ್ ಮಾಡದೆ ಆಗಿದೆ ಅಂತ.
Very well, my lords.
The order ಇಟ್ಕೊಂಡಿರಿ. The counsel for the petition to serve on KB Manish Kumar appearing for the PWSSB list tomorrow.
Tomorrow, please, my lords.
ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ.
I'll serve.
Yes, next.
49.
Learned
For the petitioner.
counsel.
Mandamus.
ಗೊತ್ತು ಸರ್ ನಿಮಿಷ.
All are BDA, all four respondents.
Only BDA ಅಲ್ವಾ?
Indeed.
Counsel B. Vachan is directed to accept notice for the respondent BDA petitioner to serve set of papers upon the aforesaid counsel. List on 18th.
Great.
Yes, next.
50.
There is no representation on behalf of the petitioner. List the matter after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks.
51.
Petitioner is the defendant number 3, man.
Correct. 11 ವರ್ಷ ಆದ್ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ.
ಅಲ್ಲ, 2007 I filed the return statement.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 2017.
17 and return amendment
ಆಯ್ತು,
is under
617 ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಸರ್?
2022, man.
5 ವರ್ಷ ಯಾಕೆ ಸುಮ್ಮನೆ ಇದ್ರಿ?
That pleading has been mentioned earlier also. Now the brief ಮಾತ್ರ ಹೇಳಿ.
ಪ್ಲೀಡಿಂಗ್ ಇದ್ರೆ ಇರುತ್ತೆ ಬಿಡಿ, ಮತ್ತೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾಕೆ ಬೇಕು?
If deed ಬಗ್ಗೆ ಹೇಳಿದ್ವಿ. It is not mentioned clearly and the document number is not mentioned, man. That's why there is
ಅಷ್ಟೇನಾ?
an amendment. The amendment ಅದನ್ನ ಕೇಳಿ.
ಅಮೆಂಡ್ ಇಲ್ಲಿ ಟೇಕ್ ಮಿ ಟು ದಿ ಅಮೆಂಡ್ಮೆಂಟ್.
Page number 51. Earlier return statement I mentioned regarding the gift deed. A gift deed ಬಗ್ಗೆ details I mentioned in the para to include para number 3A, madam. And also regarding that second.
Oh, no, sir.
Release deed also was
Anyway,
mentioned.
get serve on the plaintiff. The petitioner to serve on the counsel representing the plaintiff before the concerned court.
Defendant is not filed any objection to the amendment application.
No problem, sir. Plaintiff 1 and 2 before the concerned court. List on, no, list on 18.
Contesting is the other defendants, man.
Contesting the plaintiff or the contesting defendants as the case would be. List on 20th.
Public.
52.
Mandamus to
Correct.
consider an action.
Learned counsel Murgesh Charati is directed to accept notice for respondents 1 and 2 AGA 1. List the matter next Tuesday. ಇವತ್ತೇ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕ್ಲೋಸ್ ಮಾಡಿ.
53.
Seeking compensation in lieu of acquisition of my property without notification.
Learned counsel, learned AGA is directed to accept notice for the respondent. First respondent ಯಾರು NR ಜಗದೀಶ್ವರ ಅಂತಿದ್ದಾರೆ.
Please.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
We have already served, but I will.
Petitioner to serve set of papers upon NR Jagdishwara, if not already served. List the matter on 19th August.
Please.
Yes, next. ಅದು ಹೇಳ್ಬಿಡಿ.
54.
Appearing for the petitioner, my lords. For Narnalli Layouts,
Correct. Petitioner to serve on learned AGA 1, R2 and 3, TP Vivekanand, 19th.
date, my lords.
19th. Yes. These are all matters that can be disposed, ಅದಕ್ಕೆ 19th ಆಗ್ತದೆ. Yes, next.
55.
Alternate site.
Yes, madam, after 19 years, they say not available.
Correct. Yes.
But they
Petitioner.
also identified in Kempegoda layout that also
ಆಯ್ತು,
they don't have.
19th ಹಾಕೋಣ. Petitioner to serve on Murgesh Charati, counsel Shri Murgesh Charati appearing for the respondent BDA with requisite set of papers. List the matter on 19th. Next.
56.
What's wrong with Taluk surveyor being appointed as commissioner in 26/9?
Initial suit for bare injunction. my lords.
No, so what?
Subsequently, it was converted for recovery of possession, my lords. In the entire prayer, my lords, it doesn't say to the what extent, my lords, there is an encroachment. Or, my lords, in the application also, my lords, it doesn't say.
Let the
my
survey
lords,
be conducted, so what?
lords, survey may be conducted, my lords, if there is any encroachment, my lords. In the evidence also, my lords, nothing has been elicited. To what extent, my lords, I mean,
So
encroachment.
you
my
mean to
lords.
say now 26(9) is for fetching evidence?
Yes, my lords.
The petitioner is before this court calling in question an order dated so and so passed under order 26 rule 9 seeking appointment of commissioner. The learned counsel for the petitioner submits initially the suit was filed for bare injunction which was later converted to declaration, and and without there being any averment or evidence let in the proceedings, the court commissioner is now appointed to fetch evidence,
Please, my lords.
which runs counter to plethora of judgments rendered by the apex court. In that light, the order dated so and so shall remain stayed. The order appointing the court commissioner shall remain stayed. It is made clear that the proceedings before the concerned court are not stayed. Yes, next.
Grateful, my lords.
Emergent notice to the respondent, sir.
57.
Learned AGA is directed to accept notice for the respondent.
All the response.
All the response.
All the respondents list on 20th, list on 21st. The learned AGA to secure instructions and make his submissions. I will dispose Marana. Yes, next.
58.
38D. Yarilva. 1 AGA, 2, 3, 4, 5, 6. All Ajay Kumar is directed to accept notice for the BDA petitioner to serve set of papers upon the aforesaid council, 4th September. Next.
59.
Appear for the petition in this case, my lords.
They are now represented.
Pardon, my lords.
Are they now represented before the court? 39, 1 and 2 is not
Please, my lords.
considered. Are the defendants represented
No, my lords,
today?
because the first defendant is based abroad. The notice has still not been served on them.
How do you serve him now?
Pardon, my lords.
How do you serve him now?
I have taken steps, my lords, but it hasn't reached him yet.
Mysore stoneware and pipes.
Please, my lords.
Abroad yakidare illilva?
The first defendant is abroad, my lord. Second defendant is based out of Bangalore.
The petitioner to serve the second defendant by way of hand summons, and also place on record steps taken to serve the first defendant before the court. List the matter on 20th till such time the temporary injunction that was sought by the petitioner shall stand granted till the next date. Next.
Grateful, my lords.
Yes, sir.
60.
But a small concession was sought before the trial court to further
Order 18
examine
rule
the-
17.
Please, my lord.
The petitioner is before this court calling in question an order rejecting an application under order 18 rule 17 in terms of its order 28/3/2025. A perusal at the application would is indicative of the fact that the application was to be allowed, albeit prima facie. In that light, there shall be an interim order of stay of further proceedings. Petitioner to serve on the counsel who represents the plaintiff before the concerned court and file an acknowledgement of such service by the 1st of August.
Lord, the learned judge is on his toes to
I have stayed, sir.
oblige.
Even before you tell it, I have done it. Yes.
51.
This case, my lord.
Alternate site.
Alternate.
ವಿಶ್ವೇಶ್ವರ
ವಿಶ್ವೇಶ್ವರ ಸೈಟೇ ಇಲ್ಲ ನಮಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ 2003 ಲೇಔಟ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ
ಈಗ ಕೊಡಿಸ್ತಿರ್ತಾರೆ.
ಪ್ಲೀಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ 2 and 3 ಗೆ
ಜಾಗ ಇಲ್ದಿರೋ ಕಡೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಗೊತ್ತು. BDM ಮಾಡ್ತಾರೆ ಇವೆಲ್ಲ. The learned counsel Murugesh Charati is directed to accept notice for the respondent BDA. First respondent BDA. 2 and 3 be served by way of hand summons. List on 28th.
Please.
Next.
62.
60 in this case, my lord, the site ittu but land has been
Same ಇದರಲ್ಲಿ ಇವರು ಕೊಡಿ. K. Krishna. Yes. Next.
53. I appear for the petitioner, my lords.
28/4 ಆಗಿಲ್ವಾ?
No, my lords. There's a delay of 12 years. my lords.
Correct. No 28/4?
I will seek instruction.
Seek instruction.
My lords, this matter is covered by judgment.
Correct, madam. Notice sir ಕೊಡ್ಬೇಕಲ್ಲ? Yes. 1 HCGP 234.
ಬಸವರಾಜ್ ಹಳ್ಳ.
Baswaraj?
ಹಳ್ಳ.
Allah accepts notice. Petitioner to serve set of papers upon the aforesaid counsel. The petitioner, if in possession as on today, shall not be dispossessed till the next date of hearing. List on 28th. Copy what?
54.
election.
ಅದೇ
Oh.
9 months kindly may be granted.
ಏನ್ 9 months kindly may be granted.
9 months kindly.
ಮೂರ್ ತಿಂಗಳಿಗೆಲ್ಲ ನೀವು ತೀರ್ಮಾನ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಅವ್ರು?
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. Election petition all are appeared.
All are appeared. The petitioner is before this court seeking the following prayer. The learned counsel submits that the proceedings before the concerned court in OS 44 of 2025 is concerning election. Yavudakke? Election to third respondent Samaja. In the light of the process of election question, the expeditious disposal is what the apex court has time and again directed. In that light, the proceedings shall conclude before the concerned court within 9 months, if not earlier, ordered accordingly. Let's next. 65, 66, 67, 68, all same. Yes.
For the board, special counsel.
ನೀವು ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್?
Yes.
ಇದು KIDB ನಾ?
Non KIDB.
ಯಾವ್ದಕ್ಕೆ ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್?
For the nice road.
ಅವ್ರು ಯಾರು?
State, 4 persons we are the state.
ಇದು ತುಂಬಾ ಸ್ಪೆಷಲ್ ಮ್ಯಾಟರ್ಸ್ ಇವೆಲ್ಲ, ಬರೀ ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್ ಇದಾರೆ? Yes, we'll see. Learned AGA is directed to accept notice for the first respondent. Special counsel 1.
Along with the special counsel.
Along with.
State ಗೆ ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್. ನೀವು ಯಾಕೆ ಮತ್ತೆ ಕೂತ್ಕೊಂಡ್ಬಿಡಿ. Yes. The special counsel for the state, Ravindra Reddy, accepts notice. Special counsel for the?
That's Siddharth, as an additional advocate general, Malad, we can't find.
ಅಯ್ಯೋ ಯಾವ್ದಕ್ಕೆ ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ಸರ್ ನೀವು?
State only.
ಸ್ಟೇಟ್ ಇಲ್ಲಿ ಒಂದ್ ಆಯ್ತಲ್ಲ ಈಗ?
ಎಲ್ಲದೂ.
ಇಬ್ಬಿಬ್ರ?
ಇಲ್ಲ ಅವ್ರದ್ದೇ ಇರ್ಲಿ. ಟೋಟಲ್ 4 ಜನ ಇದ್ವಿ, ಬಟ್ ರವೀಂದ್ರ ರೆಡ್ಡಿ ಇಸ್ ಎನಫ್.
ಈಗ ಇದ್ರಲ್ಲಿ ಇಬ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾ ಒಂದು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ?
For Ravindra Reddy for all the cases, Malad, the state.
ನೀವೇನ್ ಲಕ್ಷ್ಮೀಕಾಂತ್ ಪ್ಯಾರಲ್ ತರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಯಾರಿಗೆ ಹೇಳಿ?
For the state, Malad.
State is first respondent.
Please, Malad.
ಅದಕ್ಕೆ ಯಾರಿಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು?
Ravindra.
ನೀವು ಯಾರಿಗೆ?
AGM, additional advocate general. We can't take.
ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ?
ನಮಗೇನ್ ಬೇಡ.
ಅಷ್ಟೇ ತಾನೆ. ಮತ್ ನೀವು ಅಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ. Yes. The learned counsel Ravindra Reddy is directed to accept notice for the first respondent state, BDA. KIDB, yes.
I am appearing. Sharan Sabrad.
Sharan Sabrad, 2, 3. Nice. Nice name.
Nitin Prasad.
Nitin Prasad, 4. Petitioner to serve set of papers upon the aforesaid counsel.
Seeking interim stay.
What interim stay?
Dispose ಮಾಡಬಾರದು ಅಂತ.
Yes, the petitioner, if not dispossessed as on today, shall not be dispossessed till the next date of hearing. List on 2nd September. Same ಎಲ್ಲ, same order, 66, 67, 68.
69.
In this case, madam.
Good. Counsel K. Krishna is directed to accept notice for the respondents. Petitioner to serve set of paper, respondent, set of paper upon the said counsel, set of papers upon the said counsel forthwith. List on 18th. Yes. 18th, 19th, 18th.
Submitting for petition and filing and withdrawal memo.
Withdrawal, thank you sir.
70 randomness, Pawan Kumar.
ನೀವು ಯಾವ್ದು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಸರ್?
WP number 21386. WP number serial number 70.
Second list ಇರ್ಬೇಕು, wait. Third list ಇರ್ಬೇಕು, wait.
Apologies.
Third list.
Learned HCGP is directed to accept notice for all the respondents. List on 19th. Next.
71.
A miscellaneous is pending. My application is also, 2 suits were filed, my lord. In fact, my lord, 1 suit, your lordship, similar order was passed, your lordship, lord, has granted an interim order in WP 18977 of 25. 2 suits were filed by bank, my lord. Ex parte judgments, my lord. Miscellaneous petition is pending. My application seeking stay of the.
80,000, yes.
Yes.
Petitioner to serve, tag this petition along with so and so.
WP 18977.
List the matter on 11th September. There shall be an interim order. The learned counsel submits companion petition interim order. In that light, so on. Next.
72.
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff or defendant. Plaintiff who institutes a suit in OS 151 of 2015 seeking ಏನು
ನೋಡಿ he's a E to T
ಸೂಟ್ ಯಾಕೆ ಸರ್? ಇಂಜಂಕ್ಷನ್
injunction and declaration.
suit for declaration and injunction. He is before this court at this juncture seeking a direction for expeditious disposal of the suit in the light of the fact that it is languishing for the last 10 years. The learned counsel would submit that the concerned court is granting adjournments time and again without any rhyme or reason. In that light, I deem it appropriate to infuse finality into the proceedings. Therefore, the concerned court shall endeavor to dispose the suit with an outer limit of 6 months, if not earlier. Yes, ordered according. Next.
23.
No representation. List after 2 weeks. Register is directed not to list prior to the expiry of 2 weeks. Next.
24. Kindly pass over the matter.
Pass over.
LF in quarter number 12, my lord.
Passed over to tomorrow. Yes, next. List tomorrow in preliminary hearing. Next.
75.
The petitioner is before this court calling in question an order date.
In order dated,
Order dated 4/4/2025 by which the application under IA 9 filed in OS 14 of 2009 comes to be rejected. The application is preferred in Order 6 Rule 17. The learned counsel Madhusudan Rao takes this court. So the application so filed, a perusal at the application would prima facie indicate that the application ought to have been allowed. Reject ಮಾಡಿದಾರೆ ತಾನೆ? Ought to have been allowed. In that light, further proceedings before the concerned court shall remain stayed. The counsel for the petitioner shall serve on the counsel representing the plaintiff and file an acknowledgement to that effect. List on 3rd September. ಇವತ್ತು ಸರ್ವ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮತ್ತೆ ಸರ್ವಿಸ್ ಬಂದ್ರೆ ಇಂಟರ್ ಮಾಡ್ರಿ.
immediately to be.
ನೀವು ಮಾಡಲ್ಲ ಹೇಳಿ.
Lord, 74, my lord.
Yes, Pradeep, where were you?
I was held up in another court, my lord. 74, Lord, the petition has already filed a writ petition, my lord, which is pending before this court.
Number ಕೊಡಿ.
Lord, I was not
Suppressed,
aware. I just
suppressed ಅಂದ್ರೆ 1 ಲಕ್ಷ 2 ಲಕ್ಷ 3 ಲಕ್ಷ.
Lord, I just received the number now. I'll verify, my lord. Kindly have it.
List tomorrow.
Tomorrow, please.
ನಾಳೆ ಅದು ವಿಡ್ರಾ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಡೆಫಿನೆಟ್ಲಿ.
Collected the number, my lord. Verify.
ಸಪ್ರೆಸ್ ಮಾಡಿ ರಿಟ್ ಪಿಟಿಷನ್ ಮೇಲೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಕಾಸ್ಟ್.
Writ petition ಆಗಿ stay ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಹೇಳಿ, my lord, he files.
Then I will not permit you to withdraw also.
I am not on record in that matter. I have received the number, my lord.
ಅಲ್ಲ, the parties would have hoodwinked. Advocates ಗೆ ಏನು ಗೊತ್ತಿದೆ?
ಗೊತ್ತಿಲ್ಲ. I'll take instruction.
Tomorrow. Yes.
77. 76.
77, I prefer the petitioner, my lord. Serial number 76.
76, sir.
Sorry, my lord. I am representing the petitioner in this case. We have to file a 151 application to the set aside the compromise.
10 ವರ್ಷ ಆದ್ಮೇಲೆ. Suit for specific performance. Compromise 10 years ago. And you file an app. Who are you?
ನಮ್ಗೆ ಅದು ನಾಲೆಡ್ಜ್ಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ.
ನಾಲೆಡ್ಜ್ಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ಕಷ್ಟ. But who are, ಯಾರು ನೀವು ಹೇಳಿ?
ಡಿಫರೆಂಟ್ ನಂಬರ್ 1, 3 and 7.
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು ನಿಮಗೆ ಗೊತ್ತಿರಲಿಲ್ವಾ?
ಇಲ್ಲ.
Compromise between whom?
Plaintiff and another
dependents. Emergent notice to the respondents. Petitioner is also at liberty to serve the respondents by way of hand summons. List on 3rd September.
77.
For the petitioner, the respondents of
it will fix respondent yaar.
They filed a suit for ejectment against the petitioner.
Caveator Janardana.
Please, madam. Office served on the other side.
There is no representation on behalf of the caveator respondent. The petitioner is before this court calling in question an order dated
12/6/2025
by which the application filed by the petitioner under section 45 and 73 of the Evidence Act refer the disputed signatures comes to be rejected. A perusal at the order would indicate prima facie error in law. In that light, the further proceedings before the concerned court shall remain stayed. list on 1st September, 3rd September. Next.
78.
Lord, JDR is the petitioner. Sued for money and arrest warrant issues is issued against me without following the procedure under section 51.
What procedure? 50,000 suit.
Yes, Lord.
Emergent notice to the respondent. The petitioner is before this court calling in question a warrant so issued without following the due process and law. A perusal at the order would indicate prima facie that the procedure in law is not followed. Therefore, the warrant so hanging on the head of the petitioner shall remain stayed till the next date of hearing. Next.
79.
Lord, I appear for the petitioner.
Mandamus to execute sale deed on learned
Yes, Lord.
counsel. Ajay Kumar is directed to accept notice for the respondent 1 and 2. 1, 2 and 3. Petitioner to serve. Petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 23rd. List the matter on 19th August. Idella dispose madadu. Seek instructions. Next. The petitioner is before this court seeking the following prayer. A suit in OS 781 of 2009 is instituted. Suit any specific performance which is later renumbered as OS 2459 of 2022. However, the fact remains that the suit is of the year 2009 and has been languishing in this concerned court for the last 16 years without it moving forward. The learned counsel takes this court through the order sheet appended to demonstrate that there are only adjournments found in the order sheet. In that light, the concerned court shall endeavor to dispose the said suit with an outer limit of 3 months from the date of receipt of the copy of the order, if not earlier. Ordered accordingly. Next.
81.
Concurrent only. Notice.
Undertake to file wakalat. Some documents are also produced. May I request your lordship kindly status quo order, because they are now by virtue of the impugned order. Now,
sir, you have lost before both the courts.
True, my lord. Day before yesterday, about 25 members came and they demolished a portion of the shed. Status quo may be ordered. If I am there, I will continue. If they are, let they continue. That is my only humble submission.
Why are you precipitating the matter?
There is a police complaint also.
Where is the police complaint?
It is here, my lord.
It is here and the Nangotil.
After filing this appeal, writ petition, a day before yesterday, they came and they
day before yesterday agidya. We will take it day after tomorrow. List day after tomorrow.
Till that time, Mary.
Day before yesterday agiradnella produce madi. Day after tomorrow I will take it.
Till that time. No, there is every threat of disposition.
No, sir. Yes. Next.
Day after tomorrow.
Day after.
Please. Yes.
80.
82.
The petitioner is before this court. Illi RS ಏನು pending ಇದೆಯಾ? The petitioner is before this court calling in question the proceedings in execution, notwithstanding the pendency of RA in collateral proceedings and RSA before this court. Though there would be no impediment to get the decree executed if there is no interim order granted. However, to balance the rights of the parties, I deem it appropriate to grant an interim order of stay before the executing court till the next date of hearing. List the matter on 20th. Petitioner to serve on the contesting respondent and file an acknowledgement by the 1st of August. In the event acknowledgement is not filed, the interim order would get automatically vacated. Yes, next.
53.
Responded by.
An ad interim order of injunction is granted.
Granted.
The contesting defendants file an application under Order 39 Rule 4.
Vacating interim order.
Vacating. It has been pending for last almost 1 year on the ground that other defendants are not served.
2 weeks I will direct the court to consider it. Ashte. The petitioner is heard the learned senior counsel Jai Kumar Patil.
One aspect, my lord.
injunction is sought as against all the defendants, defendant number 1 to 17, 17 defendants, out of which some of the defendants have appeared. Indeed, the court has heard the plaintiffs as well as defendant number 1 to 5, sorry, 6 to 13, and thereafter there is a note in the order sheet that let all the parties be served, only upon which this application has to be considered. Time and again we have been
all other
taking
defendants
steps.
are the persons against whom a decree for specific performance
then
has
don't-
been
yes.
granted.
The
It's only we three
the petitioner
defendants who are
is
contesting.
before this court on a circumstance that the concerned court vacates the interim order on an application filed under.
Granted ex parte ad interim order, we applied for vacating, it is yet to be
Yet to be considered. The petitioners are the defendants. Defendant, defendant
6 to
defendant number
13.
6 to
13.
6 to 13. An ex parte temporary injunction is granted in the suit instituted by the respondent plaintiff. An application is preferred by these defendants under Order 39 Rule 4 of the CPC seeking vacation of the interim order. It transpires that the concerned court for the last 1 year has only adjourned the matter and not considered the application seeking vacation of the interim order as filed by the defendants. The learned counsel for the respondent plaintiff submits that the other defendants are to be served in the matter as injunction is sought against all the defendants. In that light, in the light of the application pending for the last 12 months before the concerned court, I deem it appropriate to direct the concerned court to dispose the application in accordance with law within an outer limit of 3 weeks from today. Ordered accordingly.
84.
The state.
R1.
AGA 1, 2, 3 and 4 emergent notice. You are in possession?
Yes, my lord, we are in position.
The petitioner to serve on the counsel representing the respondents in the road widening.
Yes, my lord.
Matte
It is road
widening stop
widening.
ಆಗ್ಬಿಡುತ್ತೆ.
They have fixed the stone larger than what they are already
Large
notified.
stone?
Yes, my lord.
Large stone?
No, my lord, they have fixed the boundary stone.
Boundary.
Sorry, my lord. Boundary stone larger than what they are notified in the notified for the purpose of accusation. There is 6 guntas of property belongs to the petitioner, my lord. They have fixed more than 75% of the property, but they have notified only 1 gunta, half gunta. Like, well, my lordship may kindly come to the page number 66, wherein they have very clearly said that out of 6 guntas, only 0.4 guntas, not 1 gunta, 0.4 guntas has been acquired, but they are acquiring more than 4 guntas out of 6 guntas. That's why I made a representation before the land acquisition officer as well as the Karnataka Road Widening Authority at Annexure F, my lord.
Road widening ಗೆ ಒಂದು authority ಇದೆಯಾ?
Yes, my lord. Karnataka
Road Widening
Road,
Authority.
my lord, that is the.
ಯಾವ ಫ್ರಾಗ್ಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ
Sorry, my
ನೀವು?
lord, that is.
Road narrowing authority ಅಂತ ಒಂದು ಮಾಡ್ತೀರಾ?
Road Development
Road Widening
Authority.
Authority.
First respondent, my lord.
Sir, Road Development Corporation, Road Widening Authority.
That is third respondent, my lord.
ಅದೇ Karnataka Road Development Corporation
Limited. Karnataka Road Development Corporation.
ನೀವು ಅದು
Limited,
ಬರೆದು
my
ಬಿಡ್ತಾ
lord.
ಇದೆ Road Widening Authority.
Sorry, my lord.
ಮತ್ತೆ ಎಸ್
Made a representation.
ಆಯ್ತು ಸೇಮ್ ಆರ್ಡರ್ ಸ್ಟೇಟಸ್ ಕೋ be maintained till the next date of hearing. 20th. 19th August. Next.
85.
Please, my lords. Only prayer is for alternate.
Arrest land is allotted to you. 1 crore compensation. ಕಮ್ಮಿ ಆಯ್ತು. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಕೇಳಿ. ಎಸ್ ಸರ್.
Sir will appear.
ಲ್ಯಾಂಡ್ ಅಲಾಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಅಲಾಟ್ ಮಾಡಿದೀರಾ? ಮಾಡ್ಬಿಟ್ಟಿದೆ. ಈಗೇನ್ ಮಾಡೋಣ? ನೋಟಿಸ್
As my lord.
ಎಸ್
Please, and also my lords,
Heard the learned senior counsel PP Hegde appearing for the petitioner, 1 HCGP, 2 K Krishna, 3 and 4, Nive, for 1, 3 and 4, 1, 3, 4 and 5 HCGP, 3, 2 K Krishna, petitioner to serve set of papers upon the aforesaid counsel forthwith, list on 26th,
please.
sorry, 28th.
Please.
Survey was conducted for about 3 times, my lord. In that 7 acres was.
Forest land ಹೆಂಗ್ ಅಲಾಟ್ ಮಾಡ್ತೀರಾ? ವಾಟ್ ಇಸ್ ಆಲ್ ದಿಸ್?
We have not allotted.
ನೀವಲ್ಲ, ಬಿಡಿಯೇ.
ಎಲ್ಲ ಒಟ್ಟಿಗಿದ್ದಾರೆ ಇಬ್ರು ನಾವು.
Hands in glow.
No, they will allot an alternative site.
The strong glow.
ಕೊಡ್ಲೇಬೇಕು, ಚಾಯ್ಸ್ ಇಲ್ಲ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೊತ್ತು ಮಾಡಿರ್ತಾರೆ.
ಪ್ಲೀಸ್
ಇಲ್ಲ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀವಿ. 1 crore ಕೇಳಿದಿರಲ್ಲ,
ಕಡಿಮೆ ಆಗಿದೆ ತಾವೇ ಹೇಳಿದ್ರಿ.
ಅದೇ ಕಡಿಮೆ ಆಗಿದೆ ಈಗ. ಎಸ್,
86.
ಫ್ರಮ್ ದಿ ಪಾಕೆಟ್ ಆಫ್ ಪರ್ಸನ್ ಹೂ ಇಸ್ ಅಲಾಟೆಡ್.
We being the first, we have already taken our question.
Yes, Vasant, tell Krishna.
Respondent.
So set the wrong right by the next date.
Petitioner filed for seeking for discard of the evidence actually because the witnesses didn't turn up. For which actually the application came to be rejected as per annexure A.
Correct, sir. Nothing wrong with the order.
Lord, because my counterclaim is there. I set out my counterclaim because it's a breach of the contract actually between the parties. Big friction was going on between the parties. All of a sudden, actually, they wanted to do this.
Petitioner to
pretending
serve on
witness.
the counsel who represents the respondent in the trial proceedings. List on 2nd September.
Till then, actually, proceedings.
No,
may be-
3rd September.
Already posted for actually argument actually instead of leading
Yes.
evidence of mine.
No case. Yes, next. Heard the learned counsel as Subramanya appearing for the petitioner. The petitioner is before this court calling in question the order of the first appellate court which upturns the order of the trial court. Prima facie, the petitioner, prima facie to balance, to protect the interests of the petitioner, there shall be an interim order of stay of the order in dated 19/1/20, date in 25/10/2024 in MA 3 of 2024 till the next date. Emergent notice to the respondent. Next.
88.
The petitioner is before.
Amendment of written statement.
Correct, sir. The petitioner is before this court calling in question an order passed on so and so. Date, Adar ಹೇಳಿ.
9/6/2025.
The order dated 9/6/2025 by which the application under order 6 rule 17 of the amendment to the written statement is rejected. Prima facie, a perusal at the amendment application would indicate that the application ought to have been allowed. In that light, further proceedings before the concerned court shall remain stayed. Petitioner to serve on the counsel who represents ಹೇಳಿದ್ನಾ? Respondents and file an acknowledgement by the 1st of August.
2nd of August.
ಯಾಕೆ?
ಅವತ್ತಿರಲ್ಲ.
ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಹಾಕಕ್ಕೆ ಏನಂತೆ? ನಾನು 20th ಹಾಕಿದ್ದೀನಿ ಮ್ಯಾಟ್ರನ್ನ. ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ 1st of August ಒಳಗೆ ಹಾಕಿ. ಅದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ಬೇಕಾ? ಎಸ್.
89.
List on 20th.
Mandamus may not to consider the section 20.
Compensation. The Vivekananda serve ಮಾಡಿ. Heard the learned counsel G. Balkrishna Shastri appearing for the petitioner. Counsel Shri T.P. Vivekananda is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel 19th preliminary hearing. We'll dispose it on that. Yes.
90.
Petition.
The petitioner is before this court seeking the following prayer. The petitioner, you are the plaintiff.
Plaintiff. I am the defendant.
The petitioners are defendants in a suit instituted by the plaintiff in OS
696 of 12.
696 of
2012.
696 of 2012 for
Permanent injunction.
for permanent injunction. He is before the court seeking a direction for expeditious disposal. It is surprising that a suit for permanent injunction is languishing before the concerned court for the last 13 years. In that light, though the apex court has directed that timeline should not be fixed for disposal of the suits before the concerned court, the suit for injunction being pending for 13 years would undoubtedly entail a direction for this expeditious disposal. In that light, the concerned court shall endeavor to conclude the proceedings. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಈಗ ಅವರು 12 ರೂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಅವರು ಮಾಡಬೇಕು.
Within 6 months from the date of receipt of the copy of the order, if not earlier. Next.
Please.
91.
In
My lords, kindly
My lord,
pass
in
over,
this
my lord,
matter-
senior is held up.
91.
My lord, what happened, my lord, Honorable Justice Keshav
Kindly
ಗೊತ್ತಾಯ್ತು,
pass over,
allotment
my
of
lords.
alternate site.
My lord, the committee is pending before the matter committee. In the meantime, BDA is trying to allot the property.
To whom?
We give to the third party purchasers and site allottees. My lord, my endeavor is until passing of committee taking decision, page 54, may kindly look at, my lord. Notice was issued in 2023. A matter has been heard and reserved for
That-
orders.
Whom are you appearing?
Respondent 1 and 2, my lords.
BDA.
My lords, it
Yes.
may be passed over, my
BDA.
lords, senior, BDA.
Why BDA is interested?
That's why they are trying to, because we
They-
also given representation.
Whom are you appearing for?
Both respondent 1 and 2, my lord.
No, madam. Yaar counsel yaar.
Counsel is DP,
Huh?
madam, DP, madam. She's
DP?
held up in another court. She'll come, my lord. That's
KVET
why-
also filed, my lord, because of that reason only.
KVT ಇದೆಯಾ?
Yes,
ಹಾಗಾದ್ರೆ pass over.
We served also notice to them
List
long
tomorrow,
back.
list tomorrow in preliminary hearing. Day after tomorrow, yes.
Till decide only my grievance, my lord. To committee has to take a decision.
ನಾಡಿದ್ದು ಕೊಡೋಣ ಅವ್ರಿಗೇನು.
ಅಲ್ಲ ಅವ್ರು already agreements and their all lease agreement ಬರ್ಕೊಟ್ರೆ ನಾನು ಮುಗ್ದೋಯ್ತು ನನ್ನ ಕತೆನೆ. That is my grievance, my lord.
ಯಾವ್ದು ನಿಮ್ಮ allotment of what?
My lord, the Arkavati layout, my lord, is
ಗೊತ್ತು
formation.
sir. What allotment are you saying?
Sites, my lord.
ಎಷ್ಟು ಸೈಟ್ ಕೇಳಿದ್ದೀರಾ?
Only 2 sites, my lord. We are the landowners, purchasers, my lord.
List the matter day after tomorrow in preliminary hearing. The respondent BDA shall not precipitate the matter till the next date. Yes.
92.
Mandamus, my lord.
The mandamus interim order not to demolish. What?
Blood, in your lordship. my lord,
Main
was-
prayer ಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ. ಏನು ಡಾಬಾನಾ ಏನಿದು?
ಇಲ್ಲ ಇಲ್ಲ. Lord, it is, Lord, in respect of acquisition, where your lordship, not a separate bench was constituted at another.
ಶಿವರಾಮ್ ಅಂತ ಇದು.
ಹೌದು.
ಬೆಂಚ್ಗೆ ಹೋಗ್ಬೇಕಾ ಇದು?
Your lordship, my lord, on similar terms can be disposed of.
Where is that order? Which order?
My order is not produced before the court, my lord. I
ಕೊಡಿ
can-
ಆರ್ಡರ್ ಕೊಡಿ, ನಾಡಿದ್ದು ಹಾಕ್ತೇನೆ.
Please.
You serve on ಅಲ್ಲಿ ಯಾರಿದ್ರು? You serve on Ajay Kumar.
Please.
Counsel Ajay Kumar is directed to accept notice for the respondent BDA. Learned HCGP 1 list on Friday, 1st August, list on Friday in preliminary hearing. We'll dispose it on that day.
93.
Alternate site, yes. Your name?
Respondent has utilized
Learned.
petitioner land, my lord.
Karthikeyan, my lords.
Huh?
Karthikeyan.
Karthikeyan, correct. Counsel K Karthikeyan. no?
Yes, Karthikeyan.
Learned Counsel K Karthikeyan accepts notice for the respondent. You're also there in BDA?
Yes.
Accepts notice for respondent BDA. Petitioner copy ಇದೆಯಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
Copy, sir.
Just now, sir.
Dispose ಮಾಡದ?
ಅಲ್ಲ, they have
Next
served
week.
it now, my lords, on
Now,
18th.
all right. List on 19th.
Great.
These are all matters which can be disposed. So just secure instructions.
Yes.
Next.
94.
My application for recalling.
ಆಯ್ತು, we will direct the concern to hear and pass orders. Till then we'll state. The respondent Burley, the petitioner to serve on the counsel representing the defendants 1 and 2 before the concerned court and file an acknowledgement of such service by the 1st of August. List on 20th August, there shall be an interim order of stay of further proceedings before the concerned court till the next date. Next.
95.
Who are the impleading applicants?
Myself, my lord. He
Oberoi.
is the co-partner, eldest brother. He is the eldest brother. He has let it out on rent and it was utilized for the joint family funds. For suit is filed, within 15 days, the one gift deed is got executed by the younger brother, taking advantage of the mother's 88-year-old. She is senile.
I'd serve on the plaintiff. Contesting is only the plaintiff.
Also,
Petitioner to serve on the counsel for the plaintiff before the concerned court. The learned counsel for the petitioner challenges an order which rejects an impleading application under Order 1 Rule 10 of the CPC. The learned counsel for the petitioner submits that the petitioner is also a member of the family who ought to have been impleaded in the proceedings. In that light, further proceedings shall remain stayed. List on 20th.
106 also same. Another tenant.
Barley.
Next.
96.
106 ಬರ್ಕೊಂಡ್ಬಿಟ್ರಿ 106.
Here, my property was acquired for formation of Kempegowda layout. For that consent decree was passed, 9 sites was allotted. Now my vendor, which was I have purchased in 1995, he has filed the suit his LRs has filed the suit for.
Learned Counsel B. Vachan is directed to accept notice for the respondent BDA petitioner to serve set of papers upon the aforesaid counsel. ಈಗ ಯಾವ್ದು ನಿಮ್ 9 sites
Nine sites.
ನಿಮ್ಗೆ ಅಲಾಟ್ ಆಗಿದ್ದು ಎಲ್ಲಿದೆ?
Two allot ಆಗಿದಲ್ಲ. ನಮ್ಮ
ಮತ್ತೆ?
property was acquired. CD has been formed. ನಮ್ಮ ಪ್ರಾಪರ್ಟಿಲೇ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ 9 sites.
The BDA shall not alienate the 9 sites as indicated in the petition if not already alienated as on today till the next date of hearing. List on 19th.
97.
Okay, for respond number 1, 2 and 3 minutes.
Got this, the application on order 26 rule 10A for setting is.
They come to page 98, sir. No ground. Yes.
That may be, right may be reserved. After examining the witnesses, I can go for it because there is the one and only course.
The learned counsel appearing for the petitioner after arguing the matter at length would seek leave of this court to urge to present an application of the kind that is now presented after the completion of evidence. Liberty so sought is granted, petition disposed in the aforesaid terms. Yes, sir.
ಅದೊಂದೇ ಇರೋದು ಇನ್ನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಆಯ್ತು ಅದೇ ಮಾಡಿ ಆಮೇಲೆ. Yes, next. Interest on compensation.
But R1 and R6 I will, government will accept, but respondent 2 to 5, Jimaya sir.
1 and 2 HCGP, 3, 4, 5.
6 I will.
3, 4, 6 Niva. 1, 2 and 6 HCGP, 3, 4, 5 KS Bhimaya. Petitioner to serve set of papers 2nd September. Yes, next.
99.
The unconcerned parties have invoked Article 23 Rule 3 of CPC. It is not permissible.
Stranger to the compromise cannot come in.
Please.
Settle. The petitioner is before this court calling in question.
Order dated.
Order dated
17/4/2025
by which a stranger to the compromise petition is permitted to raise a challenge to the said compromise under Rule 20, Order 23, Rule, 23(3)A, Order 23, Rule 3A. It is trite that a stranger to the compromise cannot seek or file an application seeking recall of the compromise. In that light, further proceedings before the concerned court shall remain state. Next.
Please.
Emergent notice to the respondent. 100.
Petitioner. Lord, this is the successive petition of the petitioner, wherein in a suit for partition, he has been arraigned as defendant number 11. He is the present title holder and the kata stands in his name.
Order 12, Rule 6.
Yes,
Allowed.
it is not allowed, man.
You want it to be allowed.
Yes, it has to be allowed on the ground that there
Where is the
categorical
admission? Admission.
Admission in the plaint itself, my lord. Page number.
Admission is
90.
unequivocal or disputed?
It is not disputed. In fact, we also contended that the land has been, occupancy rights has been granted in favor of defendant number 1 during his lifetime. And he has sold the property to my vendor, that is defendant number 11, defendant number 10, and subsequently I purchased the property. In fact, my vendor earlier had filed a similar application.
Anyway, suit stay ಮಾಡಿ ಏನು ಉಪಯೋಗ ಇದೆ?
That
Notice
is a
ತಗೊಳ್ಳಿ.
time bound disposal, my lord.
That stay ಮಾಡಿದ್ರೆ ಏನು ಉಪಯೋಗ ಇಲ್ಲ. Application ಅಲ್ಲ, let the respondent come. Next date ಏನು?
1480. It is in the stage of plaintiff's further evidence.
No problem. We will post it before that and close it. List the matter on 13th August. Petitioner to serve on the contesting respondents before the concerned court and file an acknowledgement of such service.
Except respondent number 11. He is my vendor.
Except respondent number 11. Yes.
101.
Petition, my lords.
In 39, 1 into not granted.
Yes, my lords. My lord, insofar as IA number 1, my lords, not to alienate. Of course, my lords, IA number 2, deposit of friends, my lords, after notice.
Who are you?
My lord, I am the my lord, brother of defendant number 1, 2, 3, and 4, my lords. Defendant number 5, my lord,
What
is the
suit for?
suit for partition and separate possession.
Partition ಏನದು?
Partition and separate possession. As a matter of fact, my lords, earlier, my lord, there is a decree with respect to other properties in which suit, my lords, the defendant number 1, my lords, has specifically admitted during the course of cross-examination that certain properties are not disclosed by him, which are
The
standing in his
petitioner
name.
to serve on the council
Counsel is not
petitioner to serve the contesting respondents by way of hand summons. Ella JV joint venture. Yes. So and file an acknowledgement of such service by the 1st of August. The respondent shall not alienate the suit scheduled properties till the next date of hearing.
Please apply.
102.
I'll take notice for respondent number 1 and 1, my lord. Respondent 2 and 3 are vide. Road forms previously.
Prayer nodidira.
Sorry, my lord.
Void ab initio. Learned HCGP is directed to accept notice for respondent 1, 2 and 3. Gautam Dev Ullal, petitioner to serve set of papers upon the aforesaid counsel. Next.
103.
For petitioner, please. Only writ of mandamus.
The petitioner is before this court. Appeal ಯಾವ ವರ್ಷದ್ದು?
2022. Judgment reserve ಆಗಿತ್ತು 24/1/24.
Petitioner is before this court seeking the following prayer. The petitioner is the appellant.
Appellant.
Appellant before the first appellate court in RA.
RA 149/22.
RA 149 of 2022. The learned counsel for the petitioner submits the matter was reserved for its order and no order has been passed despite passage of 1 year. In that light, he has sought the aforequoted prayer. The prayer being innocuous to a direction to consider to dispose the appeal within a time frame. In the light of the submission that the matter was reserved for its orders, I deem it appropriate to direct the first appellate court to dispose the petition with an outer limit of 3 months from the date of receipt of the copy of this order, if not earlier.
104.
For the respondent.
Appearing for the petitioner. I may request a password.
No password today.
But
Any
date may be
enter
fixed.
shadmale?
The section 14 application was filed. Lord, I suffered an arbitral award and I challenged the arbitral award before the courts at Seeker because I was appointed as an authorized service center at Seeker, Fatehpur. Lord, ultimately the Rajasthan High Court held that that court does not have jurisdiction, but the courts in Bangalore will have jurisdiction because the venue of arbitration was shifted. I filed an application under section 14 to exclude the period which I spent in pursuing the matter before the Seeker court. That application is allowed.
You just request a password.
Anything else?
Led by senior counsel.
List on Friday.
Obliged.
105.
My lord, plaintiff, opportunity.
PO
to
number
cross
40, 1817.
Yes, ma'am. My lord, cross-examination opportunity has been denied.
What opportunity, sir?
My lord, 6/2/2000.
7 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಇಲ್ಲ, 6/2/2025, the examination in chief of DW1 was completed.
They heard
But
the
then
learned
10th
counsel Sanjay Krishna appearing for the petitioner. The petitioner is before this court challenging an order rejecting an application under order 18 rule 17 filed by the petitioner seeking further cross-examination.
So, cross-examination, first time.
Seeking cross-examination of PW?
DW1.
Of DW1. The learned counsel submits that the cross-examination of PW1 was, gets concluded on 6/2/2025.
Examination in chief of DW1.
Examination in chief of DW1 gets concluded on 6/2/2025, but cross-examination is not permitted. In that light, further proceedings before the concerned court shall remain stayed. Petitioner to serve on the counsel representing the defendants before the concerned court and file an acknowledgement by the first. List on 20th. Not 6, same order.
90.
Agree.
107.
Application under 3 rule.
ಆಯ್ತು 3 rule to notice serve on the council.
Stay, my.
Stay ಯಾಕೆ? Yes. List on 13th August. Petitioner to serve on the council representing the respondent before the concerned court.
108.
The petitioner, you are the plaintiff.
Yes.
The petitioner is the plaintiff. The plaintiff is calling in question an order passed under order 26 rule 9 permitting appointment of a court commissioner at the fag end of the proceedings. in that light, the order dated so and so, which date?
The date is 24th June 2025.
24/6/2025 shall remain stayed. It is made clear trial before the concerned court is not stayed.
Highly obliged.
Yes, next.
109.
On 109, I am appearing for the petitions council, my lords. My lords, the BDA after resolving that for the land utilized without acquisition, they'll give 16,000 plus square feet. Later relies upon another government order says that we will give you only 11,000 square feet. Now I am due to get another 3 sites.
Interim order main prayer alla one.
My lords, interim order, my lords, I told him, your lords may only direct that no third party interest be created in respect of the sites in question.
Yes, direct what?
No third party.
Heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner. 1 HCGP, 2 Ajay Kumar, petitioner to serve set of papers upon Ajay Kumar. The respondent BDA shall not create any third party rights during the pendency of the subject petition till the next date of hearing. List on 28th.
110.
It's an arbitration proceedings where construction of a
ಆಯ್ತು,
convention,
ಈಗ original bills produce ಮಾಡ್ಬೇಕು.
original bills is with the owner and that he has annexure B, my lord.
ಈಗ ಅಲೋ ಮಾಡಿದಾರೆ ಅದನ್ನ.
Page number
ಏನ್
21.
ತಪ್ಪು?
Alla, page number 21, may I kindly take my lord to page number
Yes, sir.
21. This is the document they have produced and this has been marked, it has been admitted in the evidence. Now,
Original bill produce ಮಾಡ್ಲಿ ಬಿಡಿ.
original is with the owner. He is withholding the document. He is withholding the document. He is asking to, because I
There
was.
is a serious dispute about what you have produced, so original bill produce ಮಾಡ್ಲಿ.
My lord,
ಏನ್ ತಪ್ಪಿಲ್ಲ.
total contract agreement is 8 crore 11 lakh. Now I have paid in total about 12 lakh 51 lakh. Now after that, now he is making claim for 3 crore. Now for which I have also made a counter claim for
Right,
claim,
we'll see.
claiming,
Sir,
my lord.
petitioner to serve on the council representing the respondent. List on 20th.
My lord, next month, 15th, the 16th, they have given date, earlier to 16th, any date.
No, no, you serve, case ಇಲ್ಲ. Yes, next.
11.
1817 dismissed.
Yes, ma'am. And
What did you want to, whom did you want to examine?
PW2, ma'am.
ಎಷ್ಟು ಸರ್ತಿ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
You have lost the opportunity?
Yes.
Why? Why, sir? ಇದು ಕಮರ್ಷಿಯಲ್ OS, ಟೈಮ್ ಫ್ರೇಮ್ ಎಲ್ಲ.
ಕಮರ್ಷಿಯಲ್ ವೈಸ್ ಅಂಡ್
ಎಷ್ಟು ವರ್ಷ ಮಾಡಿಲ್ಲ?
ಇಲ್ಲ, ವರ್ಷ ಏನಾಗಿಲ್ಲ.
ಮತ್ತೆ ಎಷ್ಟು?
ವರ್ಷ ಏನಾಗಿಲ್ಲ.
ಮತ್ತೆಷ್ಟು?
PW2 was PW1 was examined. He resigned, therefore PW2 was examined. He was not cross-examined.
You lost the opportunity. ಎಷ್ಟು ಸರಿ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬೇಕು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್?
An opportunity, my lord.
ಕಮರ್ಷಿಯಲ್ OS ಅಲ್ಲಿ ಕಷ್ಟ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಬ್ಯಾಂಕ್ ಲೋನ್ ಕೊಡ್ತದೆ ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿಲ್ಲ. ಆ ನಂತರ ದೇ ಆರ್ ಕಲೆಕ್ಟಿಂಗ್ ದಿ ಪ್ರೋಸೆಸ್ ಫೀ. ಅದನ್ನ ಪ್ರೊಸೆಸಿಂಗ್ ಮಾಡೋದಕ್ಕೆ ಅಷ್ಟೇ.
You serve on the respondent. You have no right, you have lost your right, we'll see. ಇವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ, Francis Xavier. The petitioner to serve on counsel Sri Francis Xavier representing the respondent bank.
Matter is posted for arguments.
No problem, sir. Yes.
Arguments.
List on Monday, Tuesday, next Wednesday. Yes.
112.
For the petitioner, my lord.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. And file an acknowledgement of such service by the 1st of August. List on 28th, there shall be an interim order of stay for the proceedings before the concerned court till the next date of hearing.
13.
Betterment charges representation. The petitioner shall serve on counsel Shri B. Vachan is directed to accept notice for the respondent.
It's already in similar matter, my lords. Already.
Notice are ಕೊಡ್ಬೇಕಲ್ಲ.
Sorry, some date may be.
So 3 HCGP 19th. Yes.
Much.
114.
Petitioner.
Now court commissioner was appointed prior to the impleading application.
Prior to the impleading application, and court commissioner advocate is appointed in the FTP. 2013 is the report of the court commissioner.
One moment. Petitioner to serve on the counsel who represents the respondent.
Respondent 1 and 2.
Respondents 1 and 2, the contesting respondents. The petitioner is before the court calling in question an order passed under order 26 rule 9. Sorry, calling in
Accepting the
question.
court.
ಒಂದು ನಿಮಿಷ, ನೀವೇನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು?
ಇಲ್ಲ ನಾವೇನ್ ಹಾಕಿಲ್ಲ.
ಈಗ ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅದನ್ನ?
ಇಲ್ಲ ಏನಾಗಿದೆ, ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಈಗ.
Calling in question acceptance of the report of the commissioner on 21/6/2025. The petitioner gets impleaded into the suit and the report of the commissioner was already in place by then.
Please.
The learned counsel for the petitioner submits that the advocate is appointed as a commissioner to survey the property and place a report regarding in a suit for partition. In that light, there shall be an interim order of stay of further proceedings before the
But for
concerned
interim
court.
order of stay of the order.
There shall be an interim order of stay of the order impugned till the next date of hearing.
Memo, respondents 3 to 46 may be dispensed.
Counsel for the petitioners wants contesting respondents serve ಮಾಡಿ
ಹೌದು.
list on 28th.
Please. Court of. Great.
Seeking to amend the plain prayer, my lord, alternative prayer, my lord, that's it. Alternative prayer, recovery.
ಆವಾಗಲೇ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
I don't want to lead any evidence, my lord.
No
just-
problems. Nothing.
My lord, the nature of the suit will not change.
No. If you want to amend the prayer, you should have done it long ago. Proviso to rule 17 takes off your right.
My lord, by virtue of a sale deed, my lord, I am in the position, my lord, because I did not change the revenue records. My lord, the defendants have created the documents, my lord.
You argue all those points at the time of arguments.
My lord,
I will permit, but there is nothing wrong.
because of the only absence of revenue records, my lord, this situation has arose.
No, sir. We will permit you to argue everything and the court will consider.
A notice may be issued, my lord. Then, please, my lord.
Emergent notice to the respondents. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
My lord, it is posted for the argument, my lord. Till then, at least, my lord.
Notice ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಸ್ಟೇ ತಗೊಳಕ್ಕಾಗಲ್ಲ. Yes, next.
16.
Please.
No.
That's my counterclaim, my lords, filed in the suit. My lords, has not been considered. However, my lords, application for order 7 rule 11
One
was
ನಿಮಿಷ.
filed.
Emergent notice to the, ಯಾರು contesting ಯಾರು?
My lords, contesting respondents are all the respondents because, my lords,
Sir, petitioner to serve on the council representing the respondents.
before the
Suit
trial.
in OS 440 of 2010 comes to be rejected, notwithstanding the fact that the petitioner had registered his counterclaim in the said suit. If the suit is to be rejected, the counterclaim ought to have been continued further. In that light, stay ಏನಿದೆ ಇಲ್ಲಿ?
ಏನ್ ಕೇಳಿ?
In that light, emergent notice to the respondents, petitioner is at liberty to serve on the council for the respondents before the concerned court.
My lords, a date
And
may fix
list on 3rd September.
much. My lords, in this month
In
itself, for this reason, my lords, a suit for bare injunction is pending. My lords, by virtue of this, my lords, they are trying to interfere.
List on 22nd.
Much.
117.
RFA is allowed.
Yes, my lords.
Huh?
Yes, my lords, but we were not given an
The
opportunity to
petitioner
be heard.
is before this court. Petitioner judgment debtors are before this court calling in question an order passed by the executing court, notwithstanding the fact that the RFA filed against the decree itself stands allowed. In that light, there shall be an interim order of stay as prayed for.
118.
I appear for the petitioner in this case, Lord. Lord, the originally.
ಆಯ್ತು, ಸೆಕ್ಷನ್ 10 ಎಷ್ಟು ಪೆಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ?
Lord, ಒಂದೇ.
ಎಷ್ಟು ಸೂಟ್ ಇದೆ ಸರ್?
2 suit.
Same cause of action.
Not same cause of action. In the earlier suit, the original suit was filed for suit for partition. In that suit, I filed an application for counterclaim. I am the defendant in that suit, my lord.
ಈಗ ಇನ್ನೊಂದು ಸೂಟ್ ಏನಾಗಿದೆ?
Lord, the suit for this is, I am challenging the suit for eviction filed by the purchasers.
ಸೆಕ್ಷನ್ 10 ಕಷ್ಟ.
Lord, for the reason, Lord.
ಜೊತೆಗೆ ತಗೋಬಹುದು ಅಷ್ಟೇನೆ. ಸ್ಟೇ ಸೂಟ್, ಅರೆಸ್ಟ್ ಆಫ್ ಸೂಟ್ ಎಲ್ಲ ಕೊಡಲ್ಲ.
Allah, if, my lord, the suit was originally filed for suit for partition. In that suit, my lord, my mother, without consenting of myself and my sister, she sold the property. The property was acquired by my father, utilizing the funds of my father.
Separate.
Lord, for the reason, my lord,
I will not stay any suit, sir. They will be taken by the same court.
already both matters.
Then
same
no
court.
stay of suit.
My lord,
Nothing.
my lord, if the
They
suit-
are not figuratively and collectively the same. They are different.
my lord, the suit for partition is still.
Suit for partition and suit for eviction.
They have filed a suit for eviction against me. Until and unless, my lord, my share has to be determined by the same court.
Both courts are, both the matters are being taken up together, right?
My lord, no, my lord, the earlier suit filed by my
Eviction
sister.
suit stay kelidira.
Yes, my lord. Earlier suit filed by my sister. In that suit, I am the defendant number 2.
The petitioner is defendant number 3, seeks arrest of suit in OS 5289 of 2023, which is filed by the plaintiff seeking eviction of the petitioner. The petitioner is the family member of the petitioner, and others are before the concerned court in OS
OS number
36.
36.
OS 5289 of 23.
This is the eviction suit. Partition
Innೊಂದು
suit
partition ಯಾವುದು?
3612 of 2023.
36
12.
3612 of 2023. In the light of the partition having a bearing on the possession of the petitioner, I deem it appropriate to stay the suit in OS 5289 of 2023 till the next date of hearing.
Much obliged.
Then 19.
Suit for partition, my lord. I'm defendant number 5. I filed an application at 1 rule 10.
Transposition.
Transposition. So that came to be rejected, dismissed. Operative portion at 101, my lord.
Plaintiff is continuing with the suit.
2006.
Why do you want to transpose as plaintiff?
2006 is a case, my lord.
So
till that, even the crossing has not been completed, my lord.
We'll direct the court to conclude the proceedings within a time frame. That does not
My
mean
lord,
you
there is a
should.
collusion apparent in the face of it between the
We'll
plaintiff and the
direct.
other defendant.
ಆಮೇಲೆ ನೋಡೋಣ. If collusion emerges, we'll see.
That is,
Otherwise, no reason for defendant to transpose as plaintiff. You are entitled if the suit is withdrawn.
also one of the daughter, my lord.
I'm not saying you're a stranger, but transposition without any rhyme or
Not
reason.
seeking for stay, my lord, because 1 rule 10 also there's application that's been pending under.
ಆಯ್ತು
then
ಸರಿ.
it did my fix.
Serve ಮಾಡಿ. Petitioner to serve on the counsels representing the defendants before representing the respondents before the concerned court. R16 be served by way of hand summons. List the matter on 28th.
12th or 13th. Because 13 one application pending, my lord. Where I mean,
ಇರ್ಲಿ
21
ಪರವಾಗಿಲ್ಲ.
good task.
ಏನಾರು ಆದ್ರೆ ಅದ್ರಲ್ಲಿ ಹೇಳಿ. Yes. Next.
Published.
120.
The KV responded.
The counterclaim had to be continued. Without continuing the
No,
counterclaim.
counterclaim ಹಾಕಿಲ್ಲ. You want WS to be treated as counterclaim.
ಇಲ್ಲ ಸ್ವಾಮಿ. Prayer, your honor, your lordship may kindly turn to written statement.
ಹಾಕಿದಾರ counterclaim?
ಹಾಕಿದ್ದೀವಿ.
ಮತ್ತೆ?
Your lordship may kindly turn to written statement. Para 20, my lord. Page
Separate
20.
counterclaim ಎಲ್ಲ ಹಾಕಿದ್ರೆ
ಅಲ್ಲ, page 20, your lordship may kindly.
WS ಅಲ್ಲಿ ನೀವೇನೋ ಪ್ರೇಯರ್ ಕೇಳ್ಬಿಟ್ರೆ counterclaim
ಅಲ್ಲ,
ಆಗಲ್ಲ.
by way of counterclaim ಅಂತಾನೆ ಹೇಳಿದೆ ನೋಡಿ ಸ್ವಾಮಿ. Your lordship may kindly see, please to honorable court be pleased to dismiss the suit of plaintiff, on the other hand restrain the plaintiff from interfering with so and so ಅಂತ ಮುಟ್ಟೆ ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ. And also should have been mentioned. And the learned judge also refers to the counterclaim in the order saying that
by mistake counterclaim
ಅಲ್ಲ,
number.
ಇದು injunction ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ. I have mentioned the injunction. Your lordship may kindly pass over, my lord.
Pass over. ಯಾಕೆ?
Senior ಇದೆ.
Passed over by 1 week.
ಸ್ವಾಮಿ.
Next Tuesday. Next Wednesday ಹಾಕಿ.
Please.
ಏನ್ ಕೇಸ್ ಇಲ್ಲ.
ಅಲ್ಲ, direction may be issued because there are 9 years they have been fighting, my lords.
ಅದು ಬೇಕಾದ್ರೆ ಕನ್ಕ್ಲೂಡ್ ಮಾಡಕ್ ಡೈರೆಕ್ಟ್ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ, ಸೂಟೇ ಅವ್ರದ್ದು withdrawn.
ಮತ್ತೆ is withdrawn the suit. You should have
This
registered
may
a
be considered as a suit and permitted. Injunction ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ. I sought for injunction.
By this
Injunctive
time,
prayer
they would
is
have
there.
filed one more suit.
ಅಲ್ಲ,
ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ. Because they have sought for this,
And they
considering
can't
pleadings
immediately
complete ಆಗುತ್ತೆ.
prosecute the suit.
Issues ಆಗತ್ತೆ. Already 7 years they have been fighting, my lord. That's the reason why I'm asking.
ಇನ್ನೊಂದು ಹಾಕ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು ಸೂಟು.
ಅಲ್ಲ, already it's a pleadings complete ಆಗುತ್ತೆ. Again, notice
ಇನ್ನೊಂದು
of
ಸೂಟ್
pleadings.
ಹಾಕದೆ ಹೋದ್ರೆ ಇದೇ ಮಾಡೋದು. Plaintiff will intelligently withdraw the suit. If you have no
And he has
counterclaim,
suffered an
WS
order. Your
goes.
Lordship may kindly see the conduct. He has suffered an order. Later on, since he has suffered an order of injunction, he withdraws his, files a memo and withdraws his suit.
ಇದು ಜಾಸ್ತಿ ಆಯ್ತು ಸ್ವಲ್ಪ ಕಾಂಡಕ್ಟ್.
IA3, your Lordship may kindly see.
In fact,
They
it
immediately
offends-
suffers an order, he files a memo for withdrawal.
Just been
Just
judgment of
because-
dishonorable court. I
Sir,
would have challenged
why should you fall prey to his intelligent tactics?
No, that's why a filed counterclaim has been sought in the.
ಎಲ್ಲಿದೆ counterclaim?
ಅಲ್ಲ, injunction has been sought for.
Impleading cannot be converted to a counterclaim. It is not there. Yes. Anyway, next Wednesday. Yes.
My lords, it may be kindly day after tomorrow. my
No,
lords.
day after tomorrow.
Because there is threat of alienating the property. Your Lordship may kindly see.
ಅಷ್ಟ್ರಲ್ಲಿ ಸೇಲ್ ಡೇಟ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೀರಾ? ಏನಿಲ್ಲ.
Your Lordship may kindly.
ಪ್ರಕಾಶ್ ಹೇಳಿದ್ಮೇಲೆ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಇಲ್ಲ ಬಿಡಿ. Yes.
Oh, please.
List next Friday, Wednesday.
Please.
121.
Petitioner was.
Serve on the respondents. The counsel Ajay Kumar is directed to accept notice for the respondent BDA petitioner to serve set of papers upon the said counsel. List next Tuesday in preliminary hearing. Till such time, the auction of the property shall not be undertaken. Next.
122.
Petitioner, my lords. Plaintiff is the petitioner. Suit for declaration, cancellation, and my lords, possession of the suit property. A gift
No
deed.
ground. 1817 rejected.
My lord, kindly see, my lords. The certain questions, my lords, only one date, my lords, I will not seek any further adjournment. My lord, the bank has, my lords, advanced the loan in my favor. Without discharging the loan, my lords, the bank, my lords, further granted the loan in favor of the defendant number one, not based on the gift deed. My lord, those questions, my lords, I wanted to please.
Which
Earlier
bank,
counsel, my
sir?
lords, since died, my lords.
Which bank?
Not Janata Cooperative Bank, my
Oh.
lords, whom, my lord, was examined as DW2. That is why, my lords,
No, sir.
earlier counsel, my lords, since died, my lords, I could not raise that
10
question.
ವರ್ಷ ಆದ್ಮೇಲೆ ಇವೆಲ್ಲ ಇಲ್ವೇ?
ಅಲ್ಲಲ್ಲ.
Earlier change of counsel, no ground.
Now, my lords, the cross-examination of DW3, my lord, is just completed, my lords. That's all, my lords. The matter is now, my lord, posted for final argument.
Serve ಮಾಡಿ.
Only-
No ground.
only-
no-
only
No
the-
interim mod.
One, my lords, one
The
date, my
petitioner-
lord, is
I will
lords,
see.
for complete the
Petitioner to
cross-examination.
serve on the contesting defendants before the concerned, counsel for the contesting defendants before the concerned court and file an acknowledgement. List the matter on 6th August.
Please.
Yes. Serve ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ no.
123.
Who are you, sir?
I am for the applicant.
Stranger in the mirror, sorry, stranger in the partition suit.
No, my lords, I had filed.
ಮತ್ತೆ ಯಾರು sir?
Your Lordship may kindly see, the very property which involved, my lord, has been allotted to me, and the plaintiff says.
Allotted to you, who are you?
Allotted to my grandmother.
Who are you?
Grandmother. My grandmother was allotted the property, and my grandmother has executed a will in favor of my father. Then my father has executed executed will and have produced a judgment saying that the will is valid insofar as it was executed by my mother in favor of my father, my lords. Now, my lord, now to.
My lord, for the respondent, yesterday I filed a caveat petition.
ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದು.
ನಾಡಿದ್ದು.
Please.
Counsel for the petitioner to serve set of papers upon counsel for caveator.
Caveat.
So, list day after tomorrow.
Please.
Only respond number one, my.
Huh?
Only in respect to respond number one.
Respond number 1. So and so, ಹಿಂಗ್ ಮಾಡಿ. So and so undertakes to enter appearance for respond number 1, register to print the name of so and so is appearing for the respond number 1. ಆಮೇಲೆ order.
Please. Caveat has been.
ಎಲ್ಲ ಒಂದು ಕಾಪಿ ತಗೊಳ್ಳಿ.
Please.
124.
Why 12 impleading applicants?
Your lordship, they have impleaded 12 applicants on the same ground. Here we had filed our suit for
Who is the contesting respondent?
contesting respondent is defendant number 1, your lordship.
Only one is it?
Only one.
The petitioner shall serve on the counsel who represents the first defendant before the concerned court. The suit is for?
Suit is for, we have prayed for declaring the one sale deed. The defendant number executed is null and void on the ground of forgery. There is already a decision by the Honorable High Court that the thumb impressions were not identical of the party in another suit, whereas this impleading
Sir,
party
so and
statements
so
are
and
not
file an
necessary.
acknowledgement of such service before the next date. List the matter on 22nd, list the matter on 19th, 20th. The order impugned shall remain state till the next date.
Your lordship, the notice to the impleading applicants may kindly be dispensed because it is a question,
Allow ಆಗಿದ್ಮೇಲೆ notice dispense ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes.
because they are not at all actually necessary parties.
That is
to this.
ಆಮೇಲೆ. Now there is an order against you. They are directed to come on record. We'll see whether you can't dispense notice to them.
Much obliged.
25.
For petition in this case, my lord. So plaintiff petition, my lord. Pre-trial amendment has been rejected by the trial.
Petitioner is before this court calling in question an order dated 16/4/2025 rejecting an application filed seeking amendment under Order 6 Rule 17. A perusal at the order would clearly indicate, would prima facie indicate that it ought to have been permitted. In that light, further proceedings before the concerned court shall remain stayed.
Obliged.
126.
It's matter for expeditious disposal of a memo filed seeking dismissal of the suit, my lords.
Why have you filed?
Lords, the plaintiff, respondent number 1, was before the civil court, and the very registration of the respondent number 1 has been quashed by this honorable court, my lords. That is at page number 52, my lords. Pursuant to which I file a memo seeking dismissal of the suit.
All right. Petitioner to serve on the counsel representing the plaintiff first respondent and file an acknowledgement of such service by the first. List on 20th. Further proceedings shall remain stayed
No, my
in
lords,
OS.
what I'm seeking is for expeditious disposal, my lords.
Ashtana?
Ashtas.
On what expeditious disposal?
On my memo filed for dismissal of the suit. Because on the
The
strength of
petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that the petitioner's defendants have filed a memo seeking memo. How can you file memo to dismiss the suit?
What had happened was,
Memo na? Ayena.
Lordship, but
Memo
please see page
seeking
74.
dismissal of the suit on the score that the coordinate bench, ಯಾವ್ದದು? Which matter, sir?
The order in the writ petition is at page 52.
The coordinate bench in writ petition 16821 of 2024 has allowed the petition and the certificate of registration of the fourth respondent is quashed. In that light, the memo is preferred. The memo is not taken into, no order is passed on the memo, despite the order passed by the coordinate bench. In that light, the concerned court shall dispose the memo so filed in accordance with law within 3 weeks from the date of receipt of the copy of this order, if not earlier. Next.
I'm grateful.
127.
For the petition, Madam is seeking direction to the KADP to determine
Current counsel
compensation.
P.V. Chandrasekhar is directed to accept notice for the respondent
2 and 4.
2 and 3, 1 AGA 19th.
2 to 4.
2 to 4.
No,
2 to
endorsement
4.
is issued, my lords. 2017 is
Made a
acquisition.
representation.
List on 19th, yes,
Great. That's in the preliminary hearings.
19th.
28.
Petitioner,
What's wrong?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಅದೇ ಪ್ರೊಬೈಟಿಕ್ ಪಬ್ಲಿಕ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪಬ್ಲಿಕ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಅದು ಸೆಕ್ಷನ್ 15 ಆಫ್ ಇಂಡಿಯನ್ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ ಪ್ರಕಾರ ಅವರು ಯಾರಾದ್ರೂ LRs ಇದ್ರೆ ಅವರನ್ನ ರೆಕಾರ್ಡ್ ತನ್ನಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಆರ್ಡರ್ ಅದು ಯಾವಾಗ ಅಂದ್ರೆ ಇಫ್ ದ ಫೀಮೇಲ್ ಪರ್ಸನ್ ಡೈಡ್ ಇಂಟೆಸ್ಟೇಟ್, ಇದ್ರಲ್ಲಿ ವಿಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸೆಕ್ಷನ್ 15
ಪ್ರೊಬೈಟ್ ವಿಲ್ ತಾನೇ ಮಾಡಕ್ ಬಂದಿರೋದು.
ಹೌದು ಸರ್.
Petitioner 2, ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾರು ಇಲ್ವಾ?
ಇಲ್ಲ. ಅಲ್ಲಿ
ಇಷ್ಟೇ
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗಲೂ ಯಾರು ಬಂದಿಲ್ಲ.
ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ ಇನ್ ಪ್ರಿಲಿಮಿನರಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. ಫ್ರೈಡೆ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಆನ್ ಫ್ರೈಡೆ.
ಮುಚ್ಚ
129.
Partition.
Who are you?
I'm the plaintiff.
ಅದು ಗೊತ್ತು ಸರ್. Who are you? Partition suit ಅಲ್ಲಿ.
Order
1 Rule 10.
Yes, 1 Rule 10.
Who are you?
I am the plaintiff and family member, co-person. Suit
who
is
is-
filed against the father and brothers. These the respondents are subsequent. 1 Rule 10 filed against the
By the
subsequent
respondents.
purchasers.
Purchasers during the suit or prior to the suit?
Prior the suit, but one schedule has been included at the time of filing the suit. But subsequently, they sold the property. Respond number 10 is they sell the properties to the subsequent purchasers, the impleading applicants.
But preliminary decree you can't enter.
Yeah, not-
Unless,
it's not
unless you
decree.
have purchased it, they allow ಆಗಿದೆಯಾ?
Dismiss ಆಗಿದೆ.
ಮತ್ತೆ? Yes.
Kindly take the page number 59, my lord. Revenue record stands still respond number 10, my lord. He was the party before the suit.
Let's see. The contesting yaru?
Contesting 1 to 4, my lord.
Petitioner shall serve on the counsel representing the defendants 1 to 4 and file an acknowledgement of such service by the 1st of August in the such service before the registry by the 1st of August. List on 28th till such time further proceedings before the concerned court shall
This is the
remain.
notice to the respond number 5 to
Memo,
11.
memo.
I filed.
Memo ಕೊಟ್ಮೇಲೆ, yes. Next,
130.
Paper petitioner. For a
mandamus
declara-
compensation.
No, no, not compensation.
Huh?
For a declaration that the acquisition proceedings have lapsed.
130.
130.
Huh.
What is it? It's not the case of compensation. According to the award. has not-
Declare acquisition, all right, 1963.
ಹೌದು.
Hmm.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, we continue to be in possession throughout. Revenue records stood in our name. We filed the suit for declaration and injunction. In the suit, my lord, the defendants say that the property has been acquired without giving any details of acquisition. In 2023, they produced the documents. As on, in fact.
You are in possession today?
I'm in possession today because DW7 in the cross-examination has categorically admitted that no sites have been formed in my property. And in fact, after in 2007, my lord, the borewell was demolished by these other people.
ಅಯ್ಯೋ, ಸರಿ.
Higher caste people.
2007.
7 ನಲ್ಲಿ. ಅವರು in fact government
Learned,
itself has
one
restored
ನಿಮಿಷ.
it.
Learned HCGP 1, 2 and 3. List on 19th. If the petitioner is in possession as on this date, his possession shall not be disturbed till the next date.
130.
Yeah, if he is in possession. Yes. 130?
31.
But the connected matter as now listed today, it may be taken up along with the connected matter.
What connected, sir? WS 120 days ಆದ್ಮೇಲೆ?
Yes, ma'am.
ಏನ್ ಕೇಸ್ ಇಲ್ಲ.
Matter is pending for.
Matter may be pending. WS after 120 days, no right in commercial OS.
One opportunity may be given.
No opportunities. Only opportunities dismissal. 1 day delay idrunu illa. Yen statutory mandate, sir. Supreme Court affirms
The
it.
transaction, my lord,
Huh?
he has filed a suit.
Maybe,
against-
sir, 120 days ಮುಂಚೆ ಹಾಕಕ್ಕೆ ಏನಾಗಿತ್ತು ನಿಮ್ಗೆ?
That's the inconvenience which is happened.
Inconvenience, very inconvenience. Nothing doing.
An opportunity may
No, sir.
be taken up along. with
Covered,
the
sir. It's covered by what I have written. At least I have to follow that alva.
matter. I have seen.
JSM ನೋಡಿಲ್ವಾ?
Note them.
ಮತ್ತೆ.
At least I may be permitted to cross-examine the witness along on point of law, my lord.
You can always cross-examine. Written statement ಹಾಕಿಲ್ಲ ಅಂತ cross-examination nobody can take away.
That observation may be made.
The counsel for the petitioner. The petitioner is before this court seeking the following prayer. The counsel for the petitioner, after arguing the matter at length, would restrict his prayer to urge all the contentions restrict his prayer to permit the petitioner to cross-examine the plaintiff or his witnesses in accordance with law. It is made clear non-filing of the written statement cannot be taken as denial of cross-examination by any means. With the aforesaid observation, petition stands disposed.
132.
Who is the impleading applicant?
He is the dealer. He is.
Dealer?
He is the dealer of petroleum
ಅದೇ
products.
ಹೇಳಿ ಫಸ್ಟ್. ಬರೀ ಡೀಲರ್ ಅಂದ್ಬಿಟ್ರೆ?
He's a dealer. He was
ನೀವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಏನ್ ಹೇಳಿ ಡೀಲರ್? ಪೆಟ್ರೋಲಿಯಂ ಪ್ರಾಡಕ್ಟ್ಸ್.
Not very, it's a petrol bunk, my lord. And it's a petrol bunk. There is a clause, my lord, which says that they are permitted to retail outlet that could be given. At least he should have been given a notice, my lord, saying that he should be terminated co-extensively with regard to the lease agreement. That has not been done. Page 97, my lord, there is one clause.
He is only a dealer of petroleum products. There is no privity of contract between me and him. I am evicting my tenant.
With whom has he the contract?
He has with I was Indian Oil Corporation. Nothing with me. There's no arrangement between me
That
and
arra-
the
ಅಲ್ಲ
landlord
ಈಗ
and-
ನೀವು ಅವರು ಏನಾದ್ರು ತೊಂದ್ರೆ ಆದ್ರೆ ಇವ್ರಿಗೆ ಎಫೆಕ್ಟ್ ಅಲ್ವಾ?
ಇಲ್ಲ, ಇವರು they enter into
A dealership
a
agreement. is
dealership
entered.
agreement in 2017 for 15 years. That is far subsequent to my lease deed. That is an arrangement.
That's all right.
They'll go to another petrol bunk. If this petrol bunk is evicted, they go to, that is nothing to do
Petroleum
with me.
products you sell within the premises, is it?
Yes.
Shift ಮಾಡ್ಕೊಳ್ಳಿ ಬೇರೆ ಕಡೆ.
Product
can-
means it's a petrol bunk, my lord, which we.
ಪೆಟ್ರೋಲ್ ಬಂಕ್ ಅಲ್ಲ.
It's a petrol bunk.
It is a petrol bunk.
It's a petrol bunk.
Then let him come, so what?
ಇಲ್ಲ, no, my lord-
ಅಲ್ಲ ಆರ್ಡ್ 1 ರೂಲ್ 10 ಅಲ್ಲೋ ಆದ್ರೆ ಏನೀಗ?
ಇಲ್ಲ, one ನಿಮಿಷ. ಈಗ it's already posted for arguments. I just take your lordships to page 60 of their license.
ಆಯ್ತು, ಫ್ರೈಡೆ ನೋಡುವ. ಯಾವತ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್?
So ಇವತ್ತು arguments final ಗಿದೆ.
Then defer it. Concerned court shall defer its proceedings
One
to the.
second, my lord. What I would just take your lordship to their own.
No, we'll hear it on Friday. List the matter on Friday. The concerned court shall defer its proceedings to the next date.
No, they have said that they are not, what he says is, dealer shall have no right, title or interest in said premises or outfit and shall not be entitled to claim any right of lessee, sublessee.
ಆಯ್ತು ನೋಡೋಣ Friday.
Our document, this is their own document.
Friday ನೋಡೋಣ.
133.
We'll only undertake. I'll only
Ah,
undertake.
sorry. The learned counsel appearing for the respondent, other previous matter, madam, undertakes not to precipitate the matter before the concerned court till the next date. So Friday. Yes.
My lord, grievances with regard to the granting
That's
police
all right.
aid.
Who has injunction?
My lord, he had the injunction.
Then no problems.
My lord, only one submission, my lord.
Yes, sir.
Kindly peruse the order sheet.
Injunction ಇದ್ದು police protection ಕೊಡಬಾರ್ದು ಅಂದ್ರೆ you can't say
ಅಲ್ಲ
that.
ಅಲ್ಲ ನಾನು ನಾನು ಹೇಳಲೇ ಇಲ್ಲ.
ಆಮೇಲೆ?
ನನ್ನ ಪ್ರಾರ್ಥನೆ ಇಷ್ಟೇ. ತಾವು ದಯವಿಟ್ಟು 53 ಪೇಜ್ ನಂಬರ್ ತಾವು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿದ್ರೆ
ಹಾ.
ದೇ ಗಾಟ್ ಇಟ್ ಅಡ್ವಾನ್ಸ್ಡ್ ಆನ್ ದಟ್ ಡೇ ಮೈ ಲಾರ್ಡ್.
ನೀವು ಹಿಯರ್ ಮಾಡದೆ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಹೌದು ಮೈ ಲಾರ್ಡ್. ನನ್ಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ಗೂ ಟೈಮ್ ಇಲ್ಲ ಅಂತ ನನ್ನ ಪ್ರಾರ್ಥನೆ. ತಾವು ದಯವಿಟ್ಟು 53, 54 ನೋಡಿದ್ರೆ ಇಟ್ ವಾಸ್ ಅಡ್ವಾನ್ಸ್ಡ್. ಅಲ್ಲಿವರೆಗೂ ಇಂಜಂಕ್ಷನ್ ಇರ್ಲಿಲ್ಲ. ಆಮೇಲೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿ
ಇಂಜಂಕ್ಷನ್ ಅಡ್ವಾನ್ಸ್ ಮಾಡಿ ತಗೊಂಡಿದ್ದಾರಾ?
ಅಲ್ಲ, ಇಂಜಂಕ್ಷನ್ ಬಿತ್ತು. ಆಮೇಲೆ ಏನಾಯ್ತು, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ಲಿಲ್ಲ ನಾವು, ಮತ್ತೆ ನಾನು ಹಾಕಿದೆ. ಈ ತಾವು 54 ನೋಡಿದ್ರೆ ತಾವು ನೋಡ್ಬೋದು. ನನಗೆ ಆಪರ್ಚುನಿಟಿ ಇಲ್ಲ ಅಂತ ನನ್ನ ಪ್ರಾರ್ಥನೆ ಅಷ್ಟೇ. ದಿಸ್ ಇಸ್ ಓನ್ಲಿ ಮೈ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್. ಇಫ್ ಮೈ ಲಾರ್ಡ್, ಐ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್ ಅದರ್ ಅಪ್ಲಿಕೇಶನ್ ಟು ವೆಕೇಟ್ ಆರ್ ಮೈ ಲಾರ್ಡ್ ಟು ವಿತ್ಡ್ರಾ police help. My lord, it's a matter of merits, my lord. This procedural, my lord, I am before your lordship.
The learned counsel submits that the matter which was slated to be listed on a particular date is advanced and the impugned order is passed without hearing the petitioner.
We giving
Though,
opportunity.
Without opportunity of hearing. Though the injunction though the law is an injunction in favor of in favor of the plaintiff can be protected by way of grant of police protection. That could not be without an opportunity of hearing to the petitioner.
Please.
As he had already represented and was awaiting filing of written statement.
Please.
In that light, the order impugned shall remain stayed.
Please.
List the matter on remain stayed. In the light of the stay granted, the parties to the list shall not precipitate the matter against each other.
Please.
List the matter on 20th. ಇಲ್ದರೆ ನೀವು ರಾತ್ರಿ ಹೊಡೆದಾಡ್ಕೊಂಡು.
ಇಲ್ಲ. No, my lord.
List on 20th, petitioner to serve.
Please.
On the plaintiff's counsel.
Along with emergent notice of ಜ್ಞಾನ. ಎರಡು
ಆಯ್ತು, ಬೇಡ, ಅದು ಬರೋದು ಲೇಟ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಎರಡು ನಾನು ಸರ್ವ್ ಮಾಡ್ತೀನಿ. ಎರಡು ಅಪ್ನೆ ಆಗ್ಬೋದು.
Petitioner to serve on the plaintiff's counsel before the concerned court and file an acknowledgement by this 2nd of August. List the matter on 28th.
Please, my lord, one apology to the honorable court is, interim prayer ಅಲ್ಲಿ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಕೇಳಿದ್ದೀನಿ. ಇಂಟ್ರಿಮ್ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಏನು
ಸ್ಟೇ ದಿ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿದೆ. ಸ್ಟೇ ದಿ ಆಪರೇಷನ್ ಆಫ್ ದ.
ನೀವು ಅದು ಕೇಳಿದ್ಮೇಲೆ ಲಾರ್ಜರ್ ರಿಲೀಫ್ ಇಸ್ ಸಾಟ್, ಸ್ಮಾಲರ್ ರಿಲೀಫ್ ಕ್ಯಾನ್ ಬಿ.
My apologies.
134.
My lord, may I request for the hand delivery of the order, my lord. Police are coming to the spot. Please, much obliged.
134, my lord, kindly permit me to represent respondent number 1.
670 ಯಾರು petitionerಗೆ ಏನ್ ಗ್ರೌಂಡ್ ಇಲ್ಲ. 617 rejected, correctly rejected.
Even in my written. Property itself is different, even in
my written
cross-examination.
It changes the nature of the entire proceedings.
12 suits.
No, I'm seeking, my lords, there is false boundary stated by the plaintiff towards northeast states that there is a road. I've taken such a contention by specifically narrating that whatever the boundary stated in the plaint is not
You have
correct.
taken a contention when, sir?
In the written statement, kindly see page 50.
When, sir?
While filing my written statement
When,
on,
sir?
on
2012.
Application 13 years after the,
The closure of evidence is only in
Oh,
the
no,
year
sir.
2019.
nothing,
And even
anything
in the
else, sir?
even in the cross examination, she specifically
You,
denies.
whatever you want to examine, examine, but I will not permit amendment of a 13-year-old suit, which completely changes the nature of the defense itself.
I've taken such a
Nothing.
contention. I'm only saying the boundaries towards the north is not forthcoming in my defense.
Correct.
Therefore, I've sought
No, no,
amendment.
sir.
It does not change the nature of
No,
the suit.
it
My lord.
doesn't.
This prayer is,
No,
prayer
sir.
is for declaration.
Ella
and
evidence
injunction.
admele you want to protect that by amendment.
No,
No,
she
sir.
has specifically denied. As
That is why
regards-
you have filed an amendment.
Exactly. my
ಅದು
lord, when
2012 ಅಲ್ಲಿ amendment ಹಾಕ್ದಾಗ WS ಹಾಕ್ದಾಗ ಗೊತ್ತಾಗ್ಬೇಕು.
evidence is closed only in the year 2019.
No, sir. Anything else, sir? Dismissed. Yes.
135.
No representation list after 2 weeks.
136.
135 ನೀವಿದ್ದೀರಾ?
Nagbhushan, sir.
ಹಾ.
Plaintiffs,
ಏನ್ 4 ವರ್ಷದಿಂದ ಸ್ಟೇ ಇಲ್ಲ, ಇವಾಗ ಏನ್ ಕನ್ಕರೆಂಟ್? ಎಸ್. ಏನ್ ಕೇಸ್ ಇಲ್ಲ. 3 ವರ್ಷ 2022 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ರಿಜೆಕ್ಟೆಡ್. 2023 MA filed, 2025 MA rejected. No point in time you had any protective orders.
question is, my lord, when the grant itself is pending before the authorities, my lord. Land tribunal is pending and the authorities are pending. Parties are standing in our name for up to 96.
Nothing.
This is the only point, my lord. Without
Notice.
exam, without, my lord, they
Notice
say.
ಅಷ್ಟೇ.
The lordship mentioned the status quo.
No, sir. 4 ವರ್ಷದಿಂದ ಇಲ್ದೇ ಇರೋದು ಈಗ ಕೊಡು. No way, yes. Emergent notice to the respondent. Next.
136.
Attachment.
That's interim
ನಿಮ್
order.
ಪ್ರಾಬ್ಲಮ್ ಮುಗ್ದೇ ಇಲ್ಲ ಇನ್ನು.
There's a different issue.
ಎಲ್ಲ different issues keep coming up between the same parties.
No, it's not the same party methods.
Ingram Micro.
This methods are
same
not,
party.
no,
Yes.
this issue.
Creative
methods-
Infotech ತಾನೇ ಇದು.
Creative Infotech,
ಮತ್ತೆ,
but
yes.
different issue methods.
Will not forget, sir. Yes.
That 17(2) order has to be executed in terms of 136 methods. But methods, what has happened is they have executed it as though it's a decree methods. That methods may not be permitted or is not permitted.
Attachment order challenge ಮಾಡಿರೋದು. Serve on the respondent.
Yeah, the proceedings
Hey, ಬೇಡ್ವಾ?
may, he'll serve. I'm only saying
Counsel for the
methods-
petitioner to serve on the counsel who represents the decree holder before the concerned court and file an acknowledgement by the first list on 6th August. There shall be an interim order of stay of the order of attachment till the next date of hearing.
137.
Appear for the petitioner, my lord. My lord, I'm challenging the order of the trial court wherein they've rejected my application under order 16 rule 6, my lord. My lord,
Petitioner to serve on the counsel who represents the, they are contesting
my lord, all the defendant
the
one and
defendants before the concerned court and file an acknowledgement by the 1st of August. In the event acknowledgement of service would not be filed, the interim order now granted would stand automatically vacated. Subject to the aforesaid, there shall be an interim order of stay of further proceedings before the concerned court.
My lord,
List.
if I may also be granted the liberty to file on the trial court advocates as well, my lord.
ಅದನ್ನೇ ಹೇಳಿದ್ದು sir.
My
Concerned court ಅಂದ್ರೆ ಅದೇನೆ. Yes, list the matter on 20th.
much obliged.
Yes.
138.
Without complying.
12A.
12A, my lords.
Interim order ಕೊಟ್ಟಿದ್ದಾರಾ?
My lords.
ಏನಂತ
Suit has to be
ಕೊಟ್ಟಿದ್ದಾರೆ?
dismissed. ಅದು Supreme Court, Honorable Apex Court.
I know, sir. Interim order ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೇಳಿ sir.
39
That Apex Court also is distinct with Dhanbad fuels ಅಲ್ಲಿ Supreme Court says urgent iದ್ರೆ ಕೊಡ್ಬೋದು ಅಂತ. Where is the urgency pleaded?
And they have not pleaded any urgency. Only for the recovery of rent between agreement as well between the parties.
The petitioner is before this court calling in question the interim order granted by the concerned court without complying with the mandate of section 12A of the Commercial Codes Act. In the light of the said submission, the interim order so granted and the further proceedings in Commercial OS 202 of 2024 shall remain stayed. Yes, next. Emergent notice to the respondents returnable by the 3rd September.
39.
Since a false affidavit was filed, my lord, we filed an application.
Kept in abeyance.
Kept in abeyance.
Ah.
This honorable court says, my lord, that has to be heard at the earliest, my lord. It cannot be kept in abeyance. That is what this court says. Because it,
ಆಯ್ತು, will direct the court to hear.
yes, my lord, that is.
ಅಷ್ಟೇ.
ಯಾಕಂದ್ರೆ now they file an application for recalling and they want to cover up whatever false affidavit has been filed. Before that, my lord, the application had to be considered.
Disposed ಅಷ್ಟೇ.
With the direction, my lord, to.
With the ಅಲ್ಲ ಒಂದು ನಿಮಿಷ. ಮಧ್ಯಾಹ್ನ ಮಾಡ್ಲಾ?
ಅಲ್ಲ, ಈ judgment ಪ್ರಕಾರ ತಾವು.
ಕೊಡಿ.
Court says, my lord, at the earliest it has to be disposed. It cannot be kept in abeyance.
ಇದು ಕಮರ್ಷಿಯಲ್ ಓಎಸ್ದೇನಾ?
Yes, ma'am.
The petitioner is before this court seeking the following prayer. ಇದೇನ್ ಪರ್ಜುರಿ ಇದ್ದಂಗೆ?
Perjury.
ಇಲ್ಲ ಅದೇನಾ?
Allah, now they had filed an application under 39(2)(a). In that, my lord, evidence was led. The evidence, my lord, they gave a false affidavit was filed. We filed an application, my lord, saying perjury. That application, my lord, has been kept in abeyance.
The petitioner is before this court seeking the following prayer. Heard the learned counsel Bipin Hegde appearing for the petitioner. For the prayer that is sought, the notice to respondents would not become necessary. The learned counsel for the petitioner places reliance upon the judgment rendered by the coordinate bench. The coordinate bench is held as follows. The petitioner projects an identical circumstance where he has filed an application seeking order on perjury, and that is kept in abeyance and further proceedings are taken forward. In the light of the judgment of the coordinate bench, I deem it appropriate to direct the concerned court to at the outset answer the application filed by the petitioner, which has now been kept in abeyance at any rate within 3 weeks from the date of receipt of the copy of the order, in accordance with law, after granting opportunity of hearing to the respondents.
140.
Before the order of notices,
The petitioner shall serve on the counsel who represents the.
My apologies. Appearing for the petitioner, Manoj.
You have 140?
140 Manoj.
You are the 140? Correct. Gaurav.
Please.
ನೀವು ಯಾವ್ದು? It's not yet 140. Serial number 140 no alla. The petitioner is before this court calling in question an order passed by the first appellate court in MA 4 of 2025, which upturns the order of injunction granted by the trial court in OS 25 of 2023. In the light of so and so, there shall be an interim order of stay of the order of the first appellate court. Emergent notice to the respondent. Yes, next.
141.
Are you the owner?
I'm the owner.
Nothing doing.
Insurance
Yes.
was lapsed. My lord, both are one is a mechanic, one is a worker at a coffee
Nothing
plantation.
doing.
My lord, there was a talk of settlement also. And
I will adjourn it.
5 lakh was.
I will adjourn it. Talk of settlement gets concluded, you move the
At least
matter.
if he gets some money, even the injured, the LRs of the deceased will get some money that would have been realized. He
We'll
had
see.
offered 5 lakh rupees. Any
Notice to the respondents.
Dates may be given, my lord, so that.
Returnable by the 10th of September.
Obliged.
142.
the notice could be ordered to the.
ಆಯ್ತು 8 to 18.
8 to 18.
Why?
Lord, among the 8 to 18, 3 were the purchases earlier to filing of the suit.
Necessary parties, all right.
And others were immediately after the institution of the suit,
Not necessary parties.
taking notice of the fact that they are first wife children who are the petitioners herein filed the suit for partition.
Who is the, you serve on, it is allowed now, right?
No, it is nipped in the bud itself.
Nipped in the bud, rightly so. 3 matra, only 3 entry. But persons who have purchased during the pendency of the suit only in FDP, not PD.
In fact, they could have been heard in the matter.
No, sir. If you have purchased it from the parties in the partition suit, you can come only in the FDP.
Very true. But now, what is the progress that they are doing is,
No,
those who are
no
purchased.
poker, sir. Yes. More janake, yes, prior to the suit, we will consider, but not all.
They are 8, 9 and 10, I believe. They
8, 9, 10 ge okay, but not the others. Who is the contesting defendant?
Contesting defendants are the second wife children.
ಆಯ್ತು ಅವ್ರ ಮೇಲೆ ಸರ್ವ್ ಮಾಡಿ
Start
ಬಟ್ ಆ 3 ಜನಕ್ಕೆ ಮಾತ್ರ ಪರ್ಮಿಟ್ ಮಾಡಿ, ಅದರ್ವೈಸ್ ಐ ವಿಲ್ ನಾಟ್.
ಆಯ್ತು ಸರ್ ಮಾಡ್ತೀನಿ ನಾನು.
Defendants 2, 3 and 4.
ಹೌದು.
The petitioner shall serve on the counsel representing the defendants 1 to 8 before the concerned court. List the matter on 13th August.
143.
I prefer petitioner.
Same properties?
Same property, one and the same properties.
Same
they
property.
file,
The
even
petitioner is before this court calling in question institution of a subsequent final decree proceedings of the same properties that was subject matter of the earlier final decree proceedings. In that light, there shall be an interim order of stay as prayed for. But
only.
there can be any number of FDs and PDs, sir.
It can
Matte?
be, but
Yes,
adre
but
ಏನಾಗಿದೆ?
same property anta ಮಾಡ್ತಾರೆ.
Same property.
So and so, list the matter on 3rd September.
And a notice to respondent 2 to 5 may be dispensed because they are not
Two,
contesting.
madam, 2 to 5. Accept kota, madam.
Only 1 and 6.
Accepting the memo dispensed with at the risk of the petition.
My
Next.
lord, serial number 141, the final order may be may deferred so that any settlement in this court, it will be very grateful.
You are the owners. Leave it,
Owners.
please.
144.
The petitioner is before this court calling in question an order dated, order dated so and so rejecting the app 31/1/2025, rejecting the application filed by the petitioner seeking amendment under order 6 rule 17 of the CPC. A perusal at the application so filed and its and the content would prima facie indicate that the application ought to have been allowed. In that light, there shall be an interim order of stay of further proceedings. Petitioner shall serve on the counsel who represents the defendants before the concerned court and file an acknowledgement by the 1st of August.
1/1/2025. Date of order.
ಆಗ್ಲೇ ಡಿಕ್ಟೇಟ್ ಮಾಡಾಯ್ತು, ಈಗ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ತುಂಬಾ ಲೇಟ್. ಎಸ್.
45.
ಅಟ್ಲೀಸ್ಟ್ ಅದಾರು ಹೇಳ್ಬೇಕು ಅಂತ ಅಷ್ಟೇ. 2020 suit, sir.
But only one
And
dependent,
disposal.
ನಮ್ಮ brother no purchasers. No purchaser, my brother ಒಬ್ರೇ ಇರೋದು. And section 8 ಅಲ್ಲಿ no ಇದು admitted fact that it's a joint family property. ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
Partition suit.
Please, no purchasers ಯಾರು ಇಲ್ಲ.
ಪರವಾಗಿಲ್ಲ.
Only
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಎಲ್ಲಿ ಮುಗಿಯಲ್ಲ ಸರ್.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಬೇರೆ purchaser ಇದ್ರೆ ಲಾರ್ಡ್, ಇದ್ರ only one ಲಾರ್ಡ್. My brother is unnecessary prolonging it. Section 8 ನಮ್ಮ fatherದು self acquired property. But that is only the reason I request.
ತಗೊಳ್ಳಿ. List the matter on
Lord,
ಒಂದ್ ನಿಮಿಷ 13th ಒಂದ್ ಸ್ವಲ್ಪ ದಿನ ಆಗ್ಲಿ, ಆಮೇಲೆ ಕೊಡು.
Fresh matter.
In preliminary hearing.
146.
39 1 and 2 not granted.
My lords, not to.
Injunction not granted.
Not granted.
Are they represented now?
No, not yet, my lords, in the trial court, not yet.
What's the suit for?
My lords, the suit is for ejectment. I have filed 2 applications. One is not to hand over the property to the third parties. Other one is regarding the deposit of the rent. At least
Deposit
not to,
of the rent I will not
no,
grant.
please, my lords, not to hand over is
Heard the
sufficient.
learned senior counsel M. B. Nargund appearing for the petitioner. The petitioner is before this court on the act of the concerned court not considering grant of temporary injunction. In the light of the averments in the petition, I deem it appropriate to direct that the defendant shall not hand over the property or create third-party rights by Insofar as other prayer is concerned, the same would be considered after the appearance. Emergent notice returnable by 3rd September.
147.
Partition suit among.
ಆಯ್ತು 2011 suit na 2024 recalling 13 ವರ್ಷ ಆದ್ಮೇಲೆ.
I understand that. What happened is her husband, my lord, sustained injury in road traffic accident. He took treatment almost 2 years. My lord, her advocate did not, my lord, cross-examine. And he didn't even inform me about this order. My lord, now it is posted
Serve on
for
the
my
respondent.
evidence.
The petitioner to serve on the counsel representing the respondent in the trial proceedings and file an acknowledgement to that effect. List on 6th.
148.
It's posted.
No. 6th, yes.
The reference proceedings, my lord, under section 3H.
ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ?
R5, my lord, is ought to be impleaded, my lord, claiming independent title. In reference proceedings, my lord, scope of reference is
Correct.
limited.
Yaar sir?
Notice for R5.
Who are you? Now impleading application is allowed.
Allowed, my lord, by the improved order next year.
File. Learned counsel so and so undertakes to enter appearance for the fifth respondent. Mahaswamigalu. LAC proceedings, huh?
LAC proceedings.
So and so.
He claims to be.
Oh, ನೀವು Mahaswamigale. All right, ಬಿಡಿ. Yes. The learned counsel undertakes to enter so and so and would seek time to file a statement of objections. A petition counsel for the petitioner shall serve a set of papers upon the counsel for the fifth respondent. The tussle is with regard to the compensation in a land acquisition proceedings. Till the next date, there shall be an interim order of stay of the impugned order. List the matter on 20th.
149.
We are for petitioner in this case, my lord.
You are for petitioner. Dispute between two wives, huh?
No, no, my lord.
Two children.
Dispute between wife and the deceased brother.
Oh.
Deceased brother. Father has filed the suit. During the pendency of the suit, he has expired. Thereafter, though, even though this, the other children of the Chandrappa has not no legal.
ಆಯ್ತು ಈಗ ಏನ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟೇ ಆದ್ರೆ ಉಪಯೋಗ ಇಲ್ಲ. ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದಕ್ಕಲ್ಲ, ಅರ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಗೆ ಒಂದು ಡೈರೆಕ್ಟ್
ಬೇಕಾಗಿರೋದು ಅಷ್ಟೇನೆ.
ಅರ್ಲಿ ಡಿಸ್ಪೋಸಲ್.
ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನೀವೇ ಸ್ಟೇ ತಗೊಂಡ್ರೆ ನಿಮಗೆ ಉಪಯೋಗ.
There is a
ಆಯ್ತು 6 months.
short issue, lord.
4
months.
months.
The petitioner and the children of the class 1 here.
3 months. They disposed. The petitioner, the petition is allowed. The concerned court is operative portion ಮಾತ್ರ ಬರ್ಕೊಳ್ಳಿ. The concerned court is directed to dispose the subject proceedings with an outer limit of 3 months, if not earlier. Yes.
Please, plaintiff's writ petition.
Correct, sir. 2007 suit, why do you want it to be recalled now?
I am not seeking for
Then
recalling,
who
my lord.
says?
It is the defendant.
Permitted, is it?
See, defendant.
That is permitted.
My lord, yes, my lord. Recalling is allowed after the case has been posted for judgment.
1 minute. The petitioner to serve on the counsel for the defendants before the concerned court and file an acknowledgement. The application seeking recall of?
Recall to file lead evidence.
Recall, application seeking recalling of particular order and permitting to lead evidence comes to be allowed after 18 years of after 17 years of the said order. Without 17 said order. In that light, there shall be an interim order of stay of the said order dated so and so. Date of the date
27/6, man.
27/6/2025. It is made clear the proceedings before the concerned court are not stayed. Next.
List number 2, preliminary hearing, seal number 1.
Ex parte assessment.
Correct, 144 order, yes.
Manoj, I appear for the respondent here.
Tirumalesh sir.
Yes,
Well,
sir.
Ravi Raja ಅವರ ಯಾರಿದ್ದೀರಾ?
I am for the respondent here.
Learned counsel, initial sir.
M. Tirumalesh, M.
M. Tirumalesh is directed to accepts notice for respondent, all three.
Yes, yes.
All the respondent registry to print the name of so and so is appearing for the respondent. ಯಾವತ್ತು ಇದು ರವಿರಾಜ್ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವತ್ತು ತಗೋಬೇಕು? ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಯಾವತ್ತಿದೆ?
ಅದೇ ಅಲ್ಲಿ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ. ವಿಲ್ ಗೆಟ್ ಬ್ಯಾಕ್.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಬುಧವಾರ ಇದೆ.
ಬುಧವಾರ?
ಇಲ್ಲಿ.
ಸರಿ, ನಾವು ಗುರುವಾರ ತಗೊಳ್ಳುವ.
ಗುರುವಾರ ಧಾರವಾಡದಲ್ಲಿ ತಗೊಳ್ಬಹುದು ಮೋಸ್ಟ್ಲಿ.
ಅಯ್ಯೋ, ಆತರ ಆದ್ರೆ ತಗೊಳಕ್ಕೆ ಆಗಲ್ಲ. ಧಾರವಾಡದಲ್ಲಿ ನೀವು ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡೇ ಅಪಿಯರ್ ಆಗ್ಬೋದು.
ಅಲ್ಲ, ಟ್ಯೂಸ್ಡೇ ಮಾಡಿ ಅಂತ.
Whatever, Thursday, Thursday is fine. List the matter on Thursday, 21st August.
This matter, my lord, R3 I'll take notice.
ಯಾವ್ದ್ರಲ್ಲಿ? Central Board.
ಅಲ್ಲ, Principal Commissioner, Bangalore 1.
R1 and 2 M. Tirumalesh. R3 Y, what Raviraj? Y?
YV Raviraj.
YV Raviraj. Yes, list on 21st. So Thursdays are tax days. I'm not going to change it. Yes. You make arrangements however you want.
Number 2.
Petitioner, my lord. Short but direction, my lord, consider the representation, my lord. My lord.
Sir, tax list idu.
Yes, madam. Tax matter.
Your
Number the page.
Pradyumna. Name change ಮಾಡ್ಕೊಂಡ್ರ? Yes.
Lordship, demand here
Either service tax demand beyond limitation.
beyond limitation, part of the beyond limitation, Lordship, and is based on income tax returns and financial records.
Yes.
It's a covered
Yes,
decision, Lordship.
Neralgi.
Let, just
The counsel Jeevan Neralgi is directed to accept notice for respondent 1, 2, ಎಲ್ಲರಿಗುನಾ? For the respondents. But registry to print the name of Jeevan Neralgi as appearing for the respondent. Yes, sir. Limitation 1 ವರ್ಷ, extendable 5 ವರ್ಷ, ಆಗಿರೋದು 7 ವರ್ಷ ಆದ ಮೇಲೆ. Anything else?
There is a suppression, my lord, it is a 5 years.
ಅದಾದ್ಮೇಲೆ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ಮೇಲೆ ವೇಕೆಟ್ ಮಾಡಬೇಕಾರೆ. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the demand of service tax for the years 2014, 15 and 15, 16, up to 17, 18 is beyond limitation. In that light, there shall be an interim order of stay till the filing of the statement of objections by the respondent. ಯಾವತ್ತು ಹಾಕ್ಲಿ? List the matter on 4th September. ಅಲ್ಲ 4th ಅಲ್ಲ, Thursday na 4th. Yes, 4th September. Jeevan sir, ಎಲ್ಲ 4th ಎಲ್ಲ Thursdays ಇರುತ್ತೆ. All tax. Yes.
Number 3.
Plus GST matter.
Correct. Show cause notice. Reply ಮಾಡಿ.
ಮಾಡಿದ್ವಿ. Plus in this
Suppression is the ground.
order has also been passed. I'm on a short point.
Ah.
It involves bunching of various assessment years under one show cause notice which.
Individual ಆಗಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
Yes, sir.
Bunching of a
ನೀವು ಯಾರಿಗೆ?
And for Union of India matter.
Union.
My lord, bunching of this show cause notice that issues before the division bench.
But anyway,
This
see,
honorable
you
court has held
you
it-
can't club everybody's case and issue a show cause. There are the result is what? Some penalty. If penalty is to be imposed, individual notices should be given. When ಕಷ್ಟನ ಅದು?
ಅಲ್ಲ ಅದೇನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಈಚ್ ಟ್ಯಾಕ್ಸ್ ಪೀರಿಯಡ್ ಅಂತ ಹೇಳ್ತಾರೆ, ನಮ್ಮಲ್ಲಿ ಅಸೆಸ್ಮೆಂಟ್ ಇಯರ್ ಇಲ್ಲ, ಫೈನಾನ್ಷಿಯಲ್ ಇಯರ್ ಅಂತ ಇಲ್ಲ.
Correct.
They say it is a tax period.
Oh, taxable year.
Tax period ಅಂತ ಹೇಳ್ತಾರೆ. Tax period is my lord, under the provisions of the act is 1 per month, 1 month, 1 calendar month.
Oh, 1 calendar.
It is a better case.
Then
for
ಆ ತರ
ಹಾಗಾದ್ರೆ ಇನ್ನೂ ವರ್ಷ.
ನಾವು ಕೆಲಸನೇ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಕೆಲಸನೇ ಮಾಡಕ್ ಆಗಲ್ಲ. You should devise some method there, sir.
So
if the penalty is being imposed, then you can't do it. Club every 100 people's case at one stroke and
they
issue a
have-
common show cause notice.
They have clubbed the my lord the years, financial years.
That we'll see.
That's the my lord.
ಏನು judgment ಆ?
Covered by.
ಅದು ಚಾಲೆಂಜ್ ಆಗಿದೆ ಅಂತ.
We'll follow this and close this ಬೇಕಾದ್ರೆ. ಅಲ್ಲೇ ತಗೊಂಡೋಗ್ಬಿಡಿ ಇದನ್ನು.
ಒಂದ್ ಸ್ವಲ್ಪ ಇಟ್ರೆ ಒಳ್ಳೇದು.
ಇಟ್ರೆ ಹಂಗಾರೆ ಸ್ಟೇ ಕೊಟ್ಟಿರ್ತೀವಿ. Yes. The learned counsel
ನೋಡೋಣ
appearing.
ಏನಾಗುತ್ತೆ ಅಂತ.
The learned counsel appearing for the petitioner submits that the issue in the list stands answered by 2 judgments of the coordinate bench in so and so. The learned counsel, Jeevan Neralgi, representing the revenue, would submit that the said judgments are pending consideration at the hands of the division bench. Stay ಇದೆಯಲ್ಲಿ?
ಇಲ್ಲ
There, but there is no interim order of stay. In that light, either dispose it or stay it. In that light, further there shall be an interim order as prayed for, subject to the outcome of the writ appeal. Number, madam. Subject to the outcome of the writ appeal, so and so. Counsel Jeevan Neralgi is directed to accept notice for the respondent. Registry to print the name of Jeevan Neralgi as appearing for the respondent. Next.
Great.
4.
For the petitioner, my lord.
Reimbursement.
Yes.
ಸತ್ಯನಾರಾಯಣ ಇವೇನಾ? ನಿಮ್ದೇ ತಾನೇ ಕೇಸು? Refund of GST ಯಾರ್?
I appeal for the.
Learned counsel.
Take notice, my lord.
Your name, madam?
Jyoti M. Maradi.
Jyoti M.
Maradi.
Maradi. Sorry, first day ಅಲ್ವಾ ಗೊತ್ತಿಲ್ಲ ನಂಗೆ ಅದಕ್ಕೆ.
Sorry.
Learned counsel Jyoti M. Maradi is directed to accept notice for
HCP.
HCGP na?
Yes, ma'am.
Oh, sorry, madam. Yes. State ga?
State.
Learned counsel, learned HCGP is directed to accept notice for the first respondent. Case Bhimaya for respondents 2 and 3. list the matter on 21st.
Along with my lord, three matter.
Kodi, numbers. Refund of GST.
WP number 1343/2025.
Speech bada, barcodis. Yes.
Well, item 5, Malaj, I have a copy for the petition in this matter. Whereas order under 129, 1B.
Correct.
There was a transaction. I am not even a registered person, my lords. I was sending gold bars from Bangalore to Mumbai. My own relative, my lords.
Gold bars transported without documents.
My lords, it's my personal gold. There is no sale transaction.
Personal gold. Gold
There
bars
is no-
personal.
Please, my lord, the gold bars belong to me. And my lord, I am not a registered person. I was sending it to my relative in Bombay for preparation.
Gold
of
bars
gift.
relative kodak hogta idra. ಎಷ್ಟು sir?
My lord, the valuation of the gold bars is about 9 lakhs. Now, no, my lord, I have raised three legal contentions for my lord's kind consideration. My lord, no notice is issued to me, no show cause notice is issued to me. My lord, an opportunity of hearing, my lords are aware under section 129, the statute mandates an opportunity of hearing must be given to me. No opportunity has been given to me at all.
Yes.
Now, imposition of penalty.
My lord, alternative remedy is there, my lord. Already in 130,
Kodi.
it is passed. This honorable court order only, it is available, my lord. Maybe let
But
them.
no notice is given to him. It's not a proceeding without my order.
But notice is given, very
giving
much
my
it is
order.
served. They have not at all appeared. They ignored at all. In other
Why are you giving my order, madam? Which is this?
My lord, it is
Other
covered,
consider-
entire
120
detail order, my lord, it is.
Huh?
This order is entire detail order, my lord.
Yes. Oh, who is the proper officer? That's the one, right?
Would my lords permit me to make one submission, my lords?
Yes, sir. This is interpreting 129 itself.
120, my lord, the
129,
impugned
130.
order, the impugned order, which is challenged, my lords, in this writ petition.
No, I have already held that it is appealable because I remember after pronouncement he said it is not appealable under 107.
Please.
And I held it is appealable.
My lords, though there is an appeal provision, my lord, at this point of time, the proceedings are recorded without even giving me an opportunity of being heard.
We'll see. Look into this judgment. Look into this judgment. Sir. Same submissions.
Please.
List the matter. Heard the counsel appearing for the petition. Ajay Kadkol, learned HCGP submits the issue in the list. Stands answered by so and so. The learned counsel seeks time to go through the judgment and make his submissions. Next Thursday, 7th.
Very good. I'm very good. Until such time, would my lords consider grant of the interim order, my lord?
Until Thursday, ಇವತ್ತು ಯಾವ ಡೇಟ್ ಟ್ಯೂಸ್ಡೇ ಅಲ್ಲ ವೆನ್ಸ್ಡೇ ಥರ್ಸ್ಡೇ ಫ್ರೈಡೇ ಸ್ಯಾಟರ್ಡೇ ಸಂಡೇ ಅಷ್ಟೇ ಎಸ್ ನೋ ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಅಂಟಿಲ್ ಥರ್ಸ್ಡೇ ಸ್ಟೇ ಬರ್ಕೊಳಕ್ ಹೋಗಿದ್ರೆ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್
Petitioner, my lords. The petitioner's finance company.
Why illegal conveyance of tobacco? Who has
Respond number 2 and 3, my lords, the owners of the vehicle.
We'll see.
Mortgage to me, my lords, the finance company.
Commercial tax ನೀವಲ್ಲ ಮೇಡಮ್
Yes, my lord, I will.
council learned HCGP 1 2 and 3 ಯಾಕೆ
They were the owners, my lords. I am the.
anyway emergent notice to 2 and 3 list on 21st.
The interim order may be granted, my lords,
No,
not
my
to
lord,
alienate.
it cannot be granted, my lord.
Cannot be.
ಇಲ್ಲ financier is claiming, my lord, owner vehicle ತಗೊಂಡು ಹೋದಾಗ intercept ಮಾಡಿ it is under
And
custody.
the secured creditor, my lords, have
claim
first
and
charge of the
matter on
property.
21st.
He has to
ನೀವು
claim
ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೂ ಕೊಡ್ತಾ ಇರಲಿಲ್ಲ ಎಸ್
7.
My lords, this is a
input tax credit
Yes, refund of input tax
refund of
credit
input tax credit
on
yes.
account of inverted duty structure, my lords.
Yes,
Similar petitions are
Raviraj ನೀವಾ
admitted and pending before this honorable court.
ಜೀವನ್
I'll take notice.
ನೀವೇನಾ
For notice may be issued and tagged, my lords.
ಓ ಇದು ಸ್ಟೇಟ್ ಎಸ್ 1 and 2 HCGP ಕಾಪಿ ಉಂಟಾ
ಇದೆ.
ಇದೆಯಾ ಎಸ್ 21st
Yes, obliged. And it may be tagged, my lords.
ಕೊಡಿ
Connected petitions. Obliged, my lords.
ಅದೇ ಹೇಳಿದ್ದಾರೆ.
8.
Hearing for the petitioner. The matter arises under the Income Tax Act.
correct
We are challenging.
3 notices were issued
139(9) were
Yes.
issued. It was complied with.
Hmm.
In spite of that, my return has not been validated.
Raviraj learned counsel YB Raviraj accepts notice for the respondent petitioner to serve set of papers upon the aforesaid council forthwith. List the matter on 14th August. 14th August, 21st ಬರ್ಲಿ ಬಿಡಿ. Yes.
14th, some inconvenience.
21st.
Please.
Yes.
9.
GST matter.
No, the reverse charge.
My lords, there are two issues here. One is under reverse charge. The second one, my lords, I'm saying is completely exempt by virtue of notification. Their reading of the notification seems to be, my lords, that because the sale and purchase of raw cotton is covered under reverse charge, the GTA services, which is a distinct service altogether for raw cotton, should be treated differently, anta, which I am in disagreement with. My lords, may kindly look at the notification for instance.
Page
93.
93. Page 93.
93.
Ah.
Serial number 21.
The
Right.
Dharwadal have granted stay in identical cases. With same notification.
I'll find out.
Yes.
I'll accept notice. For the first time.
Which is that clause? Yes.
My lords, 93 page number, serial number 21.
21.
21, please. Services provided by a goods
Transport agency by way of goods.
by way of transport of goods of agricultural produce. My lords, in the order at annexure G, page 73, they admit to the fact that, my lords, this is an agricultural produce. But they say it has to be treated on a different footing because the supply, that is the sale and purchase of raw cotton, falls under RCM under 43 of 2017. My lords, what I'm trying to canvass is that there are two distinct services. One is that of sale and purchase of raw cotton, which admittedly
And
falls
transport
under
of
correct.
it becomes agricultural produce while transport.
Please. So I have paid freight charges on GTA, which is not, my lords, part of my sale and purchase.
Well
They are now saying that the exemption should not apply because there is
The
reverse charge. on
petitioner is before this court calling in question the order date, show cause notice,
order, my lords.
the order dated 18/2/2025 by which tax is now claimed contrary to the notification. The learned counsel takes this court through the notification of exemption,
Please, my lords.
notification of exemption dated 28 June 2017, whereby transportation of agricultural produce is exempted from tax. The learned counsel submits that the revenue has obfuscated the issue in imposing in passing the impugned order in as much as the transportation ಹೇಳಿದಲ್ಲ ನೀವು? In as much as the transportation of cotton is declined to be considered to be an agricultural produce for the purpose of exemption. In that light, there shall be an interim order of stay of the order dated 18/2/2025 and all consequential action taken thereto or to be taken thereto till the next date of hearing. The learned counsel, sir?
Hemant Kumar.
Learned counsel Hema Kumar accepts notice for the respondent.
AGA.
Government, AGA, sorry. Counsel, the learned AGA accepts notice for the respondent. List this matter on 28th.
May I also request, my lords, identical matter, second assessment year can also come up on the same date, my lords, 15414.
Barkut. Yes.
Great.
Tag this petition along with source. Next.
10.
Lords,
148.
income tax. Yes, yes, my lords. Similar order has been passed.
Raviraj, notice sir.
I'll take.
Learned counsel YV Raviraj accepts notice for all three to the respondent's registry to print the name of so-and-so is appearing for the respondent. What's your name?
Kirat Singh.
So-and-so appearing for the petitioner submits that in identical cases, the coordinate benches have granted an interim order of stay. Therefore, tag this petition along with so-and-so. The interim order so subsisting in those cases will inure to the benefit of the petitioner. There shall be an interim order of stay in the case at hand as well, as prayed for in the case at hand as well. Tag these petitions so-and-so, list them all on 28th.
11.
Your
28.
Honor, same issue in the other case as well. This serial number 11.
Correct.
Yes.
Same order.
Obliged.
11 also same order. We'll continue, madam. 230. We'll continue at 230.
One small submission. It's a withdrawal. List 3 matter. List 3, serial number 70.
Withdraw ಮಾಡ್ಬೇಕು ಕೊಡಿ.
I've also served the copy to respondent. 70. List 3.
ನೀವು ಇರ್ಲಿಲ್ಲ ಸಾಯಂಕಾಲ. Come at 6 o'clock.
My lords would continue. My lords would continue second list. My lords.
ಯಾಕೆ?
ಅಲ್ಲ 230 matters. So
ನೀವೆಲ್ಲರೂ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ
ಇಲ್ಲ ಇರಿ.
ನಾವಿಲ್ಲೇ
ಟ್ಯಾಕ್ಸ್ ಮುಗಿಸ್ಬಿಟ್ಟೆ ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್.
ಪ್ಲೀಸ್.
Just after 4 weeks. Just after.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 114 ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ನೋಟಿಸ್ ಏನಾಯ್ತು ಮೇಡಮ್? ಏನು ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಅಥವಾ ಏನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ಗೆ?
ನೋಟ್ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್.
ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸಾ? ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಅಂತಿಲ್ವಾ? Court officer?
That works.
Ma'am, are we alone?
Finish it up as a, did you get the latest judgment? What is, I don't know the detail. The overriding effect of the act.
With your lordship kind permission, my lord, serial number, list number 3, serial number 10. Senior Subramanian is on video.
Serious?
Subramanian senior appears. In that case, your lordship on the other day said that 2:30 it should be called, but it is not mentioned in the car list.
ಏನ್ ಬೇಕು?
ಅಲ್ಲ ಅದಕ್ಕೆ ತಾವು ಯಾವಾಗ
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆಮೇಲೆ ತಗೊಂಡು.
List number 1, my lord.
6 o'clock.
ಅಲ್ಲ 4 o'clock ಅಲ್ಲ ಇದು 4 weeks could be reduced next Tuesday.
ಆಯ್ತು, 6 o'clock ಆರ್ಡರ್ ಕೊಡುವ.
Next my lord. Next week.
ಆಯ್ತು, we'll see.
Next Tuesday my lord.
ಆಯ್ತು.
Punishment could be reduced to next week.
5 ಗಂಟೆವರೆಗೆ ಇರಲ್ವಾ?
ಇರ್ತೇನೆ.
ಇರಿ ಮತ್ತೆ. ಕರಿತೀನಿ ಆಮೇಲೆ ಮತ್ತೆ.
Next week.
ಕರಿತೀನಿ ಆಮೇಲೆ ಮತ್ತೆ.
Please.
My lords, one matter for tomorrow, the urgency is this. The execution court attached the property worth 2 crores for recovery of 23 lakhs.
ಕೊಡಿ tomorrow.
My lords, list 3, serial number 53, my lords. There's a slight inconvenience because seniors held up, my lords.
FR ನಂಬರ್ ಬರೋಲ್ಲ ಶ್ರೀಕಂಠೇಗೌಡ ಸರ್. FR ನಂಬರ್ ಇದ್ರೆ ಬರೋಲ್ಲ ಮ್ಯಾಟರ್.
Number.
My lords.
You have to go and comply. FR ನಂಬರ್ ಲಿಸ್ಟ್ ಮಾಡಿಸೋದೇ ಇಲ್ಲ. WP ಆಗ್ಲೇಬೇಕು.
Number
ಮಾಡಿಸಿ.
Number
ಮಾಡಿಸ್ಬಿಟ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿ.
That I have moved this writ petition, this memo on Friday.
For what?
There was another writ petition to the main petition.
ಎಷ್ಟು ಹಾಕಿದ್ದೀರಾ? How many petitions you have filed?
Eradu, my lord. I have submitted, filed.
It's a fresh or pending?
This is fresh, my lord, and it was.
It will come on Monday.
Given me a date on 6th.
Monday. Yes.
There is an existing petition.
ಹಂಗಾರೆ 6th ಬರ್ಲಿ ಕೊಡಿ. Yes.
My lords, list 3, serial number.
We'll grant it, not now. You will, don't worry.
ತಮ್ಮ ಮೆಮೊ ಇದ್ರೆ ಅವರು ತಕ್ಷಣ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಮೆಮೊ ಹೋಗೋದು ಓನ್ಲಿ ಸ್ಕ್ರೂಟಿನಿಗೆ. You should go and do it. Yes.
Lord, list 3, serial number 81, my lord. Lordship had directed the matter to be listed at 4 PM, my lord. It's come in V group. Serial number 81, list 3, my lord. 4 o'clock ಆಗಿ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೂ 4 o'clock ಅಂತ ಇದೆ.
ಪರವಾಗಿಲ್ಲ. We'll see. Yes.
Please.
Continue the list.
List number 2 continue, seal number 12.
Petitioner, madam, is a penalty order which is passed prematurely during the time when the appeal is
pending.
Yes, similar matter.
ಕೊಡಿ.
Page
ಇಲ್ಲ ಇದೆ.
74.
ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ, ಕವರ್.
It is covered, my lords, next week, my lords. I'll take notice.
Covered ಇದ್ರೆ.
It is
Learned counsel, sorry, I forget your name.
My name is Dilip, my lords.
So and so accepts notice for the respondent. The learned counsel for the petitioner submits that the impugned order is passed notwithstanding the pendency of the appeal against the original assessment order. He would submit that the issue in the list stands answered by the judgment rendered by the coordinate bench in writ petition 6164 of 2024. Counsel for the respondent counsel for the respondent seeks a week's time while admitting the fact that it is in fact covered. List the matter next Thursday. Yes. Avat mat time kelbidi. Finish it off. Yes.
13.
Proxy advocate. There is a bereavement in the family of the advocate. Serial number 13, 14 and 40.
13, 14 and
40. Can
all
we post
three
it on
adjourned
14?
to what day? Next week?
14, my lords.
That's a Thursday? Yes. list on 14th. Madam, ಯಾವ್ದು ಅಂದ್ರೆ ಬರ್ಕೊಂಡ್ರ serial numbers 13, 14 and 40. All three list on 14th. Yes.
15.
Who appeals the respondent? Central tax. Yeah, Jeevan Neva. Senate Counsel Jeevan Neralgi accepts notice for the respondents. Petition copy there. Petitioner to serve set of papers upon the aforesaid counsel. That's the matter on 21st. Exemption consider madilla on service tax. Yes.
16.
No notice issued.
No notice. An ex parte order, Lordship.
The petitioner is before this court calling in question an order dated 2023.
23, Lordship. 19/12/2023.
What are you doing till now?
Lordship, order was very recently served. It is seen that
The learned counsel for the petitioner submits that the adjudicating order impugned dated 19/12/2023 was passed ex parte or was passed without issuance of any notice to the petitioner and was recently served with the said order, and therefore the subject petition is preferred. In the light of the said submission is also the admitted fact that no notice was issued to the petitioner, there shall be an interim order of stay of the order and all further proceedings taken there to till the next date of hearing. Commercial tax. Yes, learned HCGP is directed to accept notice for the sole respondent. List on 21st. Yes. Copy, madam?
17.
Have, yes.
Same lot.
17. 17 same. Yes. Notice ಕೊಟ್ಟಿದ್ದೀರಾ? ಹಾ. ಅದಕ್ಕೆ you should now develop.
Page 23,
No. Annamalai sir.
Please, my lord. My lord.
Mute ಮಾಡಿ ಅಲ್ಲಿ. Your case is not yet reached. Yes.
Sorry, my lord.
It's all right. You should develop a system of blue tick. Otherwise, email red receipt ಬರ್ಲೇಬೇಕು. Ilದರೆ nothing is going to happen here. In every case, there will be a statement made that is not served, because email no red receipt will come. Judicial order ಆಗಿದೆಯಾ? ಮತ್ತೆ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಇನ್ನು? Otherwise, you are mushrooming litigation. Maybe, sir, whoever is handling it, should you not? It's by the government of India. There is a judicial order already. We will not reiterate, but we'll have to stay the proceedings until you bring in a system which shows red receipts. He says email is not, have you not received?
not received, Lordship. And only one hearing, Lordship, as per the order. 3 hearings are to be given, one personal hearing.
We will do it. You notice ತಗೊಳ್ಳಿ. ಇದು first day, next week ಎಲ್ಲ we will finish it. Yes, list the matter on 7th August. Learned counsel so and so accepts notice for the respondent, registered to print the name of so and so is appearing for the respondent. The sorry. AGA, learned AGA accepts notice for the respondent. The learned counsel for the petitioner submits that opportunity of hearing as necessary in law is not provided to the petitioner prior to passage of the impugned order. The learned counsel, learned AGA would however seek to defend the action on the score that a electronic mail was communicated to the petitioner, which the learned counsel for the petitioner submits he has not received it nor read it. In that light, there shall be an interim order of stay of further proceedings, stay of the order impugned and further proceedings taken thereto till the next date of hearing. List on 7th August. That day we will finish this. All these remand matters will send it. Some system you have to evolve.
17 to
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? What can be done? See, you should make the system without any loopholes like this. ಅವಾಗೆಲ್ಲ ಆಗುತ್ತೆ ಸರ್. Yes.
18.
Yes,
My apologies, my lord. I could not come
Ah.
personally because of leg fracture, my lord. The fracture
all
in
right,
my.
sir. Constitutional validity
Yes, my lord.
challenge.
Yes, my lord. Please, my lord, it is in respect of 148 notice, my lord. The
Yes.
similar order has been passed by this honorable court, my lord, at
Put it-
page number 193, interim
Add
orders,
this
my
petition
lord.
along with Counsel M. Tirumalesh. ಯಾರಿಗೆ ಎಲ್ಲರಿಗುನಾ?
My lord, respondent 1 and 2, Madan Pillai, my lord, Union of
1
India
and
and Madan Pillai.
Learned DSGI Shanti Bhushan is directed to accept notice for respondent 1 and 2. Tirumalesh for 3 and 4.
All my lords, let it be all.
All.
Rest
All
of
agata?
them. Rest of them.
Rest of them. The remaining respondents, Learned Counsel M. Tirumalesh accepts notice for all the remaining respondents. Registry to print the names of so and so appearing for the respondent. Tag this petition along with the so and so. So and so. In the light of the interim order subsisting in the companion petition, there shall be an interim order as obtaining in the aforesaid case in the case at hand as well. Yes, next.
19.
Yes, madam, no notice issued in this also. Annamalai, you mute your system.
Please, ma'am. Please, ma'am.
That would matter. Tag beda, identical order. State is a formal party. Then who? Central authorities. Learned Counsel Jeevan Neralgi accepts notice for the second respondent, the Learned AGA for the first respondent. Without notice, madidira.
I just verified, my lords, who has passed now.
Yes. 73 proceedings.
Yes, yes.
Without issuance of notice. The order also does not indicate. A summary order.
Lord service. My lord, your lordship's mechanism, ink page number 28.
Lige banni. Yes.
The taxpayer submissions and personal hearing.
Not furnished relevant document.
But he had appeared in that.
Let's see. No representation on behalf of the petitioner. Counsel Jeevan Neralgi is directed to madam. Jeevan Neralgi ಅಂತ ಹೇಳಿದೆ ಅಲ್ವಾ? So and so. No representation by the petitioner ಅಂತ ಮೇಲ್ಗಡೆ ಹಾಕಿ. List on 21st.
Please.
Yes.
20.
My lord,
yes,
in this matter, my lord, the petitioner challenged the order passed on. Yes, my lord, 217 and 1. The identical matter at page number 208, my lord. At interim order at 208, my lord.
One moment, sir. Tag this petition. To tag this petition along with the WP 9039 of page 208, madam. So and so, same order. Yes.
Much obliged.
21.
Same as 11?
Yes, my lords.
11, serial number 11 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ ಮಾಡಿ.
Obliged.
There's two more matters of yours in this.
Another one.
One is it? Serial number?
34, my lords. That is on a different.
Different.
My name may be shown.
There are Learned Counsel M. Tirumalesh accepts notice for the respondent. All respondents? One day. How many respondents?
Yes. Yes, ma'am.
All respondents. Registry to print the name of M. Tirumalesh is appearing for the respondents. Next.
22.
I appear for the petition. It's the GST matter, my lord.
Correct. Input tax.
Input tax. Denial of input tax credit on the ground that the service. Same.
Tribunal is not constituted?
Not at,
Then don't, any action being taken?
not at my lords.
Yes.
Stay
Learn
may be-
it, HCGP, AGA? Huh? That's the general order passed.
My lords, it's because tribunal is not constituted, I am forced to come here. And it is a case where, my lords, non-taxable supply. If my lords see the 4 provisions, what I extracted in the petition, it's a
Since the tribunal is not constituted, the associates are given an opportunity to pay 10% of the additional tax amount. In addition
Pay
to the
10%,
pre-deposit
so
that is
I'll do.
made,
It's all
and they
right.
can only intimate to the authority
learned,
that they'll wait there
you
for
are
the tribunal, HCGP will take.
Learned HCGP accepts notice for respondent 1, 2, 3, all the respondents.
all the.
The learned counsel for the petitioner is before this court on the score that the tribunal before whom the grievance had to be presented is not constituted as on today. In the light of the said fact, there shall be an interim order as prayed for, subject to the condition that subject to the payment of 10% of the additional amount demanded.
Tax.
Additional tax demanded. Yes, till the next, subject to the outcome of the petition.
My lords, may give some time to deposit.
List after 4 weeks. Objections, if any, by the next date. Next.
23.
GST matter, where it is a case of
show cause notice.
bunching of show cause notices for
Has to be
several
stayed.
years.
We have, department has filed several writ appeals. Which
Yes.
are pending adjudication.
We'll stay this also.
Please.
Yes.
Similar order in serial number 3, my lord. This
Serial number?
3, list 2, serial number 3, this morning.
Same order.
Yes,
List 2, serial number 3 tag madi. Same order. I've granted a stay there.
Please,
Same order. Arvind Chavan,
please.
learned counsel Arvind Chavan accepts notice for the respondent. Ellariguna? For all the respondent, registry to print the name of Arvind Chavan as appearing for the petition, respondents. Adadmele tag and pass out. Next.
24.
Please, my lords. Lordship, I want to apologize for appearing online.
That's all right. IGST refund.
Lordship, it's a very simple issue pertaining to a technical glitch in the system. I state exports are not disputed. The IGST scroll is generated 52316 of 23. There is absolutely
no. Yeah, Niva. Learned counsel Jeevan Neralgi customs accepts notice for the respondent, registry to print the name of so and so as appearing for the respondent. The petitioner shall serve set of papers upon learned counsel Jeevan Neralgi, list on 28th.
Lordship, extremely grateful.
Yes. Next.
25.
Remand in this case was raised on the basis of Form 26 as an income tax returns, Lordship. It's covered by
Differential amount.
all the matters
Actually,
are
it's covered. Lordship may have it next week. It's covered by Chinmaya Seva Trust.
We'll take it next week. Learned counsel appearing for the petitioner submits that the issue in the list stands answered by judgment of the coordinate bench, disposing plethora of cases in terms of its order dated 3rd July 2024. The list the matter on 7th Agboda. Counsel Arvind Chavan accepts notice for the respondent, registry to print the name of so and so as appearing for the respondent, list on 7th. We'll close it on 7th.
Yes, please.
Yes. Yes, next.
26.
Appearing for the petitioner.
Where is your claim for refund?
Claim for it is not a. I have filed the return of income. There are certain exempt incomes which I have disclosed. It is only a presentation error which has caused the 143(1) intimation and consequential demand, my lords.
Yes. Jeevan. CBDTR, Nivena.
EA Sanmati.
Yara?
EA Sanmati.
Oh, yes. Learned counsel EA Sanmati is directed to accept notice for respondents, petitioner to serve set of papers upon the aforesaid counsel. We'll list it on 7th. List 7th, list on 21st.
27.
The case, my lord, where the order is passed on a dead person.
Recovery notice.
Sorry, my lord.
Recovery order.
Recovery is issued in the name of the dead sole proprietor. That is at annexure J, my lords.
Yes, sir.
I'll accept notice.
Learned, I forget, Learned AGL.
AG.
AGA accepts notice for the respondent. Counsel for the, where is, the concern is not there at all now?
So it's a sole proprietary concern.
Correct.
Sole proprietor is dead, my lords.
The petitioner,
Legally, it seems to have participated in the proceedings.
we'll see. The petitioner is said to be as a proprietary, sole proprietary, proprietary concern, and the sole proprietor is said to have died during the proceedings. And
Prior to the initiation of the proceedings.
died prior to the initiation of the proceedings, and therefore the order now passed is against a dead person. The entity, the proprietorship concern is also discontinued pursuant to the death of the sole proprietor. In that light, there shall be an interim order as prayed for. The learned counsel, the counsel for the respondent to secure instructions, and learned AGA to secure instructions and make submissions. 28th.
Great.
28.
Same as 25.
Same 73. Yes. 25 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. Arvind Chavan accepts notice. Yes.
29.
Same 73. El Pradyumna.
Please say.
Same order. 29 also same order as the previous, madam.
Same order.
28 ಅಲ್ಲಿ ಏನು ಮಾಡಿದ್ದೀನಿ ಅದನ್ನೇ.
Obliged.
Same Arvind Chavan accepts notice ಅಂತ.
40.
Yes, Mahesh. 1 day delay.
1 day delay. If I filed this appeal, my lord, through by post, my lord, if that date is considered, my lord, it is within time.
Yes, Jeevan. ನೀವೇನಾ?
Central authorities are state authorities.
State GST appeals. Yes, madam.
Central excise.
Central state?
Central excise.
Central excise. ಯಾರು ನೀವಾ? 1 day delay.
My lord, the appellate commissioner may not be having my lord the power to my lord condone the delay beyond 90 days.
We will condone the delays.
90 days.
Technicalities. ಒಂದು ದಿನ. ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ if his calculation is taken.
Now, if he had sent it by post, then my lord,
he dispatch.
No, from the date he receives, not from the date.
We'll see. We'll answer it.
From the date he receives.
But 1 day's delay.
No, 1 day delay. I'm not on that. But the thing is that my lord, he statutorily, my lord, he doesn't have a power to condone the delay beyond the 90 days. That's maybe the reason, my lord, why.
We'll see. We'll post this on Thursday and dispose it next day after tomorrow, madam. Learned counsel Jeevan Neralgi accepts notice for the respondents, registered to print the name of so and so for the respondents list day after tomorrow. Yes, next.
31.
For petitioner, my lord. Copy already Sanmati sir ಗೆ ಸರ್ವ್ ಮಾಡಿದೀವಿ.
ಯಾರಿಗೆ ಮಾಡಿದ್ದೀರಾ?
My lord, ಫೈಲ್ ಮಾಡುವಾಗಲೇ.
I'll take notice on this, my lords.
Sushal Tiwari. Counsel Sushal Tiwari accepts notice. You're also there for the income tax?
Yes,
accepts notice for respondents 1 and 2. Petitioner to serve set of papers upon the aforesaid counsel. Mandamus iradu. Day after tomorrow hakla?
1 week, my lords, because they come back.
List on 7th August. Yes.
32.
Your Lordship, in serial number 32, I'm appearing for the petitioner. The petitioner is challenging the order of the appellate authority. The tribunal
I guess only notice for now.
Your Lordship, 10% I'm willing to pay, Your Lordship.
I'll fix a date, but no stay.
Your Lordship, there is no appellate tribunal constituted, so I cannot even file a statutory appeal.
Adre, the amount 10%.
Yes,
Same
Your Lord,
order.
10% of the tax amount, Your Lordship. I've already paid 10% at the time of filing first appeal.
ಇವಾಗ ಯಾವುದೋ ಕೇಸಲ್ಲಿ ಮಾಡಿದ್ನಲ್ಲ 10%.
Serial number 22, my lord.
22. Same order.
4 weeks time may be given, Your Lordship.
Same order. Yes.
Yes, obliged.
33.
Lordship, for the petitioner, Your Lordship. Your Lordship, in this case, we are challenging the expired assessment order, Your Lordship.
Correct. Covered by
Covered by
orders.
Your Lordships.
Will dispose it or what?
to the stage of 148 AB. my lord.
Whatever, same orders. Go to
There are
page 80 and 80.
86, 85 and 86. Your Lordship.
80 and 85.
My lords, 86, my lords, is relevant. my lords.
86.
Please, my lords.
Yes, Your Lordship, in page number 80,
Sadaಶಿವನಗರ ಇವತ್ತು ಸೇಮ್ ಅವ್ರದಲ್ಲಿ ಬರ್ದಿರೋದಲ್ವಾ ಇದು?
in the previous judgment has sent back to 142 not stage, Your Lordship. But in the page number 86 case, that has been sent to 148 AB notice, Your Lordship.
Which do you want now?
148 AB, Your
My lords,
Lordship.
the first order, my lords, is the regular assessment. The second order, my lords, is a
I
reopening.
want to take notice, we'll see.
Your Lordship, one submission, Your Lordship. The matter which has been disposed, Your Lordship, the assessment of proceedings has been initiated, Your Lordship. There is a tax demand which has to be paid, but there is a bank attachment, Your Lordship. So the bank attachment lifted, we can pick the tax demand for the.
That's the order here.
Your Lordship, annexure K, K1, K2, Your Lordship. Bank
No,
attachment.
no, these judgments consider that issue, bank attachment issue only.
Yes, Your Lordship.
Yes.
Please, my lords.
ಮತ್ತೆ
covered.
ಇನ್ನೇನು?
My lords, your lordships may kindly consider to pass, my lords, the order
ಬೇಕಾದ್ರೆ I'll
at
post it on Thursday.
86.
86 will pass. Yeah, 86 is 148 proceedings.
Yes, yes, Your Lordship.
Please.
148 AB.
Same order will pass. The learned counsel, the petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that that identical issue stands answered by the coordinate bench in page 85, madam. So concerning the very petitioner, the learned counsel for the learned AGN,
Standing counsel.
learned standing counsel, the name?
Dilip.
Dilip so and so accepts notice for the respondent and would submit that the issue indeed stands answered by the judgment rendered by the coordinate bench. The coordinate bench is held as follows. Page 191 to 95. In the light of the issue being answered, the petition stands disposed on the same terms, same order. Last 94-95 lane order ಇದೆ ಅದನ್ನ order ಅಂತ ಮಾಡಿ.
Annexure, my lords, they have to file reply, my lords, to annexure A and A1, my lords.
ಇಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಸರ್?
My lords, in that also, my lords, the same.
Same thing. ಇಲ್ಲಿ annexures
Annexure
A and A1, Your Lordship.
you replace that reply to the notices ಅಂತ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಅದನ್ನ ಬೇರೆ annexure ಇದೆ ಅಲ್ಲಿ A and A1 ಅಂತ ಮಾಡಿ. Yes.
Lordship, annexure H, J and K2, K2, K3, Your Lordship, may be questioned.
ಮಾಡ್ತಾರೆ.
Oblige, Your Lordships.
34.
This is 148.
No, my lord. No, my lord. So tax matter, my lord. So
Yes.
yeah, in this, the district valuation officer has passed a final valuation report and has not given effective opportunity of hearing to the petitioner.
An effective opportunity.
My
How
lord,
is it defective?
my lord, he is given an opportunity, but he has passed the final rectification. Sorry. Final value.
I'll take notice, my lords.
My lords, what has happened is, they have issued the preliminary report on 8th of April 2025. They have given us 7 days. That is 15th of, I had time till 15th of April to file the objections against that. Now, I have received that notice only on 16th of April. And I have enclosed the consignment.
It's 15th of April of
This year,
2025.
2025, my lords. And the order is passed on 15th of April. I didn't have time.
Petitioner is before this court calling in question an order dated 15/4/2024. Against the final valuation report, the petitioner has an opportunity of submitting his objections.
Yes, my lords. My lords,
The
it's
objections had to be submitted before 15/4/2024.
or before 15/4/2025. On or before 15/4/2025.
On or before 15/4/2024. But
25,
the
my
notice of such, the notice of the final assessment report itself reaches the petitioner on 16/4/2024.
Preliminary valuation report, my lords.
ಅದು final assessment ಬೇಡ, preliminary valuation report. The preliminary valuation report on the score that the petitioner has not submitted his objections has resulted in the final assessment report that is challenged in the subject petition.
Final
Valuation report that is challenged in the subject petition. The prima facie, the petitioner did not have an opportunity to submit his objections, or the objection submitted was not considered before the final valuation report, as the notice itself reaches after the passage of the report. In that light, there shall be an interim order of stay as spread for till The next date of hearing, list on 28th.
My lords, it is 18/4/2025.
What order?
Yes, my lords.
Final valuation
Not,
report.
15/4/2025.
That's what I have said.
Yes, yes, my lords. Somewhere it was mentioned 2024. That is
25.
Yes,
Every,
yes, my
madam,
lords.
24 ಯಾವ್ದಿಲ್ಲ, ಎಲ್ಲ 25. Yes.
Obliged, my lords.
Yes.
35.
Appearing for the petitioner.
Same,
Petitioner is a
This is
charitable institution.
ah?
10B report has been filed belatedly.
Exemption.
exemption. They has filed a application seeking condonation. Well, they have rejected. I'll take instruction. Lordship may have it on 14th.
We'll take it on 14th. The Council Arvind Chavan accepts notice for
1 to
the all respondents,
All CPC and
all the
exemption.
respondents. Register to print the name of Arvind Chavan as appearing for the respondent. List on 14th.
14th.
List on 14th. We'll dispose it.
Please,
Yes.
36, the petitioner is eligible for claiming deduction under section 80IA4. A 10 CCB report was filed belatedly.
You are an
41 days of
intermediary? You are an intermediary?
No, my lord.
No, no, yes. Infratech, all right, yes, yes.
I'm an intermediary.
That's what I said, yes. Is again exemption.
80IA4.
Yes.
My first time, my lords.
Learned Counsel Sushal Tiwari accepts notice for respondent, all the respondents. Register to print the name of Sushal Tiwari as appearing for the respondents. Same, 21st. Yes. Next.
37.
My lord, in this matter, the petitioner challenger 148 notice, my lord, the similar order for the earlier year at page
Adhe,
number
ellida?
212, my lord.
Which page, sir?
212, my lord. 212, my lord. Earlier year, my lord. 212, my lord.
Right, 212. Same, madam, 212. Illa ಇದೆ. Tag this petition along with 19658 of 2024. ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಸೇಮ್ ಆರ್ಡರ್. ನೋಟಿಸ್ ತಿರುಮಲೇಶ್ ನೀವಾ ದಿಲೀಪ?
I'll take for 3, my lords, 1 and 2, my lords.
1 and 2 M Tirumalesh, 3 Dilip. List on 28th. 28th, madam. List on 4th September.
38.
Yes, sir.
There is circular, my lord, which is permitted for me to.
Exemption.
It's not exemption, my lord. 10% of the paid deposited amount.
Appeal is dismissed as he paid the 10% deposit by debiting into the electronic credit ledger.
Credit ledger, not.
ಹೆಂಗ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
Cash ಅಲ್ಲಿ ಕೊಡ್ಬೇಕು ಅಂತ.
Cash.
See, that is the technical objection which has been taken by the appellate authority. So he interprets the provisions of section 49 and says that electronic credit ledger, that it can be utilized only for the purpose of payment of an output tax, not the pre-deposit.
So ಇದು ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಡಬೇಕಾಗಿತ್ತು.
Separate ಆಗಿ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು.
ಸಪರೇಟ್ ಆಗಿ ಹೆಂಗೆ ಕ್ಯಾಶ್?
ಚಲಾನ್ ತಗೊಂಡು ಇದು ಮಾಡಿ.
ಓ ಆತರ ಕನ್ವೆನ್ಷನಲ್ ವೇ.
Cash ledger and credit ledger.
ಆಯ್ತು, ಕನ್ವೆನ್ಷನಲ್ ವೇ.
ಎಲ್ಲ conventional way, or my lord, there is an electronic cash ledger through which he.
But ಈಗ ನಿಮಗೆ 10% ಬಂದಿದೆ, ಎಲೆಕ್ಟ್ರಾನಿಕ್ ವೇ ಅಲ್ಲಿ ಬಂದಿದೆ ಅಷ್ಟೇ.
That's all. That's.
ಬಂದಿಲ್ಲದೆ ಇದ್ರೆ
ಅಲ್ಲ, just one, my lord, one ಅದೇನೋ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇದೆ, just I'll see it day after tomorrow, your lordship.
ಆಯ್ತು. Counsel Jeevan Neralgi accepts notice for the respondent. Register to print the name of so and so is appearing for the respondent day after tomorrow.
Please.
And plenary hearing. Yes.
39.
I'm appealing for the petitioners, my lord. But there's a case where the show cause notices at annexure B is dated 22/1/2024, my lord. The show cause notice gets issued based on the circular which is issued by the CBIC extending the time limit for
168A.
168A read with rule notification 56 of 2023.
All
Courts
right.
have already granted.
Could it. Tag this petition along with so and so. Same order. Jeevan Neralgi accepts notice for respondents.
This is the state, my lord. This
State ಇದೆಯಾ?
Yes.
Union of India.
Union.
Oh, state ಒಂದಿದೆ. One minute.
R1 and
Learned HCGP. ಒಂದು ನಿಮಿಷ. HCGP 3 and 4 ನೀವು ಇರ್ಬೇಕು ಮೇಡಮ್. CTO state.
This Supreme Court ಅಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
Admit ಆಗಿದೆಯಾ?
ಇದು
ನಾವು admit ಮಾಡೋಣ.
maybe pending so many matters, my lord. With
Correct.
regard to notification is concerned.
ಆಯ್ತು. Yes.
Previous matter,
Tag this petition along with so and so. Same order.
previous matter, 38 ಅಲ್ಲಿ,
Hmm.
I think my learner friend has to make other two persons also parties. Commissioner appeals ಮಾತ್ರ party ಮಾಡಿದ್ದಾರೆ. He is being an quasi judicial authority. Commissioner, concerned jurisdictional commissioner and officer, he has to make.
ಮಾಡ್ತೀರಾ?
I should oral permit.
Learned Counsel, 38 and ಬರ್ಕೊಳ್ಳಿ madam. Learned Counsel for the petitioner seeks leave of this court to implead the other officers of the other department, jurisdictional officers of the income tax department. Income tax, huh?
ಅಲ್ಲ sir, GST.
Of the GST. Permission so sought is granted. ಈಗಲೇ ಮಾಡಿ. ಅದಕ್ಕೂ ನೀವೇ ತಗೊಂತೀರಲ್ಲ? ಜೀವನ್ ಅಲ್ಲಿ ಅದಾದ್ಮೇಲೆ ಜೀವನ್ ನೇರಳ್ಗೆ accepts notice for the said respondents. Next.
40 urgent 41.
ಯಾರು ಇಲ್ಲ ಅಂತ 7th list on 7th.
41. I'm appearing to the petition.
ಮತ್ತೆ
My lord, 40 he was,
40 ಅಡ್ಜನ್ ಆಗಿದೆ 41.
my lord, they have challenged the show cause notice, my lord. The show cause notice is one page. It doesn't provide for any charge at all. It only refers to the inspection report and makes a notice. I have not been provided a hearing also in this matter. The order gets to be passed.
You have not submitted your reply?
My lord, no hearing was granted. Order get to be passed. I have not submitted my reply. I have submitted reply earlier.
Yes, commercial tax.
I'll accept notice for respondent.
Learned AG accepts notice for the respondent. Yes, he says, copy idea? No notice?
I'll get instructions. ಮುಂದಿನ ವಾರ ಹಾಕೊಂಡ್ರೆ.
ಆಯ್ತು. List on 7th. List on 7th will grant or dispose, whatever. No notice andre will send it back. Sidanand, previous matter ಯಾವ್ದು? ಟ್ಯಾಗ್ ಮಾಡಬೇಕಾಗಿರೋದು ಯಾವ್ದು ಅದು ಕೊಡಿ.
I'll get
ಕವರ್ಡ್ ಅಲ್ಲ.
I'll get
Yes.
38 ಅಲ್ಲಿ ಸುಮ್ಮನೆ add ಮಾಡು.
38 ಅಲ್ಲಿ
add ಮಾಡಬೇಕಾಗಿರೋದು.
ಅದು ಅವ್ರಿಗೆ ಹೇಳಿದೆ ಸಂಪತ್. Yes. Next.
42.
Lordship, this is the second round of litigation here. First round, same Chirmai order, it was remanded of this honorable court, your lordship. Consider the documentary evidence, because the first round, the order was passed on the ground that no documentary evidence was produced.
And now what has happened?
Now I produce all the documents, identical amount, except 4,000-5,000 rupees. Everything is confirmed. The court's directions and limitations are not been considered. Supreme Court judgments are to be followed. That nothing.
All right. Which is that coordinate bench order?
Which
page?
Chirmai. On the question of limitation, your lordship.
Remind ಮಾಡಿದ ಆರ್ಡರ್ ಯಾವುದು ಸರ್?
This is the order, lordship. 1115 for about the.
ಕೊಡಿ ಅದು.
Remand order. This is that on the page number 67, your lordship.
67.
67, annexure B. Order in original. First time it was remanded.
67.
82. Lordship may take 82.
Yes, Sunildat Yadav order.
82.
82 High Court order.
The learned counsel for the petitioner submits that the coordinate bench, in terms of its order dated 18th July 2024, had remitted the matter back to the hands of the concerned court to consider the issue on its merit and pass necessary orders in accordance with law. The allegation now is that the same order, an order which is verbatim similar is passed without considering the purport of why the coordinate bench had directed reconsideration of the issue. In that light, the learned counsel Arvind Chavan accepts notice for both the respondents. Both the respondents registered to print the name of so and so as appearing for the respondents list on 21st. Any problem now? List on 21st. Yes.
43.
The adjudication order under 73, my lord, on the premise that I have wrongly availed ITC, I submitted, my lord, declaration in the form of annexure 4, opting for payment of 18% GST with ITC, which is, my lord, not considered. I produced along with the reply to the show cause notice.
Yes, madam.
Take notice, my lord, the order in 22, serial number 20.
Same order, 22.
Yes, my lord.
Yes.
No, it's
Not constituted, 10%. Yes.
On tax.
On tax, of course, yes. 1, 2, 3. ಎಲ್ಲರಿಗೂ HCGPL. HCGP, madam, 22 ಅಲ್ಲೇ order ಮಾಡಿ. Same order, yes.
44 also similar.
22, 24, ಎಲ್ಲ, yes. Next.
45.
Short matter, my lords, we have made
Short matter.
short point.
Yes, sir.
GST matter, my lords, we have made payment.
GST matters ಎಲ್ಲ short matters.
ಇಲ್ಲ, ಇಲ್ಲ,
ಮತ್ತೆ
sorry.
yes.
My lords, we had filed the return belatedly. Subsequently, a notice was issued for non-filing of returns.
Belated under how much?
My lords, we have filed it almost 7 months beyond, my lords. We have made the tax amount payment.
Have you explained the delay?
No, my lords, it's only, my lords, it's only no proceedings under 73 were initiated.
No, not initiated.
No, it was just non-filing of returns. Subsequently, we have complied. We have now recovery is there, my lords. They are only.
I'll accept notice.
Then a DGA accepts notice for the respondent's registry to print the name of, but accepts notice for the respondent. List on 7th.
Recovery is there, my lords. The accounts have been blocked. The entire
7th
amount
will dispose it, sir.
Great.
Yes.
That is blocked from 2023.
ಅದಕ್ಕೆ we'll dispose it on 7th.
45 and.
It is not blocked yesterday.
Yes,
so yes.
45 and 46 both may be called on 7th.
ಯಾವುದು 45, 46 ಎರಡು 7th. Same order, madam, as 45. 47.
47.
Yes, Pradyumna.
Here, this petition lordship, a demand notice was, show cause notice was issued demanding GST on the landowner's portion of the builder lordship of a joint venture. I filed a comprehensive reply which is contained from page number 13 into 54.
Comprehensive including yours and the landowners.
On behalf of the landowner, and assailing the demand on several grounds, your lordship. I had paid my portion correctly. On the landowner's portion, the value adopted, I had assailed demand. My reply is contained from page number 39 to 54 of the petition, your lordship. My reply has been dismissed on just one line. Your lordship may see on 54, the reply filed by the tax owner is
Yes,
not considered.
learned HCGP is directed to accept notice for the respondents. The learned counsel for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that out of a joint venture between the petitioner and the landowner, the GST was paid. The portion which the petitioner had paid is ignored, or landowner is ignored. Which is one?
Petitioner is a builder, he had paid on his portion, your lordship. Landowner's portion, the joint development.
ಗೊತ್ತಾಯ್ತು. ಈಗ why notice is issued to you?
Notice is issued proposing to tax on the landowner's share.
The notice is issued to the petitioner seeking to show cause as to why the the penalty must not be levied against, tax must not be levied against him on the score of non-payment of the landowner's portion. The learned counsel for the petitioner submits that his explanation is rejected by a one-line order. In that light, there shall be an interim order of stay of the impugned order till the next date of hearing. List on 28th.
Public.
Yes.
48.
Petitioner. What is in challenge here is an order passed under section 264, which is a revision order by the principal commissioner. There are 3 years in question. In the first 2 years, I had admitted to offer to tax certain income. But when I filed the return, I included that in a third.
Let him file his objection. Yes, the learned counsel Dilip is directed to accept notice for respondent 1 and 2. Registry to print the name of so and so is appearing for the respondents. List on 4th September.
Nine.
Your Lordship, in serial number 49, I'm appearing for the petitioner. This is the issue where there's clubbing of show cause notice. Kindly it may be adjourned. The interim order has already been granted, Your Lordship. Interim order ಇದೆ. Interim order has already been granted. ಇದೆ. It is there, Your Lordship. ಹೌದು, Your Lordship.
First time ಬರ್ತಾ ಇರೋದು.
It's been listed in preliminary hearing. B group ಅಲ್ಲಿ ಬರಬೇಕಾಗಿತ್ತು. 16/6/2025 an interim order has been granted.
49.
49 first time ಬರ್ತಾ ಇರೋದು ಮೇಡಮ್.
Your Lordship, clubbing of show cause notices, Your Lordship.
That we will see. You said interim order is already subsisting.
Yes, Your Lordship. 16th June 2025.
Nodi, madam. For the first time listed, madam.
Your Lordship, 16th June 2025, I have received an interim order.
Are you referring to list 3?
Your Lordship, I apologize. Howdo? I apologize. I'm sorry, Your Lordship. I'm sorry.
ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಬಿಡಿ ನಿಮ್ಮ ಕೌಂಟರ್ ಮಾಡಕ್ಕೆ.
I apologize.
We have the petitioner. Yes, list. Learned CGP accepts notice for the respondents. List on 21st. Next.
Same as seal number 25.
25.
On 7th, my lord.
Arvind Chavan accepts notice for the respondents. Registry to print the name of someone. 25 line ಮಾಡಿದ್ದೀನಿ ಅದೇ order.
Yes.
Number 3 order. Seal number 1.
I am for the petitioner, my lordship.
For respondent number 2, my lord.
This
I have
filed
complied the
statement of
office
objections.
objections, my lord.
You complied the office objections. Yes, sir. Pudi madam.
Await report connected matter.
Connected matter, my lordship, I am filing under I localat, my lordship. Connected petition ಅಲ್ಲಿ, my lordship. ಆಮೇಲೆ ಕಾಪಿ ಶುರು ಮಾಡಿದ್ರೆ ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇ ಬಿ ಫೈಲ್ಡ್.
What's the offense?
Offenses are, my lord, section 76, 351 class 2, 351 class 3, 352, 115 of class 2, 119 of class 1, 190 of BNS Act. There is case and counter case, my lord.
Counter case, my lord.
One day,
ಒಂದರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಎರಡರಲ್ಲೂ stay.
ಎರಡರಲ್ಲೂ ಇದೆಯಾ?
ಎರಡರಲ್ಲೂ ಇದೆ.
List on 22nd. Interim order subsisting will continue to the next date of hearing. ಇದು 1.1 ಅಲ್ಲಿ Learned Counsel B. Virupaksha, PH Virupaksha accepts notice for the complainant. Therefore, registry to print the name of so and so as appearing for the complainant. Interim order subsisting in both these cases shall continue till the next date of hearing. List the matter on 22nd.
Petitioner ಕಾಪಿ ಶುರು ಮಾಡಕ. Please.
Number 2.
For the petitioner, please, Your Honor, Your Lordship. Your Lordship, this matter is listed for maintainability.
Correct, sir. GMCPC Act.
The point is that we had filed a application for rejection of plaint before the learned trial
Anyway,
court.
I have granted an interim order.
Yes, my lord.
Office objections, maintainability stands overruled. List the matter on 20th. Interim order subsisting will continue to the next date of hearing. 21st.
Much obliged, my lord.
22nd, sorry, madam. Yes. Next.
Lord, in 3.3.
Tenant matters.
It is not a subtenant. I will argue the matter, my lord. It is not a subtenant. I am 3.3 party in person.
13%.
My office has been taken right by the rich.
10 ವರ್ಷ ಆದ್ಮೇಲೆ
they are not the owner. I will demonstrate with the documentary evidence.
They are not the owner.
They are not the owners. Because the largest
tenant saying they are not the owners.
My lord.
Whom did you enter tenancy with?
Tenancy, my lord, it is entered with the Lakshmi Venkateshwara, where they have also executed the. I will demonstrate with the documentary evidence, my lord, how the fraud has been taken place by the trial court.
ಯಾರು 3 ಅಲ್ಲಿ ಯಾರು
3.3
ಪರ್ಸನ್ ಯಾವುದು
3.3 ಶಿವನ್
3.3 ಯಾರು ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ
ಇಲ್ಲ ನನ್ನ ಐ ಫೈಲ್ಡ್ 14% ಅಪ್ಲಿಕೇಶನ್ಸ್
ಎಲ್ಲಿದೆ
ಐ ಫೈಲ್ಡ್
ಕಮಿಟಿ ಮುಂದೆ ಅಪಿಯರ್ ಆಗಿದೆ
ಐ ಅಪಿಯರ್ ಪರ್ಮಿಷನ್ ಹಸ್ ಬೀನ್ ಗ್ರಾಂಟೆಡ್ yes
registry to delete the name of Sanjay Kumar KN as appearing for the petitioner and retain the name of BN Shivanna and show him
14%
as petitioner in person. Yes.
My lord, it is the case of the respondent that Rajesh Export has purchased the property in the year of 2004. My lord, in the year 2004, the sale deed is very clear. The Manohar who has executed the sale deed in favor of the Rajesh Export.
ನಿಮ್ ಜೊತೆ ಟೆನೆನ್ಸಿ ಯಾರು ಸರ್
ಟೆನೆನ್ಸಿ ಅಲ್ಲ ಅವ್ರ ರೈಟ್ಸ್ ಇಲ್ಲ ನಮ್ಮನ್ನ ಟಚ್ ಮಾಡೋದಕ್ಕೆ ಆಸ್ ಪರ್ ದ ಡಾಕ್ಯುಮೆಂಟರಿ ಎವಿಡೆನ್ಸ್
ಟಚ್ ಮಾಡಕ್ಕೆ ರೈಟ್ಸ್ ಇಲ್ವಾ
ಇಲ್ಲ ವಿ ಆರ್ ಇನ್ ಎ ಸೆಟ್ಲ್ ಪೊಸಿಷನ್ ಫಾರ್ ಮೋರ್ ದನ್ 30 years.
ಈಗ ವಾಟ್ ಇಸ್ ದಿ ಸೂಟ್ ಸೊ ಎಕ್ಸ್ಪರ್ಟಿ
ಆರ್ಡರ್ ವಿತೌಟ್ ಗಿವಿಂಗ್ ಆಪರ್ಚುನಿಟಿ ವಿತೌಟ್ ಮೇಕಿಂಗ್ ಆಸ್ ಎ ಪಾರ್ಟಿ ಆಕ್ಚುಲಿ ದೇ ಹ್ಯಾವ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಎ ಲೀಸ್ ಡೀಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಲಕ್ಷ್ಮೀ ನಾರಾಯಣ ರಾವ್ ಇನ್ ದಿ ಇಯರ್ 1971. Lakshmi Narayan Rao was not party to the proceeding before the trial court. They have made a party as a Lakshmi Venkateshwara.
ಅಲ್ಲ ಅದಾಯ್ತು there is coordinate bench has disposed such petitions and where is that order?
Yes, your lordship. There are around 9 orders.
ಅದಕ್ಕೆ ಏನ್ ಹೇಳ್ತೀರಾ?
ಅವ್ರು ನಾವು ಪಾರ್ಟಿ ಅಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ಲ.
ನೀವು ಪಾರ್ಟಿ ಅಲ್ಲ.
they have given undertaking, those tenants have given undertaking.
One copy.
Undertaking for what?
Undertaking that they were vacated ಅಂತ.
ನೀವು ಕೊಡಲ್ಲ?
ನಾವು ಕೊಟ್ಟಿಲ್ಲ.
Undertaking. It was upon vacation that the settlement came to be executed.
Not between us. Because we are
such
there are
parties
30 advocates who are on the Sujata complex, where without giving opportunity, they brought the decree, they want to evict us.
ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ?
ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
ಅಡ್ವೊಕೇಟ್ಸ್ ಗೆ
ಗೊತ್ತಿಲ್ಲ. For a moment, for my respect to submission, kindly take how fraud has taken place in the sale deed. 1974, Krishna has adopted one Mr. Manohar. In the same year, he has filed a suit. Before adoption itself, how can he file a suit against his own father? At the age of 16. He was a minor as per their own sale deed.
ಅಲ್ಲಿ ನಿಮ್ ಜೊತೆ ಟೆನೆನ್ಸಿ ಅಗ್ರಿಮೆಂಟ್ ಯಾರು ಹೇಳಿ? ಹಿಸ್ಟ್ರಿ
ನಮಗೆ ಟೆನೆನ್ಸಿ ಅಗ್ರಿಮೆಂಟ್ ಈಸ್ ಲಕ್ಷ್ಮೀ ವೆಂಕಟೇಶ್ವರ.
Who is the defendant in the suit?
ಅಲ್ಲ,
defendant in the suit.
Yes, your lordship. His lessor is my tenant, and my tenant is made a defendant in the suit. He is my subtenant.
Lakshmi Narayan Rao was a original lessee who has executed a subtenant to the various subtenants. Lakshmi Narayan Rao was not made a party to the proceeding before the trial court. Lakshmi Narayan Rao has subletted the property in favor of various persons. Kindly see the decree whether Lakshmi Narayan Rao was a party.
We'll see, we'll hear it. List on ಎಲ್ಲ ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ.
They are all connected.
Meanwhile,
ಎಲ್ಲ ಟ್ಯಾಗ್ ಆಗಿದೆಯಾ?
Trial court record is required. A trial court record may kindly
ಕೊಟ್ಟಿದ್ದೇನೆ ನೋಡ್ತಾ. Yes, all these matters, madam. 3.3 to 3.8. 3.8 ಏನು?
3.8, I am for the petitioner.
Same order?
Same order.
We'll hear it.
Let it be taken up on any date. This
We'll
court has the time.
List the matter on 23rd.
Very well. The only point
Post immediate ಎಲ್ಲರಿಗೂ await service. R2 to 8 ಯಾರು? Who's R2 to 8?
they are the notice has been dispensed with. R2
ಅವ್ರು ಹೇಳ್ಬೇಕು.
R2 to 8 they are not required.
Memo ಕೊಡಿ. Counsel for the petitioners, the petitioner in person files a memo seeking dispensation of issuance of notice to respondents 2 to 8 in the light of the memo dispensed with at the risk of the petitioner. List the matter on 23rd. The understanding would be the matter would be heard.
And meanwhile, a trial court record may be called. SC number 2726 of 2000.
Registry to secure the trial court records.
I really don't think, your lordship, it's required.
My lord, why they are opposing?
Yeah, very sir. Why are you getting agitated? Intermodal ilva?
Why they are opposing if they are so?
Oppose ಮಾಡಬಾರದಾ?
ಅಲ್ಲ, if they are fair to the court.
ಅಲ್ಲ ಆಯ್ತು, ಅಪೋಸ್ ಮಾಡಬಾರದಾ?
ಅಲ್ಲ ಮಾಡ್ಲಿ,
ಮತ್ತೆ
ಮಾಡ್ಲಿ.
Only on account of the delay it might.
Wait, it's all right. If it's an ex parte order, we'll see. Yes, list the matter on 23rd. It is, the understanding is that the matter would be heard. It's a working Saturday.
Yes, my lord. SC 2726 of 2011.
ಎಲ್ಲಿ ನಿಮ್ಮ ಫಾರ್ಮ್ ಸಿ ಎಲ್ಲಿದೆ?
Your lordship, 23rd.
ಇಲ್ಲರೆ ಹಿಯರ್ ಮಾಡಲ್ಲ.
Yes.
23rd, I have some inconvenience.
No, working Saturday, be here, no inconvenience.
I'm out of the country on that.
Out of country, engage others. Yes, 23rd. ಇಲ್ಲ ಅಂದ್ರೆ I'll post it on in September, no problem.
Second or third September.
Oh, list on 19th September. Interim order subsisting in all these cases shall continue till the next date of hearing. Interim order wherever is not subsisting shall the benefit of interim order in the companion petition shall inure to those petitions. Yes. ಎಲ್ಲದೇ ಹೇಳಿದ್ನಲ್ಲ ಸರ್.
3.8, 3.6. Right, madam. 4.
Madam.
This is a review petition which is sought to be.
I understand. I just need my senior to make
some. Pass over.
Today, yes.
6 o'clock adru come, pass over. Yes. Get Prasanna Kumar. Yes.
Serial number 5. I appear to the respondent, madam.
CRP ಅಲ್ವಾ? ಅಪ್ಲಿಕೇಶನ್ ಇರುತ್ತೆ ಎಲ್ಲ ಇದ್ರೆ ಮಾಡಿ.
Serial number 5.
I appear for the respondent, my lord.
RP.
My lord,
for day after tomorrow.
My lord, I have one submission, my lord. On the last date, your lordships had already heard the matter.
Correct.
But There's a direction, as your lordships already is aware of. There was a direct order passed on the last date saying that the trial court matter may be deferred till tomorrow. May I at least request it be taken up tomorrow? It's a very short point of law with respect to the review.
List the matter on Friday. The earlier order stands extended till the next date of
My
hearing.
lord, may I request tomorrow?
Yes.
Day after tomorrow, my lord.
Yeah, we'll take it on Friday. Tomorrow also there are 200 matters. Yes. Next. Saravana.
Lords, before senior counsel starts, both senior counsel and the counsel on record is on their legs, my lords.
Both senior counsel and counsel on record. Who are you?
I am proxy counsel, my lord.
Oh, yes.
Lords, a notice requires to be issued on an impleading application. Lords, the
Yaar impleading applicants.
Lords, impleading applicants are those persons to whom the KEDB claims that the compensation which is required to be disbursed has been disbursed in their favor pertaining to the lands in question. That is the submission which they made. Then it fell from the court that you make them also as parties. So that is the reason why we made an application for impleading.
Notice on IA 1 of 2025, returnable by 2nd September. List on 2nd. Interim order subsisting will continue to the next date.
Lordships. Yes.
Office objections illa Swami. Court open court I had furnished the copies.
The LRs of the respondent, my lord. The sole respondent died.
No objection, na?
No objection.
LRs.
LRs.
IA 1 of 25, IA 1 to 3. For the reasons indicated in the affidavit accompanying the application, satisfied with the same. The application stand allowed the respondent, the petitioner shall amend the cause title by bringing in the legal representatives of the respondent. Notice Akbaka?
Illa, notice any sole respondent died.
Of legal representatives of the sole respondent by the next date of hearing. In the applications, office objections?
Office objections.
Even the vacating interim order.
Nandu extension ide Swami. Adrinda it may
We
be heard on
dispose of
some
this
day.
matter regarding the DNA test. That was application not dismissed. The defendant filed a
List on Friday.
Okay.
We'll close it. Next.
My lord, I appear for the petitioner. Lords, there are minor office objection, my lords.
By special order.
Special order.
By special order.
My lords, we are disabled to appear.
ಈಗ ಸರಿ ಇದೆ ಬಿಡಿ. Post the matter before the bench having roster. ಇವಾಗೇನ್ disability ಇಲ್ಲ. Yes. Interim order subsisting will continue to the next date of hearing.
Lords, interim order may kindly be extended.
ಹೇಳಿದ್ನಲ್ಲ sir. Yes. Post the matter before the bench ಅಲ್ಲ list next week ಅಂತ ಮಾಡ್ಬಿಡಿ.
Lords, last date, my lord, kindly refer to my lord 26/6 order, my lord. Where
ಯಾಕೆ orders ಅಲ್ಲಿ ಬಂದಿದೆ?
They have filed a memo. In the memo, they have stated to dismiss my writ petition.
Correct ಆಗಿ ಹೇಳಿದ್ದಾರೆ.
And to meet all those
on
points.
26/6 he has made submitted
Legal
submission
points,
that my lord committee is
nothing
formed. But it is not right submission, my lord. It is
My lord,
false.
now they have filed a memo along with some statement. Let that officer file a verifying update because they have made allegation of fraud, etc., on the petitioner. Let them file a verifying update because I have the document, I can place it before the court. Vaguely, I stated that I have played a fraud and I misrepresented, I made a false statement, all these things they have
List
stated, my
day
lord.
after tomorrow in preliminary hearing.
Please, my lord. Interim to be continued, my lord.
Interim order subsisting will continue to the next date of hearing. Yes.
That engineer requires a verifying update, my lord, because he
We'll
has
see,
made
these are
certain
fertile
allegations.
lands ತಲ್ವಾ ಇದು?
ಹೌದು, ತಾಳಗುಪ್ಪ.
ಯಾವ ಗೊಪ್ಪ?
In Shivamogga,
ಇರ್ಲಿ ಬಿಡಿ,
ತಾಳಗುಪ್ಪ.
ಪರವಾಗಿಲ್ಲ. Yes. No.
We are only for ROP.
Two, list day after tomorrow in preliminary hearing.
Please, my lord.
Petitioner.
Yes, sir.
Yes. Yes, my lord. My senior is on.
Oh, senior is there.
Yes. Appearing on.
Also. Yes.
It would be a pleasure to be present in court, but for some reason I'm not able to come. I apologize.
For some reason, sir is not able to come.
I would request your lordship's kind attention to the order of appointment issued to us.
No, the threshold issue is with regard to maintainability. Other answer ಮಾಡ್ಬಿಡಿ. If it is maintainable, all other things.
Yes.
If it is not maintainable, no other thing.
Yes. As regards maintainability, Mother, my first submission to your lordship is with reference to the judgment of a division bench of this honorable court in Tejaswini Patil's case, which mother I have appended to the. Since it is a long judgment, very lengthy judgment, I have marked the portions which I should bring to your lordship's kind notice. Kindly, mother, go to page number 255, mother. And if I can request you, the previous page also paragraph 11, mother. This is the division bench of judgment of this court.
Yes.
Has been holding the field all these days, all these years. And mother, I can refer to later judgments also, but since it is a division bench of this honorable court, I would be requesting your lordship's kind attention to paragraph 11 at page 254.
Against whom the relief is sought?
Relief is sought against the management which has passed the order. It is maintainable, is my contention. I support my submissions with reference to the division bench judgment in the identical case. As a matter of fact, this Vakaligar Sangha, which is now the respondent, was one of the respondents in the division bench judgment also.
All right.
It was represented by an advocate. I just point out now. Kindly see, to buttress this manner, I will request your lordship's kind attention to page 252 first. I'm only meditating or concentrating on the issue that your lordship wants me to answer, namely the maintainability. 252,000 ibit no para into. Having regard to the
yes, sir.
Having regard to the great public importance involved, these petitions have been referred to division bench by the learned single judge before whom the matter had come up earlier. Thereafter, the petition number so and so.
That is with regard to capitation fee, the division bench holds it is maintainable.
Yes, sir. I just take your lordship to
paragraph. Capitation should be curbed on the private medical colleges also. It was held to be maintainable.
Yes, sir.
But there is much water flown after that where it is said not maintainable.
Your lordship, I refer to various judgments that only require a few minutes of your kind attention.
Yes, sir.
David, paragraph 255 no division bench. This division bench judgment is inconsistent with any other Supreme Court judgment as Hagala. This is holding the field. Page number 255, paragraph 13. We proceed to consider the second and the third contentions together as in opinion they are interconnected. For the reason if the private medical affiliated to any of the universities established under the Karnataka State Universities Act are discharging public duties, that is the epithet, that is it, particularly in relation to admission to medical colleges, and if having regard to the Provisions Act, they are under a statutory obligation to make selections for admission according to their merit. Such an obligation on the part of the respondent itself would constitute the basis of the exercise of jurisdiction under Article 226 of the Constitution and give the relief sought for by the petitioners even on the basis that they are not instrumentality of state and therefore not state as defined in Article 12 of the Constitution. No, mother, kindly go no. I will take your lordship to paragraph 28. Now in paragraph 25 at page 274, ink page number 274.
Yes.
We shall now proceed to consider the status of his affiliated college under the provisions of the so and so act. The expressions college, principal and teacher are defined in so and so. Then our affiliation. Kindly now go to the next page, page number 276. This done some exercise to see that I'm not taking your losses much time. Page number 276. Thus, it may be seen, unless a private college established by a private body secures affiliation under the Provisions of the Universities Act, it would have no authority to admit students for undertaking a course which confers eligibility on them to appear for the examination to be conducted by the university. digressing for a moment, mother, this has been
Yes.
affiliated to the medical council, Mr. Rajiv Gandhi University, which is a nominee party to the writ petition. Now, would your lordship kindly turn to the next page now? Page 277, para 26. In view of the provisions of the Universities Act and the ordinances which are binding on the affiliated colleges, read with the provisions of the Act, the question for our consideration is whether or not they are amenable to jurisdiction of this court under Article 226 of the Constitution of India for the purpose of enforcement of the Provisions Act and the so and so. Kindly now come to para 28 now, same page. If as held above, the private medical college is under a duty to make admission to the college strictly according to merit, having regard to the provisions of the Act, the said duty, which is a public as well as statutory duty, can be enforced against private medical colleges and their managements under Article 226. It's a clear ratio laid down. Now, Mother, para 29. We are also of the view that there is no substance in the contention of the respondent medical colleges that they are private bodies not amenable to jurisdiction of this court. That is the contention now raised by the respondent. If an education institution is established by a private individual or a private body which is not affiliated to the university and is not recognized by the public law or by the state government import education, which entitles the students to appear for a public examination leading to the conferment of a certificate, diploma or degree by the government or the statute, it may be that such a private institution may not purely be a private
What
body.
is the order under challenge?
Pardon me?
What is the order under challenge?
Here, the order presently
Discharge from service.
Yes, what has been
How is the rate maintainable, sir?
Your lordship, you can see
Private management. Do you receive? Does the management receive no aid from the?
Therefore, Mother, I am first now addressing this aspect that it's a private college, still the writ petition is maintainable. Mother, only required.
Where is
No,
15 6 SCC 470?
Pardon me?
2015 6 SCC page 470.
What I will refer to the later judgment. I am referring to the latest judgment of Justice His Lordship Justice Tirit Singh Thakur, as His Lordship then was in Cricket Association case. I am asking a question unto myself. If a writ petition is maintained by Advocates Association,
every discharge of every private institution will be before this court.
No, not before the private institution is not before the court. No, employees of a private institution.
Employees of all those institutions against their discharge will land here.
No, kindly, mother, because this raises an important question.
Sir, no contract of service is what was done by the management with you, with all the employees. ಎಷ್ಟು ತಿಂಗಳ ಕೆಲಸ ಮಾಡಿದ್ರಿ?
ನಾವು ಕೆಲಸ ಎಷ್ಟು ದಿವಸ ಮಾಡಿದ್ವಿ, ಕೆಲಸ ಇವತ್ತಿಗೂ ಮಾಡೋಕೆ ರೆಡಿ ಇದ್ದೀವಿ. ಇಫ್ ದೇ ಟರ್ಮಿನೇಟ್
ಮಾಡಿದ್ರಿ ಅಂತ ಹೇಳಿ
ನಾವು ಮಾಡಿದ್ದ ಅದನ್ನ ಆರ್ಡರ್ಸ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ತೋರಿಸ್ತೀನಿ. Lordship will kindly go to the order of appointment. That is what I wanted to show.
You are discharged in terms of the order of appointment.
Page number ಒಂದು ನಿಮಿಷ ಅದನ್ನೇ ತೋರಿಸ್ತಾ ಇರ್ತಾರೆ ನಮಗೆ. ದಯವಿಟ್ಟು
I am only on how rate is maintained.
Page number 55 ಹೋಗಿ ಸ್ವಾಮಿ. 55.
ಕೆಂಪೇಗೌಡ Institute of Nursing.
Identical orders.
Nursing.
Identical orders.
Nursing institutions.
Not granted any aid, and there is no statutory regulation under which they are claiming any right.
So there is identical 15 4 SCC.
There is
15 6 SC 470.
KK section 2015 4 SCC page 770.
And Ramakrishna Mission 2019.
Ramakrishna Mission is 2019.
All these came before this court to enforce certain, saying that they discharge public functions, so it is maintainable.
Your Lordship says the first contention, the contention that was initially raised by the
division bench, it had to be maintainable because capitation fee was what was concerned there.
That's not a subject matter may be safe. Question is
that
not
is square the facts of that case.
And in the context of an employment, it is not a pure contract of service of in the ordinary course. Therefore, I am trying to bring to the lordship's kind notice the distinction between the present case and any other contract of employment. For this reason, this is a case where the college is affiliated to the Rajiv Gandhi University.
So
Representative
even
that
Education Act won't become applicable? 227 exemption.
pardon me?
Education Act, they cannot go before the
Because this is
EAT.
not 27.
ನಾನು EAT ಮುಂದೆ ಹೋಗಕ್ಕೆ ಸಾಧ್ಯವಿಲ್ಲ.
Subsection 2 of section 27, subsection 27 of section
There,
2
my lords, what happens?
of the Education Act.
ಅಪೀಲ್ ಬರೋದೇ ಇಲ್ಲ. ಅಪೀಲ್ ಬರೋಲ್ಲ ಬಿಕಾಸ್ ಸೆಕ್ಷನ್ ಎಜುಕೇಶನ್ ಆಕ್ಟ್ ಸೆಕ್ಷನ್ 94 ನಲ್ಲಿ
That is, my lords, alteration of answers written at an examination.
Your lordship will kindly see.
No, my lords, this court considered all the provisions of Education Act in management of MS Ramaya Medical College.
ನಾನು ಹೇಳೋದು ಹೇಳ್ತೀನಿ ಆಮೇಲೆ ಅವ್ರು
That is
ಹೇಳಿ.
first judgment I have filed along with my
lordship will not
companions.
deny him any opportunity. Let me complete my submissions. If interpreted another, it will affect my flow of thought also. Section 94 ನಲ್ಲಿ he contended before his lordship Justice Pandit when the matter had come up, referring to division bench judgment in MS Ramaya's case, and I pointed out he must be in a position to say whether these orders which have been passed are orders of dismissal from service or dismissal, removal, or reduction in rank. ಯಾವ್ದಿದು ಅಂತ ಕೇಳಿದ್ರೆ ಅದು ಉತ್ತರ ಹೇಳಲಿಲ್ಲ. Therefore, after having heard of the ಏನಾಯ್ತಿದು ಸಾರಿ ಏನಾಯ್ತಿದು ನಮ್ದ ಹೇಗೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ಮಾಡ್ತಾರೆ. ಇಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್
guaranteed by the Constitution and also the rights of the persons who alleges defamation. But as for the case of the plaintiff, there is an exceptional, sorry.
Yes, sir.
They have, my lord, given, my lord, the entire reason. First of all, my lord, question is, my lord, for my lord's consideration, whether, my lord, writ is maintainable or an appeal is maintainable. Can I persuade your lords to look at, my lord, a few judgments for my lord's consideration? And second thing is, my lord, please look at, my lord, what is the operative portion? Please look at, my lord, the order itself. Please come to, my lord, 746. What is it that has been said? Don't, defamatory content alone, my lord, you don't do it. Are they saying we are going ahead, my lord, with the defamatory content? Please look at, my lord, what is the order? Page, my lord, 746. Defendants, their men, anchors, representatives, so and so, so and so, so and so, from telecasting any defamatory content or information. It is not, don't, publish anything about them. No. Ultimately, my lord, question is, for my lord's consideration is whether, my lord, they can say, I will now publish defamatory content. Answer would be, my lord, no. This is one. Second thing is, please look at, my lord, a few judgments. It is not as if, my lord, ex parte order can't be granted. In fact, Bloomberg has been considered by, my lord, the Bombay High Court and the Delhi High Court, my lord, ex parte orders of URL removal, my lord, have been granted. I'll just point out, my lord, to your lordships. Yes.
No, this is regarding maintainability.
Yeah, maintainability and, my lord, also, my lord, what would be, my lord, what should be done?
One point of information just to assist my learned senior. My lord, the prayer, it says any defamatory content and information.
That's all right.
Yes.
Yes, yes. Sir, read that also. I'm aware of it. Yes.
I read the whole of it. I never suppress anything.
No,
Let me assure my learned friend, my lord, that he need not have any apprehension.
No, I'm only
I
assisting.
wouldn't want
I said I
to take an
That's
order.
all right.
I qualified by saying I assist myself.
Yes.
Lord, please look at this aspect. If they say, I am, my lord, going ahead with the defamatory content, come what may, my lord, that your lordships have, my lord, held, you can't, come out with the defamatory content. Please look at, my lord, the first judgment which your lordships have there. And this has gone up to the Supreme Court. Supreme Court has affirmed this order. SLP was dismissed.
Yes.
Page 1, my lord. Under the guise of exposing corrupt practice, head note itself, my lord, and then, my lord, if your lordships come to, my lord, paragraph 11, 4. Just leave it here. I'll manage. Don't worry. I'll manage. My lord, I have not become that old, my lord. I can tell my learned friend. I'll be able to manage, my lord. Maybe after another 5-6 years, my lord, maybe, my lord, I require
They
his
will never
assistance.
become, sir. No problem. Yes.
Sir would probably enjoy scarcity premium then.
No.
Yes, sir.
Ultimately, my lord, for everything, there's a time and a timeline.
Yes.
Bloomberg, my lord.
Yes,
in
Bloomberg para 10 and 11.
Para 10 and 11. Where their lordships, my lord, hold, there must be, my lord, a reason. In this case, my lord, there is a reason. Third, please see, my lord, what is it that, my lord, we have said in our in compilation. Supreme Court has gone to the extent of saying any defamation, my lord, is worse than death. Please take, my lord, the judgment that I have given to your lordships. I have kept, my lord, several judgments as to, my lord, under what circumstance, my lord, injunction with regard to defamation can be granted. Please come to, my lord, the judgment of the Supreme Court at 108.
108.
108. This is, my lord, 1989, 1 SCC 494.
The page number?
Kiran Bedi.
108.
Kiran Bedi.
Yes, ma'am.
Yes.
In this, please come to, my lord, para 22.
Bhagavad Gita.
Yes, my lord. And, my lord, they refer to all this and then, my lord, grant an order. Then, there are, my lord, any number of, my lord, judgments of, my lord, various courts. Please come to, my lord, page 141. Right to my lord, reputation, my lord, is an irreparable, my lord, facet of article.
Yes. Yes, sir.
My lord, paragraph 1, 21 and 22, life, liberty and property. Then, my lord, they refer to, my lord, reputation is not only the salt of life, they refer to, my lord, the other judgment of the Supreme Court itself, earlier judgment, but also the purest treasure and the most precious perfume of life. It's extremely
The
delicate.
present petitioner is also a defendant there.
Yes, my lord. And that's why I said, he is a defendant. There is, my lord, an order against him. Notwithstanding that, he says, to hell with you. Virtually, my lord, that. And look at, my lord, your lordships have always said, when you come to the court in a article 226 or 227, your hands must not be tainted. Here is a person who, my lord, goes to the extent of saying, my lord, I will arrest that judge. I will, my lord, put him behind bars. I will do what I want. It's, my lord, something,
No, that's
my lord,
what
which
is said.
absolutely
That's what he has
demeaning.
said.
Absolutely demeaning.
Ma'am,
And, my lord, I have the video. My lord, it's not as if, my lord, we have the video, my lord, we have kept a pen drive also for my lords. Your lords can look at it. It's, my lord, that's why I said, it is something, my lord, your lordships have time and again held. A person who comes, my lord, in a writ court, his conduct be tainted, your lordships will say, sorry, I will not entertain you. All that he has to do is, my lord, come to the trial court, file an application. We are ready. We have never, my lord, taken time. We will never take time. We are ready to argue. I've never said no.
All right. Yes,
Even tomorrow morning, my lord, if my lord, my learned friend goes there, I'm sure, my lord, my learned friend will never take time, my lord, he'll be ready to argue. Then, sorry.
Now,
may I? If
one
my
minute.
learned senior is finished. Can
no,
I?
1 minute. I will start.
Yes, ma'am.
Now we'll give you some options. You go before the concerned court and I will direct the concerned court to hear on day-to-day basis and decide the issue. One. Or say, go before the appellate court, or if it is entertainable, I will entertain. Now, is it not a better that if I'm entertaining the petition, I will do
My
it?
lordship may consider that. My lord, in fact, my lordship would entertain the matter because there is no counter file. All that my lordship would potentially do, I'm speculating here. My lord, here would my lordship would set aside the order and then direct the trial court to pass an reasoned order within a specified time frame.
No. Both ways.
My
See,
lord, here
you go and appear in the sense vacating stay applications are pending under 39(4) if somebody has filed. Let the court hear on those applications and pass orders. That also becomes an order.
my lord, here
Others, my lord, have already come. Matter is, my lord, being argued.
my lord, here, my lord, but in the instant case, my lord, this order is unsustainable. To start with, it is unsustainable. My lord, it is
That
not
also
even,
you can urge before the
my lord,
concerned
no,
court.
it is not, my lord, here I am saying that because rule 3 has not been followed, it is devoid of jurisdiction. My lord, imagine a gag order, my lord, why my learned senior is agitating with regard to only my conduct. How about 394 people? All who's of the media. My lord, in fact, my lord, the modus operandi, let my senior say how many injunction orders they have obtained in this manner. Continuously, consistently over the period of years, they file a petition, get an injunction order.
Now the second thing. Now after that, why are you the second thing? Now after that, why are you violating the orders? And how do you expect this court to entertain a petition of a petitioner
Yes, my
who
lord.
has continuously violated orders?
My lord, two
Why,
facets.
why is that?
My lord, two facets here. What my learned senior has alluded to is allegedly
No. Otherwise, you have open channel.
verified, false, frivolous, baseless, and vexatious videos, contents made, aired, shared, uploaded, transmitted, forwarded, detailed in the schedule herein. My lord, how is this even maintainable? How can a person be judge, jury? My lord, he cannot come to this conclusion. There is no determination of this fact, whether it is vexatious or whether it has any factual backtracks to back it. There is no adjudication. He does not even have the benefit of even perusal, because it is humanly impossible to peruse 9,000 videos here, 9,000 links in a period of three hours. Is it judicial adjudication, my lord? Here, judicial adjudication or the judicial application of mind is to the facts. Where are the facts? How can you have humanly
Now,
done it?
if we direct that he should peruse 9,000
Not even
URLs,
representatively.
no, 9,000 URLs and decide the matter, probably may take 2 years.
My lord, here, my lord, that is the onus which the petitioner has put. The petitioner has indexed. I have not indexed. And many of, my lord, majority of them have nothing defamatory at all. Absolutely nothing defamatory. It is a mere reporting of a factum.
Only yours.
My lord.
I'll point out each one of them, my lord. All that the trial court does is says remove the defamatory content. Doesn't say.
No, it says
No,
remove 9,000
1 minute,
links.
1 minute. Defamatory according to whom?
Lord,
No, according to you, everything may be defamatory.
Lordship.
A basis to file a defamatory suit, not contempt. A basis to file a defamatory suit, not contempt. That is the dictum of this court. There cannot be unilateral declaration of what is defamation. Now, my lord, this court, a catena of judgments have held that FIR, charge sheet, sources in investigation are all public documents. I have a right to telecast the same.
No, but twining a story on the public document should not be there.
My lord?
Twining the story on the public document is what they are alleging, defamatory.
Well, that is for them to establish. It cannot be established at an ex parte stage. And my lord, if that is the standard to be held, that I will decide, then where is the question of investigative journalism? My lord?
Who gave you that?
My lord?
Investigative journalism?
Yes, my lord, that has become the bedrock of so many judgments.
Yes.
Many scams.
No, power of fourth estate will not deny. That's a different.
Well, that is what has been done. They have said, whoever, whatsoever, you are not to speak anything about me, my family, my institution, etc. Because what? I'm the king of that particular region. I'm talking about king's privilege. I meant
That's
that.
all right. Yes.
King's privilege.
Yes, sir.
Please come to my lord the first judgment that I have kept for my lord's consideration.
That is A.K. Subbaiah.
Yes.
Yes, sir.
Please come to my lord paragraph 11. And please come to my lord the conduct of the parties. Please come to page 208.
Yes, sir.
Paragraph 5 of this.
208 of judgment.
208, page 208. Paragraph
5. Sorry, 1 minute more. Bottom al Bharat Nodi.
Yes, sir.
There is no dispute that the appellant knowingly, deliberately entered into a guarantee agreement, so on, so on, so on, so. Then, my lord, please come to the next page.
Page, sir.
210.
No, sir.
The appeal arises out of about 1, 2, 3, 4, 5, 6 lines from the top. Arises out of a writ petition and well settled. A petitioner who invokes the jurisdiction of Article 226 of the Constitution, it is open to the High Court to consider whether, in the exercise of undoubted discretionary jurisdiction, it should decline relief to the petitioner if the grant of relief would defeat the interest of justice. Court always has the power to refuse relief when the petitioner seeks to invoke the writ jurisdiction in order to secure dishonest advantage, defeat the interest of justice. Court always has the power to refuse relief when the petitioner seeks to invoke the writ jurisdiction in order to secure dishonest advantage, was fully justified in refusing relief on that ground alone, and the appeal must fail. This is one, but more important is, please come to my lord, the next judgment, 1991. Half an hour back, my lord, I am told today. My lord, again, my lord, there is half an hour back, my lord, I am told today. My lord, again, my lord, there is and absolutely, my lord, defamatory.
So you haven't given me a copy of that. What you have just circulated?
Same judgment that I have given, no, that long sheet. Your junior has it.
Long sheet.
Yes. First, we'll pass orders on maintainability and whether the orders are ಅಷ್ಟೇ sir.
ಅಷ್ಟೇ ಎಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ ನಾನು.
Will
Can I make one submission?
Yes, sir.
When this court is, my lord, exercising powers under 226 or 227.
227 ಮಾತ್ರ,
Yes,
no 226.
No, just quoting a general principle. My lord, the court can modify the relief, inherently modify the relief in the larger good. I urge my lordship to consider the effect of a gag order here when an SIT has been formed asking all those people who are having grievances, including missing children, missing women, to please contact them. And a helpline has been formed. The dissemination of the information is essentially through media. This is what reference to a large number of media outlets and information which is being available in the public domain regarding same, which result.
And then, my lord, the judgment is given. Bonnard, my lord, is considered at paragraph 34. Bloomberg, my lord, is considered, my lord, earlier.
No, there.
It was a senior advocate.
No. There, none of those so-called owners of the URLs had contested the matter. So 7 to 13 have not been contesting the matter. Looking at their contents, they may be removed from
Order
the
is an
platform.
ex parte order.
It started with ex parte injunction.
That's right. All that I want to show to your lordship, my lord, is that, my lord, an ex parte order, my lord, my learned friend started saying, oh, ex parte order can't be granted at all. My lord, with the greatest respect, that's not so.
We'll see. We'll answer it. Yes.
I may be permitted to submit a written submission.
After all this written submission.
A short written submission. I would like to differentiate a couple of things.
I may be permitted to file.
Less than 10 pages, my lord, if I may.
Tomorrow.
Obliged, my lord.
File it tomorrow. Tomorrow.
Obliged, my lord.
File it tomorrow.
Obliged.
Because we can't keep it for long.
Yes.
Statement of objections, my lord, sir.
First, maintainability, we'll see. Yes, we'll try old wine in a new bottle coming here.
No, my lord, here the order will have to stand on.
Old wine in a new bottle coming here.
No, my lord, here the order will have to stand on its own legs.
MS Gill yake. Yes.
My lord, it states that an affidavit, I mean, an executive order.
Para 8, sir. Para 8, 78 Supreme Court 851.
My lord, in fact, this is a right.
That's what you are saying.
Yes, my lord. In fact, well, it says, my lord, it cannot be supplemented as supplement.
It's all right. I'm aware of it.
Obliged.
Yes. That's why I told you the paragraph also. What else? Yes.
It's the pen drive, what, my lords, we have. Manuscript, what we have.
Pen drive yake, sir.
Some ನೋಡ್ಲಿಕ್ಕೆ ಏನ್ ಬೈತಾ ಇದಾರೆ ಅವರು ಅಂತ ಜಡ್ಜಸ್ಸಿಗೂ ಕೂಡ.
Judges ಮಾತ್ರ ಅಲ್ಲ. The family, the person.
That we'll see.
Absolutely, my lord, stinking language, and it's worse than, my lord, anything. That's all that I can say. Because
I will.
You want the pen drive?
No. I will answer this. I will make a short note of it.
Please do it. Yes.
Obliged. Yes, ma'am. Obliged.
That was considered, and that is why, my lords, his 2 channels were blocked.
No, well, we're on a different point. We'll do it. Yes.
Obliged.
If you were on this side saying block the channels, then you would have considered all that. Yes. ಎಷ್ಟೊಂದು ಜನ ಇದ್ದಾರೆ? ಸರಿ ಇದೆಯಾ? Yes. We'll just adjourn. All matters that have
serial number 24 your 1991 matter. ಅದಕ್ಕೆ Thursday date fix.
CRP Thursday ಬರುತ್ತೆ.
serial number 25 man.
ಎಲ್ಲ ಡಿಫರೆಂಟ್ ಆ ದಿನ ಯಾವತ್ತಿದೆ ಅದು ಬರುತ್ತೆ. Interim orders idre continue
My
aಗುತ್ತೆ.
lord, serial number 48, my lord, kind of day after tomorrow, my lord, serial number 48.
We'll fix it, yes.
Your lordship kindly.
That further hearing matter on Friday or some other day. Probably time irutte Friday, but this is what will happen. Yes. Wait, sir. We'll post it, yes. ಅದು Tuesday ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡ್ತೀನಿ. I'll look into the list and then do it, yes. ಯಾಕೆ? ಕೊಡಿ ಅದ್ಯಾ ನಾಳೆಗೆ ಹಾಕಿ, ನಾಳೆಗಲ್ಲ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Serial number 66, please, your lordship. Yeah, tomorrow, please, your lordship.
No, sir. Why?
That is urgent, please, your
Urgent, why? GMCPC. Sunil Shastri, respondent.
In across, please, 66.
66, sir. Aitlur authority.
No, wrong. They misunderstood GBA, Greater Bangalore Authority, to this GBA, which is under the CUDA Act, which has been done, my lord. They're totally different authorities.
The petitioner yaar
My learned friend is appearing, my lord.
Yaar, Niva.
64, I am appearing.
Yes, sir. We'll post it on Tuesday, sir.
My lord, can you and will not dispose my learned friend, my lord. Your lordship, we have issued notice surveying the
ಏನ್ ಕೊಟ್ರದ
preliminary notification they have challenged.
stay ಮಾಡಿಲ್ಲ.
Stay ಮಾಡಿದೆ
No,
stay.
it has not been stated.
Not to disposes, that's all I've granted.
Stay on notice also, my lord.
On what notice?
For survey and various other aspects.
No,
Your lordship,
not to
annexure-
disposes ಅಷ್ಟೇ ಇರೋದು.
Your lordship, may permit me to read, my lord. Submit the entire, no, I'm sorry. Action shall not be taken qua annexure B1 to B10 is notices for the purpose of survey, my lord. That we will not dispose them.
We'll modify that order then.
Tuesday, my lord, I make my submission. Till then, let the order continue, my lord.
Allah, if we have no objection to modify that thing, we will modify. They will not disposes you, definitely. They cannot disposes also. The idal barkodi the learned advocate general submits that annexures B1 to B10 are notices regarding survey. That cannot be stopped. Monday and Friday will have
50 ಮೇಲೆ next Wednesday.
next week ಹಾಕ್ಲಾ?
Next Wednesday. ಅಲ್ಲ ನಾನು ರೆಡಿ ಇದ್ದೇನೆ, ಈಗ ಕೇಳಿದ್ರೆ ರೆಡಿ ಇದ್ದೇನೆ.
ಅದಕ್ಕೆ ಒಂದು ನಿಮಿಷ ತಾಳಿ ಕರಿತೀನಿ. Yes. ಎಲ್ಲ ಅಷ್ಟೇ. Wherever interim orders are not there, it's a blanket order, madam. Wherever interim orders are not there, they will come on 6th. Where interim orders are there, they'll come after 2 weeks.
My lord, serial number 58.
GMCPC matra, land acquisition I'll fix.
My lord, serial number 58. My
Land
lord,
acquisition Tuesday.
Serial number 58, I have filed an impleading. I am the tenant. Due to injunction, I could not run my business, my lord. It is a T stop.
It will come. Vacating
Matter
stay.
was heard and interim order was granted, your lordships.
Vacating stay. Vacating
Yes,
stay
Your
ಹಾಕಿದ್ರೆ ಒಂದಿನ ಬರುತ್ತೆ.
My lord, I have filed a modifying application for modification.
There is no locus standi for the impleading applicant, your
All that.
lordships.
Yes.
My lord, 67, my lord. My lord, serial number
All
80.
matters. Now stop mentioning single cases. I have told you all matters will be listed in this pattern. If you still insist, then I will take all the matters after 8 weeks. I will fix up dates. Just wait. Yes. There should be some humanly possible to take all the matters. I'll take it. Yes. That's all. A Twitter matter thodi.
Bill number 90, further hearing.
Review it. Review then. I'll come back, sir. Yes.
Yes.
Thank you very much. Thank you very much. ಇನ್ನೊಂದು ಮಾಡ್ಬೇಡಿ ನಾನು. Biggest. ನಾನು ಬರ್ತೀನಿ.
ಎಲ್ಲ ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತಾರೆ ಪ್ಲೀಸ್. ಹಾ
ನೀವೇ ಮಾಡ್ತೀರಾ ಇದಕ್ಕೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಬೇಕಾ? Not settled is it? They're not settled is it? ಅದೇನೋ ಸೆಟಲ್ ಮಾಡ್ಕೊಂತ
They want my, their way or the highway, that's all, my lord.
Their way or the highway? Oh,
In
yes.
fact, as the state, my lord, in fact, the offer, in fact, my lord, earlier the primary and second.
No, this we can't stay for long. We will have to, Nade we'll have to close
In
it.
fact, my lord, I also convinced my client insofar as the other tender. And in fact, my lord, we said no objection to proceed with the tender.
No objection, we complained a lot, it's not a house objection. The whole case.
No. Tomorrow we'll dispose it. Yes, sir. Now only Twitter, nothing else. X.
Yes, X.
And Sondi sir is there? Yes. I think he was
is
there.
on,
Yes.
He is there, my lord.
Yes. No problem.
Our history there.
I'm online, my lords.
He is here.
Yes, my lord.
Great.
Yes. Yes, sir.
Lord, now I already made the point before your lordships, my lord, that insofar as section 79 is concerned, there are only three ways in which the order can be passed under 79, namely.
Even three-way or no way.
Namely.
Even three-way or no way anta ide. Yes. Yes.
Now three-way or no way. Was not accepted by the Supreme Court. And in spite of it, Supreme Court said, no, it is only an exemption provision. So therefore, my lord, it is not.
So that is why your suggestion is a provision which on the face of it depicts to be an exemption provision cannot become an empowering provision.
That's yes, exactly. And in fact, Moorchat.com, my lord, in their written submissions sought to contend that it is a empowering provision. Supreme Court said, no, it's only an exemption provision. That I showed your lordship that, my lord, that's what I want to point out to your lordship today. My lord, your lordship kindly take, my lord, the written submission. I'm sure, my lord, your lordships have already seen it, so it's going to be.
Yes.
My lord, your lordship may kindly turn to page 20, my lord, of the written submissions.
Yes, sir.
My lord, your lordships have seen that argument that Shreya Singhal is per incurium. Anyway, my lord, that argument is just not, I'm not going to trouble your lordships with that. Now, my lord, kindly see. Your lordships, I'm omitting, my lord, para 88 also because they are saying we are planning to ask for review of, to reconsider Shreya Singhal. Well, my lord, they are entitled to let them do it. My lord, we are not.
No, I cannot consider.
Exactly.
I know Manipur and Sikkim are beautiful places.
No. There's no difficulty about it. Under Rule 3, the central government shall designate by notification the official an officer of the central government, not below the rank of a joint secretary, as the designated officer for the purpose of issuing direction for blocking of access for public any information referable to section 69A of the Act. Under Rule 4, every organ, my lord, in fact, I'm not going to read this because your lordship will recall, my lord, I had given your lordship a chart.
Correct.
That, my lord, gives your lordships in a flow chart form whatever is contained in 69A.
That's in a nutshell.
That's in a nutshell, my lord. So I'm not going to detain your lordships for it. Now, my lord, please be kind enough to turn to paragraph number 117 at page 121. At page 21. Section 79 belongs to chapter 12 of the Act, in which intermediaries are exempt from liability if they fulfill the conditions of the section. It must be appreciated that section 79 is an exemption provision. Being an exemption provision, it is closely related to the provisions which provide for offences including 69A. We have seen how 69A blocking can take place only by a reasoned order after complying with several procedural safeguards, including a hearing to the originator and intermediary. We have also seen how there are only two ways in which a blocking order can be passed, one by designated officer after complying with 2009 rules, and the other by the designated officer when he has to follow an order passed by a competent court. Intermediary applying its own mind to whether information should or should not be blocked is noticeably absent in 69A, read with 2009 rules. 7th of Article 19.2. Our grievance, my lord.
Enumeration in Article 19.
Exactly. An enumeration in Article. When I've spent discipline.
Enumeration in Article 19.
Exactly. An enumeration in Article. When I've spent discipline, I meant enumeration in Article 19. 79 is valid, subject to 79(3)(b) being read down to mean that an intermediary, upon receiving actual knowledge from a court order or on being notified by the appropriate government or agencies and unlawful acts relatable to Article 19.2 are going to be committed, then fails to expeditiously remove or disable access to such material. Similarly, the information technology intermediary guidelines rules 2001 are valid, subject to Rule 3, sub-rule 4 being read down in the same manner as indicated in the judgment. Now, my lord, what they are doing is, this was in respect to 2011 rules. Now, my lord, 2011 rules has now been replaced by the 2021 rules. Now, my lord, if the 2011 rules remained as
Oh,
they
the
are.
stark difference is introduction of 31D
Yes,
in the 2021 rules.
31D also was there in 2011 rules.
No, there is
but in
some-
a different
some-
avatar.
It's
It's a different avatar.
It's tweaked.
My lord, now what they have done, my lord, is if 31D of the 2011 rules remained as it is, then it would have been read down in the manner prescribed in Shreya Singhal. What they did, my lord, was by a side wind, they have introduced rule 31D now by the 2021 rules. Doing one is to dismiss it.
One of which is reading down.
The extreme measures
To
is
uphold, to hold it unconstitutional, to
But-
save it from unconstitutionality, read it down.
read it down. Now what they have done, my lord, is instead of saving rule 31D as it was in 2011, reading down. Now, my lord, kindly see what has been done. Please go back to page 128, my lord, of the compilations. Your lordship may just see how my lord, the Supreme Court,
128, 90 pages.
one,
are
no,
still-
128 of that compilation.
File. Oh, so yes. The rules compilation.
Yes, statute and rules. But one of the reasons why the Supreme Court will be reading down is to say, how can an intermediary decide itself whether something is unlawful? If you say, because that was old rule 3(4). They said, you decide yourself. Now, my lord, 3(1)D is introduced and we are told, you decide yourself whether you want to comply with it or not. Exactly what the Supreme Court said you cannot do, they say you can do under 3(1)D. And that is the way in which, my lord, they say it's all optional side. If same argument is now being advanced, you decide whether you want to comply with the empowering order that we are issuing under rule 3(1)D or not. Exactly what the Supreme Court said you cannot do. Now they're saying well, you can do under 3(1)D. My lord, that argument is not open to them. That's why, my lord, I'm not going to read, my lord, 2021, you also have read it number of times. But what has been specifically said is not permissible is now sought to be done under the 2021 rules. This is the submission. Now, my lord, your lordships may kindly go over to the written submissions, my lord. If your lordships will kindly see, my lord, now your lordship may kindly come to para 91, my lord, of the written submissions. The above paragraphs read together make clear that the loss of safe harbor is dependent upon preceding order, namely, my lord, 1, 2, and 3 that I have already read. The words unlawful act in 79(3)(b) must be read as referring only to those three circumstances. Without prejudice, 79(3)(b) is akin to an execution proceeding. It is a mere mechanism to enforce a court order or an order passed in accordance with 69A safeguards. It is for this reason that Honorable Supreme Court in an isolated paragraph of Shreya Singhal para 124(3) to contend that they have the power to declare information to be unlawful for the purpose of stripping away intermediary safe harbor. Respondent's contention is belied by reading Shreya Singhal as a whole, as well as decision of the Honorable Supreme Court in, not in Supreme Court, it should be
Jagadamba Oil.
Bombay High Court. It should be Bombay High Court.
Yaudu.
Kunal Kamra, the Honorable Supreme
Kunal
Court.
Kamra is Bombay High Court. You are at para 94. Alla, you are at para 94, right?
93, my lord.
93.
Last line. Al tabbar, tappagide, I apologize, my lord.
Supreme Court, adu Bombay High Court.
Bombay High Court. Tappagide, I'm sorry. Now, my lord, kindly see how we would read 124(3) for your lordship's kind consideration. It is submitted that respondent's contention that para 124.3 supports them is meritless because it is only when para 124(3) is read along with all other paragraphs above that it becomes clear what Shreya Singhal meant. The meaning of 124(3) can only be ascertained by reading para 114 to 143 can only be ascertained by reading para 114 to 123 of Shreya Singhal. Read as a whole, Shreya Singhal, 14 to 123 of Shreya Singhal. Read as a whole, Shreya Singhal reads down 79(3)(b) and holds that it is not a standalone empowering provision, but is dependent on the preceding order, such as court order or an order on 69(a). An intermediary has an option and may choose not to comply with a note. An intermediary has an option and may choose not to comply with a notice under 79(3)(b). This argument is contrary to Shreya Singhal because it compels an intermediary to apply its own mind. Respondents argue in para 191 of the written submissions that the said provision contained in 79(3) also does not oblige or mandate that intermediary should remove the content in question. The intermediary which earns out of this business is required to take a business decision whether to accede to the request of the litigant whose right is taken away under section 79(1), or depending upon the facts of the case to take the stand that the material posted uploaded is not prescribed and it would defend the legal proceedings if initiated. However, this directly contradicts Shreya Singhal. But how may not kindly see this paragraph 121? These highlighted portions. The intermediary applying its own mind to whether information should or should not be blocked is noticeably absent in 69(a). If it is absent in 69(a), it cannot be present in 79.
They go hand in hand.
They go hand. That's it. And one of the reasons why they upheld 69(a), why that this was because they said is good, is because they said the requirement of applying your own mind is not there, and therefore they even 3 money. Paragraph 126. Now, my lord, I mentioned to your lordships about the contention of mouthshut.com.
Yes.
Your lordships may kindly see para 133. Respondents impute mouthshut.com India Private Limited submission to Shreya Singhal to all intermediaries including X. That is incorrect, inter alia, because X was not a party to Shreya Singhal. In any event, the Honorable Supreme Court rejected mouthshut submission that are inconsistent with X's argument. In Shreya Singhal, mouthshut position was that the statutory machinery for disabling access to content on a website is through two possible channels apart from a court order. The statutory channels are 79(3)(b) and 69(a). In fact, mouthshut.com seemed to have suggested that 79(3)(b) is a empowering provision. This argument was rejected by the Honorable Supreme Court. In para 121 of Shreya Singhal, we have also seen how there are only two ways in which a blocking order can be passed. One by designated officer under 69(a) after complying with the blocking rules, and the other by designated officer when he has to follow an order passed by a competent court. This is the point, my lord. The mouthshut.com said there is a third way, namely 79(3).
That is not.
That is not
accepted.
accepted. Therefore, this was all there, my lord, before the Honorable Supreme Court. And now,
So,
how?
according to Shreya Singhal, covers the entire